I hear ya.
Now Michelle's here.
I am. I had to throw a load of laundry in.
Gotcha.
How you doing, Michelle?
I'm crazy. How are you?
Yeah, crazy, busy. It's always something new.
Yeah. Is Luke joining us?
I believe he is. I talked to him a little while ago.
There he is.
Boom.
There he
Look
is.
at that.
And Ron is missing. Oh, what about Mark Pellegrino, Donna?
Donna's in the middle of traveling. She'll be with us in 5 to 7 minutes, possibly.
All right, hang on. Let
Hi,
me
Kurt.
pull-
My name's Luke Angstad.
What was that?
I said my name's Luke Angstad. Nice to meet you.
Nice to meet you, Luke.
The women as well. Nice to meet you, Donna. Nice to meet you, Michelle.
Yes,
Wait,
you
are they
too.
muted right now, or okay?
Oh, we
Yeah,
got you.
she's coming. Donna's coming. She's finishing up something.
Okay. Bob, good to see you.
Good to see you. Always a pleasure. So, it's been interesting.
To say the least.
Mhm.
Yeah.
So, if this is pretty much everybody, we've kind of got our introductions here. If you guys like to share with us, more probably me. I don't know if Donna and these guys probably already know you guys, but I don't. So I'd like to hear from you guys. Oh, there's Ron. Who you guys are? What you got going on? And
Sure, I could be really brief, and then I know Bob. I'll give Bob the bigger stage. But my name's Luke Angstad. I found out about the Constitutional Law Group through Nico Rocco. Nico and I were involved with a group called the Unmasked back in 2020. That's when all the bullshit first went down, and Nico and I stayed in touch. And I eventually moved down here so I was living in Pennsylvania at the time. He was in New Jersey. We held an event at Independence Hall, December 2020. I moved down here to Sarasota. Once I was down here in Sarasota, I got involved with various freedom fighter patriot groups. Through that, I met Bob, and after getting to know Bob, and I quickly realized that Bob is a constitutional law expert as well, doing a lot of the same things that Rick Martin and Nico Rocco and the Constitutional Law Group were involved with. And I think I mentioned this to Bob before about the Constitutional Law Group, but I mean, we had so many things going on, it got lost in the shuffle, and
Yeah.
it came up in conversation a couple of days ago, and I said, Bob, I think it'd be a great idea if we could reach out to the Constitutional Law Group and just to discuss the case. I mean, there's always like one thing, one person who you can't see something, and then just someone else comes along and says, hey, it's this right here. And so, I mean, it's always better to have the meeting of the minds, and hence that's where we're at here today.
yeah,
I
the Bible
agree.
talks about a multitude of counsel.
Yes.
Mhm.
Listen, and hopefully you can hear. Even if you don't hear it right now, you might hear it down the road. It might come back and reveal itself. That's
Mhm.
really how I got to this situation. My name's Bob Kraft, Robert Kraft. I guess I'm a constitutional law expert. I follow a philosophical journey. In 2020, I actually was a firefighter paramedic for 20 years, and I went head to head with Charlotte County Fire and EMS. There was something really wrong. There were things that were happening over a few years.
Just this. Because if Paul's not downstairs, and Paul's outside. Go upstairs.
Ron,
Ron, you accidentally unmuted.
we can all hear you.
So I went head to head for a couple of years. I have been reporting things that were happening, the poor behavior, their actions. In 2020, it escalated. Again, I continued the same process, and the level of retaliation was incredible. So instead of getting angry, I decided to start to learn the philosophical processes, and I didn't know what I was getting into when I started, but basically I just started reading books. Since then, I've read over 270, most of them going back, most of them are 500 years old or more, going back, Plato, Aristotle, common law, all the way up through Plutarch, Plotinus. And I was really trying to understand the education that our forefathers had when they actually wrote the Constitution, to try and understand what is really going on around here.
Mhm.
I have been practicing pro se law for about 20 years also. I had some divorces and I realized attorneys are failures. Sorry if anybody's an attorney, but I haven't found any good ones ever. And so I started to actually utilize the judicial process that I knew through the law in my interactions with my county. And what I found was the Socratic dialectic methods that I was using actually got them to reveal massive amounts of data, massive amounts of information. Through that process, I started dabbling in lawsuits. I started filing lawsuits for like bonds and some other things, trying to figure out how the system works and testing the system. Not my most recent lawsuit, but my biggest profile lawsuit is I brought a lawsuit against Sarasota County School Board for the sexually explicit books and all the other stuff. And I brought it at law, which is at common law.
Mm-hmm.
So at this point, this is my understanding of where we are. Right now, there are two separate systems. There is an equity system and there is a law system. The law system operates on action at law. It is actually common law.
Mm-hmm.
The action at law system uses individual rights as the driving mechanism to initiate cases. And that system only operates in a determination of fact.
Hmm.
The equity system, which is separate, operates on a presumptive premise of opinion or advisory opinion, and it uses the word the court. So when you're in actions at law, you need to use the word the people, because you're asking the people, because you're asking a jury. One of the biggest things I found, I went up to Tallahassee and I spent a week up there. I was able to recover 23 common law books, including the Florida Rules of Common Law Procedure and the Clerk of Court Manual for common law for the state of Florida from 1950. So
wow.
This case that I brought forward to the school board is the first case that actually had rules of procedure and actually had the Clerk of Court rules that are referenced in the they're actually referenced in the procedure. So what's happened at this point is that I was dismissed. The reason I was dismissed is because you can't show cause. You're not getting dismissed because you can't show cause. You're getting dismissed because they, at least in Florida, somewhere around 1967, I can tell you what happened in 67, both in Florida and the United States. In 1967, the Florida Supreme Court passed a order that abolished the division of the Clerk of Court docket between law and equity.
Mm-hmm.
Okay. But the Florida statutes never abolished that separation. Under Florida Statute 34, it still says actions at law. And under Florida Statute 26, it still says actions at law and actions at equity. So that division was only by the Supreme Court and only to merge the rules of civil procedure together. Now, what's interesting about the rules of civil procedure is that they come from the Code of Civil Procedure of, I believe, 1909, which
1881.
is well, in 1909, there's a code out of India. They are actually Indian rule court rules that were merged into U.S. rules. So there, it may have been earlier than that, but
It was 1881. It's from the statutory law of England, extending the High Court of Admiralty of the Court of England.
Okay, that is our equity system. The Seventh
our law.
Amendment of the that's right. Yes, it's equity. It's commerce. It's money. It's all about money and power. So the Seventh Amendment still specifically says the rules of common law rules. Okay. So
It also says it has to be heard in a common law court, right? By a jury. And
Yes.
then it can't be heard in any courts of the United States except for pursuant to the rules of the common law. So where's
Correct.
our common law courts and where are the people and the common law grand jury, the common law petite jury?
Well, it's our county courts.
There aren't any.
Yeah, there are. Yes, there are. They're still there. The county court that is actually established, if you go back to when your county was carved out, they didn't establish a county court because once the county was already carved, the county court is by metes and bounds on the land. It is the people's court. So it's been now they've called it small claims court. They called it traffic court. What they didn't tell us is it actually was an equity court. It is actually the people's court. What happens is, so these courts, as we move in and out of them, we establish different jurisdictions.
Mhm.
So we have to make we have to declare the jurisdictions and we have to make the claim. One of the biggest problems that we've been having is we never had a set of rules. We never had rules of procedure. So how do you go into a court where you don't have rules of procedure? And they were sitting on the shelf in Tallahassee at the Supreme Court of Florida, and they've been sitting there since 1953. So that's one of the problems, but it is the county court. A lot of the books that I've recovered literally reference it's the county courts. It's our county courts and our counties is the metes and bounds court. We just have to bring the action in at law, which now what's happening is they're saying, no, they're avoiding it at all costs because of how dangerous it is. So
Dangerous.
we found the court.
How lawful. Danger to who?
Lawful is dangerous for them.
Yes, it is.
So, because what I realized as in research, as a jury actually makes a deliberation, the jury creates a general law for that actual county. That law is fact. So what we didn't realize about the actions at law is once we cite the people and we actually get a deliberation, it becomes general law, even if it's just a declaratory judgment. So if you go into a county court and you want, like, one of the cases that I messed around with was a simple case, right? Because I had the school board case, and then there's another case for the bonds. We were messing around. Well, I had a guy who had an issue, a friend of mine, and his issue was his road. He doesn't pay taxes. He doesn't pay MSBUs. And the county refused to actually designate it a private road. Instead, they called it a public access right-of-way. So I'm like, you know what? This is easy. This is a super simple, like super easy. We'll bring in it at common law. We'll put it in action at law, and we'll ask 3 questions that are merely declaratory judgments of fact. It got thrown out. We can't even get an actual road defined as public or private. How are we going to try and fight anything else if you just can't get the road defined? And they know it. They know it. In fact, I have another friend in DeSoto County I met with last week. She has 3 attorneys that acted inappropriately, violated their oaths, whatever. They're all it doesn't matter. They're all violent. They're all doing it. She actually filed a complaint with the bar. The bar association sent her back a letter, and that letter said that this must be brought for a judgment at law, and then they will go ahead and move forward. So she calls me up and she's like, "What is a judgment at law?" I said, "That's an action at law. That is a declaratory judgment of fact. That is common law. That's our system." So she's working on and getting that done too. But the reality is, and I'm teaching a class right now on like human behavior, interactive cognitive warfare, like interacting with these people and drawing them out and getting them to give you information, or getting them to lose their ever loving mind is actually what they're really good at. So where I believe we are right now, and I'm gonna summarize right here, is where we are, where I think we are. If we don't have the court to actually exercise our rights, and we don't have the court to actually protect ourselves, then we have no Bill of Rights. We have no rights. We have nothing because there's no way to protect yourself unless you have the actual court that you can do it in. We have nothing until we get a court, one court in the country up and running at Action at Law. I rest.
Let me ask you something. Do you think the judicial branch is the only branch of government that we take a cause of action to?
No, I don't think that the judicial branch is the only branch, but if we can get a court, we can then execute facts and we can put like permanent restraining orders on these people where they are never allowed to hold public trust positions. We can access our grand juries. We can, I mean, this literally, but if we can't even get a simple road done, and the problem is, I mean, you can't get a road. You can't get a road to find public or
Something
private.
so stupid simple.
But it was perfect because what happened in the courtroom was they proved, and the judge that cited the actual Supreme Court abolition of Action at Law and Equity in Charlotte is the exact same citing that the judge in Sarasota used to say that law and equity were abolished. So we have narrowed it down to this one actual Supreme Court order that is not even legislated. So we're not even looking for a law. We're looking for the courts. That's where they're holding to.
May I? Can you have you tried claim in the court of claim as opposed to the court of law?
Where would the court of claim be?
In the same court, but the judge has to change hats from being a judge, which gives an opinion, to a magistrate that can only act on the order.
Right. The problem with magistrates is once you get a magistrate, you actually are out of common law.
No,
So-
actually, you're in common law. That's what I
We bring the
described.
jurisdiction.
Right. You
Then your
bring your
paperwork.
claim in, based on your evidence, and you are asking for settlement based on what your claim is outlining.
Right.
And,
But what are you trying to settle?
well, for instance, you wanted to create a road and you put a claim in that, well, first you create your evidence, which we want to create a road, and the judge says you can't do that, and he proposed an obscured law off the books for whatever reason. He just now harmed you. He
Right.
can't harm and he can't trespass. He's done both. And now you give notice that he trespassed against you. And then you give him so many days to correct the record. And if he doesn't, then you give a second notice and outline the cure, which is, I'm now going to charge you $1,000 for that trespass, and $1 a minute for every minute after this you get this notice to cure. And if he doesn't do that, then you're now been not only trespassed upon, but now you're harmed. Now you escalate this into the next notice. And then on the third notice, you now are ready to file your claim, and you have your chain of title of evidence ready to go into the court of claim, and the magistrate can only rule on what's there. And they're not going to want to settle in court. They're probably going to want to go into arbitration. No problem. What's the end result? I get my road. I get the significance of the road. And oh, by the way, I'll take half the money. And you walk out the door.
Right. But as soon as you start entering the realm of money, you are entering equity.
Mhm.
You're moving into commerce. And the whole point is to get away from commerce and stay out of any type of money.
Make it
Or any
gold and
type-
silver. Make it gold and silver.
Well, that's still
Yeah.
equitable.
Well, that's outlined in the Constitution.
Well, I agree with that.
Right.
But equity and admiralty maritime are also listed in the Constitution.
Right. And they
Right.
cannot avoid that. And one of the things you could say is you violated your oath of office, you committed treason, and oh, by the way, I want your bond for acting in a treasonous manner. That's part of my settlement of my claim.
So then where do you take them to enforce that?
The magistrate, he has to enforce the
and-
law. The law is,
Uh,
you're the court in a claim of court, and you're enforcing your claim, And part of that claim is you collect the bond. And
Right.
bailiff has to collect the bond.
We don't even have county commissioners that are bonded in Charlotte County.
Then they're impersonating a public official and you need to go and make a claim against that.
How do you enforce it?
Just outlined it just the way I just outlined.
But that's what I'm saying. Any case that you bring in, they're just dismissing.
They can't dismiss.
They are
do.
Under a
absolutely
magistrate,
dismissing.
under a claim of court, they cannot dismiss.
They are dismissing everything.
Yeah.
It doesn't
this
matter
is-
which claim.
This is why I posed the question: is the judicial branch the only place that we can go for remedy
Well,
and relief?
We can create the lawful people's court and form a common law grand jury. And to do that, to get around the Buck Act, you need to create your bilateral social compact and agreement of the parties so that you're all designated as people and not persons. And get out of and make your claim accordingly. And then once you're one of the people, they cannot make claim against you as the straw man, which is how they're going to make their claim against you under the Buck Act.
Which they can't do anyway, because an act is not law, and I
That's
am
right.
man, creation of God. Can you rebut that? No, and I don't need to change my status.
Correct.
Because how would I change my status
Not,
from I am
not
man,
changing your status.
creation of God?
Kurt, you're not changing your status.
Well, yes, I agree. I agree that you don't have to change your status. So when you divide this equity law thing up, I'm actually finishing a book right now by Scalia, and it's called The Essentials of Scalia. In it, Scalia actually outlines it is the 14th Amendment that got them to be able to make us legal entities. So the way that I've kind of figured out how to play this is when you're petitioning at law, you are pushing for law. When you are in equity, you are running defense the whole time. So you have to be the stupid. So we're sheep, right? We're sheep that are to be sheared. They don't want to kill us. They just want us to be productive. So they want to harvest our wool. They want to take us to the board and they want to shear us. They want to take it. Okay. So we have to be as dumb as sheep that needs a shepherd. So today I just wrote a notice of special appearance in any equity court that literally says, I'm a beneficiary. I'm assuming I'm being summoned because I'm a beneficiary and I don't know who the trustee is. I don't know who the account is. And it has a list of things that I don't know anything. I'm sorry that I'm stupid. And I don't know why I'm here because I have presented myself in special appearance as a American person of the people, of we the people. And I have a whole thing that lists out, basically a preamble of, and this is who I'm presenting myself as in special appearance. But I don't have I'm not an administrator. I'm not a trustee. I'm not a grantor. I'm a beneficiary. My understanding was I'm not supposed to know anything about these accounts. I'm not allowed. I have no power over them. I have nothing. I'm stupid. And I don't know what I'm doing here. I'm retarded. If anyone's offended, I'm sorry. I'm making the point of become the stupidest smart person in the room and get them to start answering questions. So that's running defense in equity. And then, but if we don't get an action at law court anywhere, we're in trouble. We're already in trouble.
No, we go to war. That's what we do.
Well,
So again, this goes back to why I asked the question. Is there any other part of the branch of government besides the judicial branch that we go for remedy and relief?
no,
So-
I don't think so.
The answer is found in the First Amendment, Article 1 of the Bill of Rights, the right to
Right.
petition. Okay. This is parliamentary practice. This is a right. This is part of our power, exercising the power to alter, reform, or abolish anything at any time we deem it necessary. But Article 4, Section 4 specifically states to protect us from invasion, and on application of the legislature, or the executive if the legislature cannot be convened. And then we have Luther versus Borden. This is a political argument, not a judicial one. So technically speaking, the judicial branch doesn't have jurisdiction at all in any of the matters that we're talking about, because this is a political argument, not a judicial one. So what we're really supposed to be doing is going through the legislature for the redress of grievances to alter, reform, or abolish anything at any time we deem it necessary. And if the legislature fails to assemble, we go straight to the executive, which is the military, the commander-in-chief. And if our state level commander-in-chief fails to act, we go to the supreme, which is the president, commander-in-chief, which is actually what is really going on right now. Trump is still the president, whether people recognize that or not. See Texas v. White. Has already been discussed, and this is the power of the commander-in-chief, is acting as president, has the power to create provisional government pending the outcome of war. We have been at war since 1861. There has been no declaration of peace. We've been under martial law ever since. So the Lieber Code, the Law of War Manual, the Uniform Code of Military Justice. And by the way, I'm a Marine Corps veteran, so I have a little bit of an idea what I'm talking about here. So I know this, I've put this out there, I've taught people this. I've been teaching online for well over 5 years now. And I've been studying law and history of law for 28 years, since 1994. That does not include what I learned in the Marine Corps or in high school. That would have been quite a few years prior to that. The fact is we have government de facto and we have government de jure. And what's going on right now, and basically since the whole January 6th incidents, we have a foreign enemy occupying a territory within the territory of the United States of America. This is what's going on. This is a military op. And we need to be focusing on how this is supposed to be done following due process of law, which is the law of the land. Synonymous. It's literally means the same thing. So what Trump has put in place for us is this Office of Attorney General, this joint task force on consumer fraud and market integrity. Now, there's different divisions: antitrust division, criminal division, civil division. There's all sorts of different divisions under this, but this goes back to the manual for courts martial. Now, some people out there are having a little bit of a hard time filing these A091s. But that's the executive branch and what Trump wants us to go through and use. It's what he created. So, this is how our form of government and our power, this is the way it's supposed to work. Judicial branch doesn't have all that power that we give it. Suits at common law are supposed to be for suits between man and man, essentially a tort claim, which can be criminal in nature or civil in nature. This whole idea, concept of, this is criminal and that's civil. No, suits at common law can be criminal in nature or civil in nature, which dictates the outcome of the jury, whether it's a unanimous consent for finding it of guilt or only 3/4. So, but you get into like mens rea and that kind of stuff. Also, right in my own Idaho Constitution, which was by 1974, which probably stems right there from what you just shared earlier, Bob. Same stuff. They've abolished the common law pleadings practice, which they can't do because the common law belongs to the people. And that's that body of law the government was instituted to secure, because the common law is our rights as the law, maxims of law, the rule of law, which are principles of law, which are maxims of law. Those are those rules of the common law that this article, the 7th, refers to, maxims of law, not actual like rules of procedure where there is, but mostly it's principles. Like what I cannot do in my person, I cannot do through the agency of another. So if I can't do it, sure in the heck can't get any agent of a governmental agency to act on my behalf if I can't do it myself first. What a man does in his defense is to be considered legal, and actually it should be lawful. These are fundamental principles of all law because this is the rule of law, rules of the common law. And we've been brainwashed and indoctrinated and stripped of our republican form of government where the people have all the power and the public servants are supposed to do what we tell them to do. And that power comes from the Constitution itself. But I think everybody here is aware of the Reconstruction Acts of 1871, which has actually been made void, and also the corporate United States Inc. and all the inks were there. They've all been foreclosed, terminated, and abolished. They're done. They're bankrupt and insolvent. They're done. The last one there was done by Trump in June of 2020. So we're basically sitting here in limbo, and what's also referred to as draining the swamp. This is it. We need to get down to a local level, and we need to start removing these public servants from office for Executive Order 13818, involved in serious human rights abuse and corruption, civil asset forfeiture, and we take their land, their property, their agency, all of their whatever they have there, and abolish it. Rest them all. So there's a little tidbit there, other than the fact I started my own business, Kirk's Law Corner LLC. I originally started out with just a joke as a Facebook private group for myself to throw law in the corner as I was studying, to share wherever for jackwagons out on Facebook. Oh no, I got this right here to rebut. And it turned into some crazy stuff and got going, and then started doing live shows. And I was already on Blog Talk Radio for a year and a half before I jumped on Facebook and started doing lives there, because I didn't really think I wanted to do any of that stuff. Didn't want to be out there like that, but that just ended up where it ended up going. But I met this man, Christopher Hallett, out of Ocala, Florida. And when we first initially teamed up, he was already going after the bar. And that's what I said, our going joke. Hey, you going after the bar, bro? Because if you're not going after the bar, I'm not even going to waste my time. Well, did you read my paperwork? Well, no. Okay, so started reading some of his paper. I'm like, okay, you're my new best friend. And it was on since then. And that was the very beginning of 2017, the end of 2016, December there. So we ended up going to Congress, challenging the bar as a monopoly, and you can't license the practice of law. There it is again. Article 4, Section 4, going to Congress, the legislative branch. And they didn't want to declare it a monopoly or deal with that at that particular point in time. So they actually allowed Chris to create his own practice, loss prevention, for the government of the United States of America, and gave us jurisdiction over Title 42. Now, if you go to read Title 42, that is the entire executive branch. So we provided oversight for emoluments violation. It ended up being called E-Clause, the Emoluments Clause, Article 1, Section 9, Clause 8. No foreign emoluments here, no titles of nobility and all that fancy stuff. But Chris had already been working in loss prevention in the private sector for 27 years. So that's what was proposed to Congress as a initial temporary remedy to the situation of claiming the bar as a monopoly. Because can you hire anybody else? Is there anybody outside of the bar you can hire? Well, no. Well, then that's a monopoly, and that's no perpetuities, no monopolies. Can't have that. So we have the right to alter, reform, or abolish anything at any time we deem it necessary. Anyway, we are able to take down the entire Magistrate Division of Family Court in Ector County, Texas. Bulk transfer of over 1,250 cases to the district court. There is no longer a Magistrate Division of Family Court in Ector County, Texas. It's still up on the county clerk's website. A little document there, although they got rid of the other one, the order for dismissing all of those 1,250 plus cases if they failed to show up on December 20th, 2018. We worked with Senator Ted Cruz in taking down Ector County, Texas. Since then, we haven't had any like major stuff other than Chris got murdered November 15th of 2020. right after he filed a bunch of stuff November 4th, which he had actually just gotten a call from Congress asking him to come back. They wanted to revisit the bar stuff. So we were kind of thinking we were going to really finally make this come to fruition to take down the bar. And the fact is that he had cracked the billing code on all the backside of all these cases here they have on the bonds, right? The bid bond, the performance bond, the payment bond. And this is some of the stuff that we were researching and trying to figure out. And Chris had previously, several years ago, wrote code for medical billing. So he's also a programmer. So when I told him about this bid bond, performance bond, and payment bond on the backside of all these cases, and when we really started getting going with E-clause as loss prevention, and he conducted this audit on cases involving family law, basically, and then a couple of the criminal cases supposedly dealing with the kid stuff, found 57 or 59 different case numbers out of 6 cases. And all the bonds. So this was the big eye opener and the gold mine. And this is part of what he was getting ready to file the day he was murdered by the woman that he was helping, supposedly, who's sitting in jail. And we'd been working with her for 2 years. So we've done some pretty crazy stuff going through the legislature. One of the things that was missing, because one of our friends became a U.S. Marshal, which is actually what we were working on in E-clause, is coming in under the Office of Inspector General, and all of us becoming U.S. Marshals. So this got pretty crazy, especially since he got murdered. But the U.S. Marshal, when I helped a gal out of Ohio, I kept trying to tell Chris we needed to be filing formal criminal complaints, because that's what it says in the code there under False Claims Act. This is part of the emoluments, making false claims on the trust, antitrust law. So every time any public servant is getting a paycheck, that's false claims on the trust, because we cannot pay these people to trespass the law. And an emolument is any advantage, profit, or gain received due to one's position of employment or holding of office. So emoluments are essentially governor, secretary of state, lieutenant governor, the president. Those are called emoluments, the office, or as Attorney General Barr, when Chris put in the parliamentary inquiry, which Nancy Pelosi read live. What's an emolument? Well, it's a stipend attached to some office. Well, that's their advantages, profits, or gains, what their duties are to perform under that office. That's the person. That's what a person is. Governor is a person, in propria persona. Man is not a person. Fictions are persons, corporations, or these titles. So this is what we were doing, was doing audits for emoluments violations and reporting that. And I'm like, Chris, right in the very beginning here, we need to be filing these formal written complaints. And I found that executive order and was like, all right, I'm going to help this gal that they'd already been trying to help for 6 to 8 months and already filed paperwork. Nothing was happening. So nobody knew that I'd helped this gal out of Ohio file 3 public corruption complaints. We actually went through the website online through the Attorney General's office, state level. And she faxed in 3 of them, and apparently they only got 2 of them, but I picked up the phone and made a phone call to the number that was right there. Said, hey, I want this investigated. They're coming after her again. And based on what she has told me, this is all unlawful. What she has presented to me, which I'm sure she has sent to you by now. If you take a look at that stuff, and I'm demanding an investigation into this. 5 days later, our U.S. Marshal friend made an arrest of a judge and the prosecutor in that case. Now, again, nobody knew that I had helped her. So they were trying to figure out what the hell happened there. And then the only reason why I found out about it was because it was our U.S. Marshal friend that made the arrest. It just happened to be her jurisdiction. So then, yeah, it was, oh, well, no, Kirk helped me. What? No. Well, the U.S. Marshal went back and started from the very beginning. Where did this come from? How did this all come about? Oh, these public corruption complaints that were filed, blah, 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 blah. That's right. So this goes right back to the executive order 13844, that creating that office of attorney general, all these different district attorney generals, criminal division, civil division, antitrust division. There's several different divisions here. So this is what's going on and what we need to be using to effectuate remedy and relief. At least what I'm proposing here and what I've been doing. If you're going to go through the legislature, there's a whole set of other rules. You have your House rules of procedure, you got your Senate rules of procedure, then you have some states, like my state, has joint rules, some have general rules. There's usually a set of rules that apply to both. And then within those rules, you're going to find what book they go by, either the Jefferson's Manual, Mason's Manual, which 70% of the states use Mason's Manual legislative procedure. But when you get into the Mason's Manual legislative procedure, it references this Luther Cushion's. Well, I finally, after I got the 2020 edition, because I had the 2010 edition, I also have the 1953 edition in PDF. The 2010 and 2020 edition I have in hardback. And they're really small books. It literally fits in the palm of my hand, and it's real easy reading. I read these books in like 2.5 hours. Pretty easy reading, bold print, not a really good spacing. So it's like you can read a page in like 20 seconds. Anyways, it references this Luther Cushion's. Well, finally, I'm like, all right, I got to go dig this sucker up. Well, it just happens to be entitled Lex Parliamentary Americana. And it gives the whole history, clear back to England, English common law, and into the American common law. See, we have an actual American common law that's separate from the English common law, which actually started in 1606 with the first charter of Virginia. We brought that over here, the good Christian people, if you read these charters, these corporate charters, the Virginia Company. Say again?
No, I'm talking to my dog.
Oh,
Sorry.
hi, Bubba. So, this is how this all got started. And we actually have an American common law. Yes, we brought that, the English common law with us over here, but only those parts which were conducive to our will, what we decided. And see, this was part of what happened even in 1689. Early 1680s there, when the little war broke out about, well, we're going to dissolve the Virginia Company. And the Virginia Company saying, no, you're not. So we broke out in a war. No, England, kick rocks, get out of here. We're not abiding by your crap no more. And this is the precursor into the Revolutionary War. Again, we ended up with the English Bill of Rights of 1689. And if you read that sucker, right in the very beginning, it talks about the executive branch exercising powers that properly belong to the legislative branch, like what we're dealing with right now. The executive branch taking this power, declaring this so-called state of an emergency when there's no enemy attack, because that's the only power that they have, is to defend from foreign invasion or domestic violence, which is internal insurrection, back to Luther versus Borden, not family law domestic violence. That's the Violence Against Women Act of 1995. Nope, that's already been found unconstitutional in 2000, U.S. versus Morrison. And then Congress somehow reauthorized that again in 2005. How do you reauthorize an act which you didn't have subject matter jurisdiction to begin with, let alone personal jurisdiction, to alter what domestic violence really is, and then create due process of law, and that you can deprive the fundamental right to keep and bear arms, which shall not be infringed, and you can deprive fundamental rights of liberty and give this order of protection through the alleged civil process through the family. No. Anyways, that's another road that I went down and have exposed. through what I helped with Timothy Charles Homestead out there in 2019. It still hasn't been fully resolved, mostly because of a fallout between what happened there. But I have my own cause of action, and I'll get to it someday. But hopefully that kind of gives a general background for me, myself, and I over here.
Yeah, Dave hasn't been able to introduce himself to Robert or Luke. Dave, can you say a few things, please?
Yeah, thank you. I'm Dave Roberts, and I go around and build state and county assemblies and try to put things in place so we can eventually, hopefully in a short period of time, start establishing common law grand juries and start holding 12-man pettit juries and mini courts and start bringing charges
No.
against public officials. So that's one of the things I'm working on. Been doing this for a while, probably as long, if not longer than Kurt. And so it's a learning, I'm growing, trying to grasp as much of this understanding the law as I can. So where I'm at.
So how many states have you assembled, states and counties?
Right now, I probably have 5 states assembled, and I got probably 40, 50 counties across the United States assembled. I'm getting ready to bring North Carolina in as a state assembly. So,
Are you familiar with National-Assembly?
Yeah,
.net?
I'm well aware. We use their paperwork. Okay. We went through their stuff and we liked it. We made some changes on some of the basic paperwork. Nothing major, but a couple words that they liked, but we didn't like. And we talked to them about it and they weren't in favor. And so we still went ahead with the changes and moving forward in that regard. Yeah.
Yeah, well, I've had a pretty lengthy conversation with, and I'm still involved with them, and I'm working on try to do Idaho here, but I got a lot of stuff on my plate right now. The fact is that paperwork that's out there that you grabbed, that's not the right paperwork, and they put that out there as a diversion.
It's whether it is or not, I've been to their meetings
Mhm.
and that's the paperwork they're using at their meetings. So I don't know about the diversion.
Are you talking about the closed meeting, assembling the 31 to 35 people, the
They're the Michigan Grand Jural Assembly meeting. I've been to more than several of them. They hold them once a month,
Mhm.
every month, and I've attended several of them.
Yeah, I just had Destry and Paul here at my house here about a month ago.
Okay.
They were just swinging through. They were supposed to work over there in Washington, and it fell through. Wanted to come meet me, so they took the 9-hour drive from up there, Lewiston area or Spokane, and came down here to Boise. So, but I've been talking with them for about 8 months now. So
I've been associated with them since 2016.
awesome. Well, that's good to hear that it's not the Anna Von Reitz crap.
No, not at all. Or the the Republic with a K or
Yeah, there's several different ones out there. The governor of the United States of America, 1770 yeah, 1789.
right. Or I'm trying to think the group out of New York. I'm trying to think of their name. I can't
That
think of
the lawful living
Life Force.
life force. That's it.
Yeah. Yeah.
I've been down a few rabbit holes trying to figure this stuff out. National Liberty Alliance was quite intriguing for me many years ago when I found that back in about 2014. No, it was before my son, so about 2012.
Their stuff, Liberty Lions stuff's pretty good as far as
Yeah.
the written stuff.
Mhm.
But as far as them acting or taking action or
Right.
implementing, they're ghosts.
Yeah, it's funny because this is so weird turn of events. When I looked up for the Idaho, who was supposed to be our jury representative, whatever, common law grand jury representative, and then I'm looking at the address, and I'm like, wait a minute. That was when I was teamed up with Tony Pellegrino and Lee Arthur Rice at American Common Law Academy. And I'm like, wait a minute, that's our office out here in Nampa. And then I hit up Lee and I'm like, Lee, you're National Liberty Alliance. You're supposed to be our common law grand jury guy. He's like, oh, yeah, well, yeah. I'm like, what happened? Why are we, it couldn't, there's a problem. You just can't get enough people together that can comprehend this stuff, even on a basic level.
Right.
And the other part is that people are just too scared. I think there's a
That's
fear factor. They're afraid of this so-called government, and it's like, dude, this is our power.
Right.
We're the masters. They're the servants.
If I can get you to stand up, just stand up, get
Right.
behind me, just stand up behind me, we
Yeah.
win.
Yeah.
We win.
Exactly.
And they're like, yeah, but I'm putting a target on my back. Oh my God, you already got a target on your back.
Yes. You're being human trafficked on a daily basis. Look at human trafficking part B, debt slave, peonage.
I go,
Same thing I told Tori says, and
oh, I love
know?
that woman. Ugh. Go
oh,
off the floor.
she does not know what the heck she's doing. I've
No.
been on the phone call with her and figured it out. And now she don't even want to talk to me because she knows I know that she doesn't
Yeah.
know what the hell she's doing.
I was on her Telegram room and I made a couple comments in disagreement with Tori. Next thing I know, I'm not on her Telegram room anymore.
Bingo.
Yep.
Yep. Me too.
So
I talked to her on the phone twice. And then, oh yeah, well, let's have our meeting on Friday, and well, in that end of that conversation was, oh well, yeah, I'm going Title 42, blah 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 blah, Title 18. I'm like, wait a minute, you're trying to do civil rights violations, and you're just citing Title 18. Title 18's criminal. Title 42 is civil for civil rights violations. You can't bring a criminal action in a civil action for rights violations under Title 42, 1983. The title of the petition is Civil Rights Violations. And right out of my common law pleadings book, it says you have to articulate in the petition, in the very beginning, what is the right? What is the conduct that violated the right? And what are the damages? And we're not talking about punitive damages.
correct.
Punitive damages come from criminal, punishment. We're talking actual damages, medical bills for broken bones. You can claim mental anguish. If your neighbor ran into your fence and it's going to cost $750 to fix your fence, you're only entitled to $750 worth of damages. Period. That's all that they would need to pay to make you whole again.
Right.
So that's where you get into failure to state a claim for which relief can be granted, or failure to state a cause of action, lack of standing. Oh, well, I'm going to sue you criminally under Title 42. No, failure to state a cause of action for which relief can be granted, case dismissed. We're done. But that's part of the hijacking that Rob was talking about on their suits at common law. And what we discovered, that's Title 42, 1983 is a tort claim under the common law. But that would be what? Back to the Declaration of Independence, legislating for us in all cases whatsoever.
Right.
And that's what they've done. They've fundamentally altered our form of government, subjecting us to pretended acts of legislation. It's all code. Ever since 1871, the Reconstruction Acts, they reinstituted the Roman civil law, the Roman code, every one of us is under the bar code. It's all barcode. This is the bar. This is why they say you have to have a license from them, permission, because license is seeking permission.
Bar Gill
Oh.
Court.
So
It's all, these are all barcode, barcode courts
Bar Gill.
enforcing bills of
Court.
attainder and bills of payments and penalties under the Roman civil law back to 1881, that code of civil procedure. Over to you, Robert or Bob.
So, two things. One, when I was doing some recent research, I was researching the Bill of Rights. So, when my premise is every time we cannot talk about any of their legislation, we cannot talk about any of their US codes, we cannot talk about anything. We can only talk about the Declaration, the preamble of the Bill of Rights, only the preamble of the Bill of Rights, or I'm sorry, the preamble of the Constitution, and only the Bill of Rights. But when I started digging into the Bill of Rights, it was interesting. So 17 amendments came out of the House in October 1790. 12 came out of the Senate in November. Washington signed 12
Mhm.
and sent them to the states for ratification.
Mhm.
Okay, here's the problem. Right now, when a president signs a bill, it becomes a law. So then the question is, where did Washington send 12 amendments to? And how come only 10 came back? Only half of the states actually had constitutions at that time. So who did he actually send it to? He sent it to the common law assemblies. He sent it to the House, to the Virginia Assembly. When I was studying Hamilton, when they were trying to pass the Bank of the United States of America, Hamilton has numerous letters, but they are all to the ratifying convention.
Mhm.
The ratifying convention was the New York State Assembly. There is actually a fourth part to approve a law because that part had the ability to veto, even if the president didn't veto, and even if Congress superseded the president, it still had to get out of the assembly.
Has to be ratified by the people.
Which
Has to
means
give
that
consent of the
everything-
governed.
That's right. Which means that every single amendment past the 12th Amendment actually has never been ratified. But this is why it hasn't been ratified, because we're missing 25% of our actual ratification process. We're missing the assemblies.
Yeah, they removed it.
They removed it on purpose. So here's how I think we get it back. So I'm doing this experiment here in Charlotte. So I decided that I filed a case. It's mid-September is actually when the time limit's up on it for the state's attorney and the attorney general. I filed an action at law against the people of Charlotte County, Florida. In that action at law, I served the state's attorney of the 12th Judicial Circuit, and the 20th Judicial Circuit, and I served the attorney general of the state of Florida, and I gave them summons. But the lawsuit is only because I'm so stupid. I need to know who I am, and I'm lost. So I have two witnesses that have known me since my birth that are actually going to testify. In it, it asks questions like, is my name this? Was I born on this date? Is this, and I have my actual live birth certificate that actually has like my feet prints and my mom's thumbprints, like actually out of the hospital, the true, actually sealed two witnesses live birth document. So it's a series of 20 questions, and these questions go through, do I actually have right? Am I the person of the people, of we the people, referenced in the Constitution of the United States of America? Am I a person of the people, of we the people, referenced in the Bill of Rights? Do I have inalienable rights? Am I an artificial person? am I a legal person? So it takes it through 25 questions. The last questions are, can any seat of government, any political subdivision, any public officer agent not acknowledge or deprive or withhold anyone's rights inside the United States of America? So I don't know what's going to happen with this, but I'm trying a different tactic because it's quite possible the state's attorney and the attorney general are not even going to show up. No one might show up, which means I'm going to have free reign in the courtroom, action at law, to basically ask the jury whatever I want. No one's shown up yet. It's been 3 weeks. It's actually been a month because I paused the summons for 2 weeks before I sent off the summons.
Yeah. So technically speaking, the common law courts is actually paperwork, not really a building. It's out in the streets. Look up the word court even in Black's Law Dictionary. It's out in the streets, down in the alley. The exterior walls of the building. Court is not a building. The court or court of record is actually the documents. That's the court.
Correct.
This is where they bring in the word, venue. Venue is jurisdiction. No, venue is just a place where it's heard.
Correct.
But in all reality, following due process of law and the rules of the common law, notice and opportunity is the very first step of due process of law. And that's a duty that we owe to our fellow man from the Bible. It's a fundamental principle. You are to go to that man and talk to the man and see if you can reason with the man. And if you can't, you're supposed to go and get 2 witnesses, 2 men, and come back and try to reason with him again. And if you can't reason with him there, then what? This is where you go back to the church, which is supposed to be your general assembly, because that's what a church is. Not a building. The church is the people. That's part of your general assembly. And this is right out of frickin' constitutions from around the 1776 era. And you were saying it before, they didn't have constitutions. Oh, no. Every last one of them had constitutions in 1776, and actually even prior to 1776. Throughout all history, even in the late 1600s, they had constitutions.
Right.
But Virginia is the key to all of this.
Well, I agree with that.
The Lee's resolution, which is July 6th, 1776. Then you have the Virginia Declaration of Rights as the theoretical foundation of all government. And that's June 12th, 1776. Then you have the Virginia Constitution, June 29th, 1776. That is the Constitution that lays out our 3 distinct branches of government and our Republican form of government. And if you read that sucker, you're going to see much of the same language that you'll find in the Declaration of Independence is in the Virginia Constitution. These 4 documents go together. The Declaration of Independence is not the document. The Declaration of Independence is the document that declares the causes for the separation, because that's what it says as it is written. And declarations lay down the law. The Declaration of Independence is declaring our independence from tyrants and declaring tyrants as our enemy, as in treason, giving aid to our enemy. All of those actions by the king or a tyrant are all things that are foreign to our Republican form of government. And then when you're talking about back to the law stuff and rights is the law, you go to the Law of Nations written by Emer D. Vattel, or the full title of those books is the Law of Nations, or the laws or the principles of the laws of nature. That's the full title. Now, when you get into the laws of nature, we're talking international law. So yes, all settled civilized societies as nations, nation state, a state of being, a body politic, is bound by the laws of nature. That's why it's in the Declaration of Independence. That the laws of nature and nature's God we are entitled to. And to assume the powers of the earth. This is God's creation. just like man is God's creation. But God gave man dominion, free dominion over the land, the air, and the water. Not the sea. It's LAW, land, air, and water. And when you get into the law of the air, this is where you get into souls and trusts. Those footprints that you're talking about on that, that's your soul print.
Mhm,
They're stealing your soul. And this
mhm.
goes back to Roman civil law and back to Perene's Patriae, where the state is the parent. No, this is part of the crap that was trying to get away from even in 1215 with the Magna Carta. You read history like I have, you'll see this repeated thing over and over and over again. And it's the same old thing. A tyrant trying to come in and dictate to the people, and then, oh, you can't have that. You can't do this. Here's a pretended act of legislation, and we're enforcing this under the code. And right out of Bouvet's Law Dictionary, 1856, look up the term law, comma, civil, Roman civil law, whoops, the code. And then in section 7 there, it talks about this is all enforced through pains and penalties. That's Article 1, Section 9, and Article 1, Section 10 prohibited to the states and federal no bills of attainder. Period. We're done. Get rid of this code crap. Get rid of the bar, which it's coming. I can tell you right now. So it's all human trafficking, part B. We've all been turned into these debt slaves because they say that we owe them the debt when they're the one that took everything in trust that's worth way more than the alleged debt that we owed, which they're the ones that created the wars. They're the ones that funded both sides. They're the ones that caused the damages. So therefore, they're the ones that should be paying the debt to whomever, like us, America, or wherever, whoever they caused damage to. And the who is Great Britain, the Roman Catholic Church, which is nothing but Islam in disguise. So I yield. Thank you. What are you thinking over there, Bob? I can
I'm
see the
saying-
gears turning.
Well, of course. Listen, they're always turning. I actually have Emerald Vitell on my shelf, so I know exactly what you're talking about. And I agree with you. It is the only, from what I can reference, it's the only book actually cited in all those documents. So
Yes.
it's the only book that we don't know anything about. So, or at least it's one book that we don't know anything about. So you're totally correct on all that, and I totally agree. I think the
Oh, yeah.
hard part is, one of the things that I've been trying to play with is I've been trying to figure out how do we establish power at the bottom, and then how do we move it up. So I've done a few things, right? And I haven't explored this a lot. So this is just theory, and so please don't take it. And I would love to hear your responses. So one of the things I started creating was a political party, a separate political party. Political party is actually based on the model of the actual assembly. So trying to play both sides of the coin, using the Constitution as the foundation, and then using the territorial voting districts to actually put forth delegates through territory district, and using that model, and then using the 1915 Robert's Rules of Order as the base model, because it seems like anything after 15 is they kind of convoluted stuff where it wasn't as open, debatable, as harsh, I guess, as harsh as it should be. And I like harsh. So, but really what it does is it takes the voting district, breaks the voting district down, and then only that voting district can put forth a delegate forward into the county. And then from the county, they can only put forth delegates at the state level, but it's actually running as a political party, playing on both the land and the water at the same time. So then you have to actually convince the people in your voting district to get you to the next level. instead of being presented the game.
Mhm.
So
that's-
this is
how
a model.
that's how
Go
the-
ahead.
That's how the assembly is supposed to work. The power of the people coming together with an equal voice, and everyone have an equal voice, and they choose the delegate that they wish to bring forward to the county or to the state or whatever the case may be, or the nation. All right.
Right.
But it's the people at the ground's roots that make that choice. Okay. And they do it
Absolutely
equally under vote. Okay.
Right.
And everything's a vote. And the state or the federal has to come back to the state, which then has to come back to the county, which has got to come back to the township and get their approval. That's how the assembly works.
I agree with
Yes.
that. What I'm saying is, instead of just staying on the land, go play in their land, set up a minor political party, start to establish delegates through that model.
No,
Putting
okay,
one foot-
I hear what you're saying, okay? But we operate under the republic, okay? We don't have to recognize this corporate entity that has transformed our world, okay?
Huh?
We create our own republic, we create our own sheriffs, and it's already been proven.
Yep.
And you talked about Scalia earlier. It's already been proven under United States versus Williams that when the de jure government shows up, the de facto has to leave, not vacate. They have to leave. They have to leave office.
That's
It's
right.
already been proven. We
Yes.
were in Ohio, in Franklin County, which is the capital, Columbus, and we were settling. That's when the county committee of safety settles the county on the land, and we had to make a public announcement at the county commissioners meeting. And we stated that our county is now de jure, and the county commissioners, the attorney of the county, they shit their pants. They literally shit their pants, and our delegation of 20 people was escorted out of the building by the sheriff.
That's right.
Yes, escorted out.
Yep.
So
So let me
explain.
let me jump in
Go ahead.
on this
Go ahead.
because this is David's exactly right, because this is how our form of government works from the ground up, of the people, by the people, for the people. So you have to assemble the state level and the county levels. Okay, this is the power of the people to create the sovereign body politic, the state or nation state. That's book 1, chapter 1, section 1. It's also section 1 of the preliminaries before section 1. The body politic is the sovereign body. The sovereign is the power to create, such as God is the sovereign who created all things. Man creates, but what I cannot do in my person, I can't do through the agency of another. Can I go ahead and just create a common law grand jury? No, I cannot.
No.
I am one man. It takes a set of men, or a quorum, a requirement, a number of people or men. And then you have to have your covenant and oath. The covenant is unto God, and the oath comes from the Bible. There's no firmer bond among men than an oath. So this is what binds us together to do what? To defend our rights. And government is instituted to secure these rights, the body of law known as the common law. Now, once you have that assembled, then you can create the Constitution. That's the instrument of government that is to serve the people.
Correct.
Okay. So all of that has to be done. And if you read the very beginning, some of the beginning constitutions and stuff, this is broken down. The General Assembly and the General Court. This is the court of justice. In the judicial branch, those are courts of law for suits in law.
Right.
And in equity, having an equitable interest in land, because that's what Article 3, Section 2 specifically states. This crap about equity and being equality is false. It is an equitable interest in land. That's what it says. Other than that, it is admiralty or maritime. Now, Article 6, Clause 3. all of the members aforementioned of the legislative, executive, and judicial, both state and federal, shall be bound by this bound to support this Constitution.
through oath or affirmation.
That's right. Shall be bound by oath or affirmation to support this. I did leave that out. Sorry. So that's it.
Right.
They're the ones that are bound by admiralty jurisdiction, not
Also-
common law.
Yeah,
So we need to stop trying to use common law, rules of the common law and common law procedures for those that are under admiralty jurisdiction. This is what I'm getting at per the executive orders and what Trump has created. They're bound by admiralty jurisdiction. Because
Right.
remember, even like police, which actually is pronounced policy, look up the etymology. This is England creating these, erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance. Declaration of Independence I just cited. So these are those standing armies, armed bodies of men. But anyway, they have a chief of police. They have their lieutenants. They have their sergeants, corporals. Wait a minute. Any of y'all been in the military? You realize that those are military ranks?
Right.
That's admiralty jurisdiction. Now, what is the governor? The governor is commander in chief. Imagine that. That's admiralty jurisdiction.
Appointed by the
Lieutenant governor, secretary of state, secretary of treasurer. Those are all admiralty jurisdiction. Those are officers, right? And everybody from the legislative, executive, and judicial branch, whether you're elected or appointed into a position of public trust, is bound by admiralty jurisdiction. You are in service to the people under admiralty jurisdiction. This is what happens when you become from, you have to come from the pool of the people. Now, see, this is the common law side, comes before the Constitution. The sheriff has to become one of the people. Now, once you assemble the General Assembly, you can, in your county, you can assemble to elect your sheriff, to elect your county commissioners, to elect your officers, which has to come, and this is right straight from the Virginia Declaration of Rights, that comes from the pool of the people, and at certain fixed times shall return to that which where they came from, and can be reelected depending on what we decide, whether they can be reelected or not. Now, some of the early constitutions say they can't. You got to wait a certain amount of time before you can be reelected in a certain office. And there's reasons behind it, which is good. But,
Everybody needs a turn.
and in fact, that is one of the things that it says, because everybody should have an opportunity to sit in those seats so that they know how our form of government's supposed to work and that they
Correct.
can actually have a say in it.
Correct.
But it says, as is written in the, which one? I've read so many of the 1776 era constitutions. I can't remember if that was the Pennsylvania one or if it was South Carolina, North Carolina, one of those. I don't know. I've read so many of them now, it's like I'm lost. But
Yeah, I know what that feels like.
it's amazing how this is supposed to be, as it is written. The General Assembly and the General Court is the court of justice. We're the ones that are supposed to assemble the grand jury, which is, why is the number 31 to 35 to assemble the state level? Clear back to the Magna Carta of 1215, chapter 60. The grand jury consists of 20 and 5. That is 25 men. That right there, that's the common law. That is where we get 25 men for a grand jury.
Correct.
This is part of the General Assembly because you have to have the grand jury. Then you have to have your officers. So that's the state level. Then you've got your petite jury, which is small, petite, is 12.
Correct.
Okay, that's also in the Virginia Declaration of Rights. Okay, of 12 men of your vicinage, without whose unanimous consent, you cannot be found guilty. They want to try and tell us today for a trial by a jury or jury trial that, oh, well, it's got to be unanimous, either guilty or not guilty.
Mhm.
No, there's no such thing as a hung jury. You get one chance, no double jeopardy. And if you don't get the consent, that's why they keep asking, well, do you want to poll the jury? Yeah, damn right I want to poll the jury. I want each and every one of them men or women to stand up and say either guilty or not guilty. And if there's one out of that 12 that says, I'm just not convinced and I don't give my consent, not guilty, that is an acquittal. There is no second chance to prosecute. That's double jeopardy. Period. But people got to read, people got to know that this is how it's done. And even in dealing with the de facto, you can raise these issues. It's unlawful, not unconstitutional. This is unlawful. This is real law, because law is that which is laid down, ordained, or established. Now, most of us here are familiar with the preamble for the Constitution for the United States of America. It says it is ordained and established. My Idaho Constitution says it's established. That leaves laying down. Well, that's what declare means. D meaning down, and clarify, in writing. We lay down the law through declarations. That's why the Bill of Rights is a Declaration of Rights. And I'll take you to American Jurisprudence, Volume 16, Constitutional Law, Section 100, very current, as of right now. I could pull it up because I have a subscription to Westlaw. But I have the 2017 from Law Library. It says that bills of rights and those merely declaratory of the common law. That's right. That's laying down the law. Declarations lay down the law. And that's why the Declaration of Independence specifically states that to secure these rights, the Virginia Declaration of Rights, that to secure these rights, governments are instituted among men receiving their just powers under the consent of the governed. How we give consent is through the Constitution. And you have to be one of the people to vote and ratify that. Otherwise, you're a free inhabitant. Articles of Confederation. No, that's a free man. Oh, that's sovereign citizen crap. No. Book 1, Chapter 19, subsection 212. What the heck is a citizen? Oh, well, it's member of the society who's bound by it. Oh, wait a minute. The word member and bound, I find that in Article 6, Clause 3. Why do you think our founders wrote that the way they did? Right straight from, because that's also the section that talks about a natural born citizen. That's also found in the Constitution as a fundamental requirement to run for president. You have to be a natural born citizen. And when you look that up, that's exactly the section that's cited from Vattel. They wrote a lot of this stuff straight from the Law of Nations, word for word. So a citizen is the public servant, or city servant, civil servant.
Yeah,
We,
but
the
that's
people.
That's a capital C, not the lower C.
Yes. But if you look into it further, it talks about there's other types of citizens, but not the type of citizen we're talking about in propria persona. The capital C is a proper noun, which is
Right.
in propria, or in proper person. It's a personification. It's a personality. They have to act out or perform the duties or discharge the duties of that office, the emoluments of that office that the people create, because the people are the sovereign body. And then from that body, we elect our representatives. And Article 1, Section 10 of the Idaho Constitution, which is a Declaration of Rights, it says the right to peaceably assemble, to consult for our common good, and to instruct our representatives, and to petition the legislature for the redress of grievances. Now, wait a minute. Let's read that backwards. We petition the legislature. Well, who's the legislature? Oh, that's what peaceably assemble means. That's to peaceably assemble the General Assembly, which is the church. On Sunday, we're peaceably assembling, depending on what religion you are. You could be Saturday, whatever. One day a week, we're peacefully assembling so that we have the opportunity to redress our grievances. And we sit there and we consult for our common good. Well, do we need to assemble a grand jury for a grand jury indictment pursuant to the Sixth Amendment? You're damn right we do. That has nothing to do with the established government.
Right, correct.
This is common law. This
Correct.
is a different body of law. This is parliamentary practice. And the people are, in fact, the first branch of government, the sovereign body that creates government. Period. That's
And
how
the
that
grand-
works.
and
And
a
unless
grand
you
jury-
have that mechanism and those people, not man, you got to have your covenant and your oath to become one of the people and exercise that political power. Now, there's certain requirements for that as well. You got to have a residence. I know a lot of people don't like that word, but it's been taken out of context. It's been twisted. You read it from the Law of Nations. Okay. That means you've declared you're settled here. You're not a free inhabitant. You can be the way our founders set up our republic because they read the Law of Nations. Or you're a vagabond, right? You don't want to be a vagabond. So there's all these different words and terms that's been twisted by the bar to mean something that are totally opposite of what it's supposed to mean and legitimate lawfully means in international law from the laws of nature. And our founders fixed that and made sure that we had free inhabitants, read the Articles of Confederation, the people, which is a sovereign body having political power, and then you have the citizens. Now, the people technically considered are the lowercase c citizens, but we're not really referenced as that. We're referenced as the people because we, in our republic, we are a capitalist confederate republic, not a constitutional republic, not a representative democracy, not a living constitution. No, Constitution is the instrument of government written by the people, and it is a fixed instrument. It says what it says as it is written, and it is unalterable except by the people who created it or have the power to alter that. The servants do not have the power to alter the laws of its creation. That's also Law of Nations, Book 1, Chapter 3, Section 34. That question was asked and answered. The legislature does not have the authority to alter the fundamental law or the Constitution. And it even says in there, how is it that that which is created can alter the laws of its own creation? It would be completely illogical to think a servant can dictate what their scope and authority, what the emoluments of their office are. No. You signed on to fill that position. You have to perform the duties as we, the people, dictate. You're the servant of the people. You do what we tell you to do. And if you don't, we get to remove you from office. Now, that's how it's supposed to work. And that would go back to the General Assembly through a petition to the legislature for the redress of grievances. And you would assemble the grand jury and do a grand jury indictment and prosecute him through a criminal court. Pardon me, let me change that. A common law court for a
Right.
suit at common law between man and man,
Yeah,
not
man,
under admiralty jurisdiction,
correct.
because
Man
this is
or
supposed to be
animal.
one of the people. And this is actually what the Bill of Rights, this is what the Constitution is for. It is for them, not the free inhabitants. This was to ensure that the people who went into service, the government didn't go rogue and start depriving public servants' rights, because that's what was going on before the Revolutionary War. We were electing our representatives. We had our own perfect legislatures, and they were destroying our own legislatures and sending these other officers in. The king or the prince was sending these people in and going, oh, we're going to take over. No, you're not. We don't consent to this. But see,
Right.
this is that power struggle throughout history, even clear back to 600 AD. It's the same thing over and over again, a power struggle. And it's really good versus evil.
Kirk, I have a question for you.
Yes,
And
sir.
it sounds to me as if the biggest challenge is getting sheriffs on board and educated as to what's going on here. Maybe I'm wrong. I mean, I'm new to this, and I know I know the least of anyone here on this call, but from what I'm listening to, it sounds like that's what we need to do is get the sheriffs informed and educated on what's going on here. And I guess my question would be, what is the biggest challenge to getting them educated and informed? I mean, is it because they're, I don't want to say it, but I'm just saying, what's the biggest, you know what I was going to say, but what is the biggest challenge to getting them on board with this?
Well, I think the problem with sheriffs is the sheriffs work for the courts.
Yeah.
They fall in
That's
the
what I was gonna say,
judicial
yeah.
branch of government,
Yeah, that's what
which
I was gonna
means
say. Yeah.
that sheriffs protect and serve. What do they protect? They protect peace, no rioting. They serve writs, warrants, and summonses,
Mhm.
which means the order or the command has to come out of the court. It also means if you go to Florida statute, and I can't speak for Idaho or any place else, but Florida statute, the sheriff is the executive branch of government for the circuit court. So then it still goes back to the courts. The other problem, one of the biggest problems is, and I'm going to speak to Florida, when they merged the dockets in 67, they took possession of the clerk of court. Okay. The clerk of court. And if you go to Florida statute at the bottom of the Florida statutes, it says exchequer. When you look at the exchequer, when you go back to England, back into the 13, actually today, it's still the same. When you look at exchequer is the treasurer. So the clerk of court is actually the exchequer. The exchequer is the treasurer. He's not only the treasurer, he is the keeper of the record. He holds the code. He carries the purse strings. And according to Florida Statute 137, he is the printer of the election ballots. He is the one who keeps the oaths. He is the one that keeps the qualifications for all candidates. This is all about the clerks of court. That's where the money is. That's where the record is. That's where the power is. And if we can't get to the clerk of court, we cannot get a hold of the purse strings. We cannot get a hold of the record.
If you're going to
So
bring a
here's-
lawsuit against the judge, you better include the clerk of court in that claim.
Here's the problem. You're citing what you think is a statute. It's actually all that code written by the bar. Number two, statutes, if it was a legitimate statute, has to have subject matter jurisdiction from the Constitution. Now, here's the problem with everything you just said. That's contrary to the common law and the power reserved or retained by the people. See the
Right.
10th Amendment. Okay.
I
This
didn't-
belongs to the people. The people dictate how elections happen. And in reading in history, it says you have to show up. And those that show up can be nominated to run for office. And those that show up cast their ballot to elect their representatives. And you physically have to be present. Now, I know that would be one hell of a feat and task in today's timing, because look at the population that we have now. Where in the heck would you, what kind of building or space would you have to have? I mean, Idaho, we're still podunk here, right? You know, we grow potatoes and gems and cold stuff, you know, just an Idaho redneck here. You know, we're at 200,000 people here in Boise. Even at that, everybody who would want to show up to vote, where in the heck are we going to do that? I mean, we got the Boise State Stadium, football stadium. We would probably fill that thing 3 to 4 times over, including the entire field and everything else. There's not enough room to house all that. So we got some issues to overcome when we get there. And we are going to get there. Make no mistake. The power is, you know, even Trump in his inauguration speech, I am putting the power back into the people's hands. And I've asked this same question ever since, and even before Trump even said it, but what is the power that he's referencing? It's all political power is inherent in the people. And this is where you go back to even like American jurisprudence volume 15, Civil Rights Section 2. Natural rights and civil rights have nothing to do with the establishment, support, or management of government. And then it talks about, well, natural rights come from God, and civil rights, or those come from society. And political rights, not everybody has political rights. So you have to become one of the people in order to claim political power. Otherwise, you remain over here below or above the line with God and in God's law in the private, and has nothing to do with government. You don't have political power. You're a free inhabitant. You're free to go do whatever. And even in some of the older stuff, talks about out in the wilderness, outside of the city. We're not subject to any of that statute or that ordinance. There's no personal jurisdiction over man in the private. You can also read Hale versus Hinkle that kind of helps clarify that. The state can't bring a suit against an individual because we owe no duty to the state because we're not bound by that crap.
Right.
That's not law. Statutes, if they were legitimate statutes, we still wouldn't be bound by that because there's no oath of office. There's no contract of employment. You'd have to be-
That begs the question. My next question would be, does this get fixed outside of the courts?
Okay.
Yes.
My answer would be, there's a sequence of events that have to take place. In my mind, it's the assembly, and then the assembly approaches the sheriff. And one of the problems with the sheriff is the people have to fund the sheriff.
Yes.
Because the way the sheriff's getting funded right now, he's never going to switch allegiance until he gets funding outside of the current system.
Okay, may I jump
Oh,
in
yeah.
here,
Yes,
please?
absolutely.
Okay, sorry, because.
Been
I'm
7
gonna
minutes.
get It's been a long 7 minutes, sorry about that. Okay, so I've been working with a few sheriffs, and namely, the main one is Sheriff Dar Leaf of Berry County, Michigan. And he is the closest, I would say, to a constitutionally compliant sheriff that I have met, as of today. I was just talking to one of his buddies that are in his common law group that they meet on Thursdays, and I think Mark's on the call here. His name is Jack. We call him Jack the Legend. And we were asking him about the common law grand jury. Why, because Dar's like, it hasn't been done in like 150 years. Like, how are we going to get justice? I mean, who's going to prosecute? Like all these questions. He is open to doing this. And by the way, Sheriff Dar Leaf, it has a lawsuit, which I think it's just a Mickey Mouse court anyways, but a lawsuit against the Secretary of State and the Attorney General because they interfered with his investigation in the voting machines. They removed the machine so he couldn't continue his investigation. Now I say he should have arrested them on the spot because that's not right? Which he didn't. But then an attorney reached out to him, and now he's got this ongoing lawsuit. Another thing I want to say about Dar is, I don't know how many years ago it was, let's say 8 years ago. He says, don't blame the sheriffs for not knowing this. I was one of them. He said, we're taught statutes and codes and police academy, not the true duty and authority of a de jure sheriff. He said, it wasn't until my community came up to me and said, hey, we heard about this thing called CSPOA, and I'm going to give Sheriff Mack some credit here when it's due. And they said, we will pay your way. And not only that, we'll pay for food and everything. We really want you to go. Well, he kind of him and hawed, and he talked to his under sheriff, and they said, hey, if the people want you to do that, you work for the people. They're going to vote you back in. You should go. So bottom line, he went to the first CSPOA conference, and his jaw dropped, and he was never the same. And then he started to study the Constitution, the common law, and here he is. And he is one of us, you guys. And so we've been trying to get him engaged with other sheriffs, like get a sheriff forum together, which has been like pulling teeth. But Sheriff Dar is under attack because of his stance. He's getting nonstop requests for FOIAs. They're trying to keep him busy so he can't do what we want to do here. But we're going to have him on a call this coming Tuesday. We're going to form, which we're kind of doing right now, and we're going to welcome you guys as well, a common law mastermind meeting. And Sheriff Dar will be on that. I pray once I call him that he will be on it. But so will his 3 key men. I call these men from Michigan our new founding fathers. I've been calling them that for probably 2 years now. And 3 of them I know for sure will be on this call. And they have a lot of information and knowledge, just like you guys on the call here. What needs to happen is we all need to come together And we also need to educate Dar so he can educate the other sheriffs. And I have several sheriffs right here. I'm in the state of Washington. Sheriff Bob Songer, she's pretty much like Dar. He's got a posse of 300. In fact, another thing, all these things going through my mind, when you were discussing, we need to get behind the sheriff and support him, because the other day when I was talking to Dar, mentioning the sheriff forum, and I told him that I helped Sheriff Mack write an article. He goes, well, have Sheriff Mack take over the forum. And I mean, he's so much on overload right now that he can't even think straight. And I said, you need people around you. I said, hire an extra assistant. And he goes, we don't have the funding. And I said, okay, here's a thought. How about you call on your posse? He's got a posse of, I think, 30 men. And he's like, okay, you just stole my thunder. I think I'm going to do that. I said, you need to, because it's time. And he wants these people to oversee the voting, right? That's coming up. I said, well, heck, if they've got wives, deputize them or do whatever you have to do. Let's get the help. The people need to come together, because this sheriff is willing to step up for us. So there are the sheriffs out there, but they have been trained a different way. They've been taught, like I said, statutes and codes and, bow down to the courts and this and that. They just don't know. So he says, give them the benefit of a doubt and let's start educating them. But, it feels like we're way behind on that, but it's never too late, you guys. We can do this. And the main thing is like Michelle and I and Ron and Mark, we've all been trying to get this common law group together so we can hash this out and finally come up with our master plan. We're also organically, with We the People too, an unbranded website, we're assembling in an organic way. We've got all 50 state groups, and I don't know how many we have on there. Michelle could tell you how many, but yeah, so that's it. I'm sure there's other things that I forgot. I'm sitting here chopping vegetables and stuff. So anyways, I yield. That's, if you have any other questions though, I
You
will.
multitasker, you.
I am, like, I've been dropping off my grandson. I've been to the store. Yeah. Anyhow,
Oh my God,
what-
we're all sitting on our asses.
How in the hell are you not chopping your fingers while you're articulating all this stuff off the top of your head?
I kind of wondered, because my hands are super greasy. I got those Costco chickens. I don't have time to bake the chickens, but yeah, I almost cut my fingers. So yeah.
do
Anyhow,
that. Please.
So I
you
want
guys,
to.
go ahead, Michelle.
I want to interject in here because I was on the phone with Kirk earlier and we did discuss, and Mark Pellegrino just joined in.
Sweet.
We did discuss earlier about the sheriffs, and Kirk,
I was just gonna go there, Michelle. So
all right, well, go ahead. I'll let you go ahead. Take it away.
David, you're probably the closest man I've talked to that grasps the concept of the General Assembly and how this is supposed to be done. And from the same source that I have found, which I found all this stuff prior to meeting them anyways. But the fact is there's no such thing as a constitutional sheriff. The sheriff does not come from the Constitution. It comes before. This is common law jurisdiction.
Mhm.
This is parliamentary practice, the rules of the common law. There's a vast amount of body of law here that is being missed. And what has happened here is the brainwashed and indoctrination of everybody. And this is where it calmed my jets a few years ago when Chris and I started working it. I'm like, wait a minute. If we're gonna admit that everybody's been brainwashed and indoctrinated, and God tells us to have compassion for our fellow man. Even Jesus on the cross says, forgive them, Father, for they know not what they do. I'm like, crap, because I used to be quite the hothead. And if you think I'm a hothead now, imagine me freaking 10 or 15 years ago, let alone just a few years ago. But
I was just gonna say, used to be.
oh yeah, it used to be much worse. It's the Marine in me, right? Because that's the way I would train. You yell at people to get it through to their freaking thick skull. Sorry.
Kind of like the Sicilian in me. Okay, go ahead.
Right? Or Italians. You ever been around some Italian? Tony Pellegrino's an Italian, and I don't know if Mark's Italian. He's got Pellegrino
I'm
name.
Italian.
Oh,
Mark,
yeah.
Mark Pellegrino.
Man, they can get loud. Whew. All
Hey,
right.
forget about it. Forget about it.
Forget about it. Meaning I'll fucking kill you later.
That's right.
Anyways, that's code word for Italian. The thing is back to what David was even saying, and I've said now, is the fact is this comes from the common law. In order to legitimately set this up, blah, 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 blah. I'm not going to go over that again. what I want to point out is that the Trump administration, and this is not just Trump, this is a military coup, right? They were going to do this before Trump. They were going to pull this on Obama at the second term. And they held off because you know what would happen? You want to talk about a civil revolutionary world war dealing with the Satanists? Because that's what the Roman Catholic Church is. And I found that, and I even heard it from a Jesuit himself, and I wish I could find that video again. Clear back to, he was laying it out 4000 BC. I'm like, holy crap, that's way further than I've ever thought of going. But the military has taken over, Trump made amendments to the manual for courts martial. He made amendments to the Uniform Code of Military Justice. He brought back, right, because this is what they changed in 1984. He dug up that executive order from 1984 and said, no, I'm bringing back death by firing squad for treason.
Heck yeah.
Why is Trump out there calling, well, this is treason, this is treason. He was watching our shows. I was laying out the law. Okay. And I got informed by the U.S. Marshals. They were watching our shows. After I found out from my U.S. Marshal friend, after she became a U.S. Marshal, the big boss come down and said, well, yeah, we've been watching his shows for a while. We're learning from him. Holy crap. No, I'm just some Idaho podunk redneck who's watching me. No, for real.
Good.
Because of part of the stuff that we were doing with E-Clause and going to Congress. And, we're the only ones that have been teaching real law. Even a buddy of mine that started help producing the shows the very beginning, he's like, nobody else is teaching this stuff. I'm like, whatever. There's lots of people out there talking now. He's like, no, not like what you guys are doing. I'm like, okay, whatever. So the reality is we have two things going on. We have the deep state cabal, whatever you want to call them. The deep state is the corrupt, evil state of being, right? The human trafficking. So they can cover up their satanic rituals, the child pedophilia ring stuff, okay, which is some of the stuff I was working on in 2019 that's getting me my death threats and what got my partner killed. And then we have the banking, and you can thank Alexander Hamilton for this. He's a traitor, okay? Do some research on Alexander Hamilton. He's the one that pushed the banking crap, and if it wasn't for Alexander Hamilton on his second attempt to bring that in, which is finally he succeeded in the Civil War, we would have won that war. And for those that don't comprehend what that means, the North is not us Americans. That's
Nope.
England again.
Correct.
And England is the one that brought that Civil War in and claiming that it was about rights. Now there's some rights of slaves and about, no. Go read some history, which I have as a homepage for Avalon, is the statutes at large regarding abolishing slavery starting in 1794 and was ended in 1803 and is in the Constitution. The Congress doesn't have the power to make any legislation until after 1803 regarding immigration. We called it immigration back then. Migrating here as slaves, and it was involuntary servitude. But it was voluntary for a contract to come over here, because if you do the real history research, you'll find that it wasn't exactly the way it's purported. Oh, they were buying these people and they were slaves. No, the deal is somebody had to pay for them to be shipped over here. And so the deal is they would be in servitude to somebody that owned land for 3 years, 5 years, or 7 years, whatever the contract was, however much it costs, and they would be in service to them. And at the end of that contract, they would be given a chunk of land. Slavery is not exactly the way it's being portrayed. And then, so how did we have the Civil War and was about slavery, or no, it was about states' rights, and the fact that they extended admiralty jurisdiction on the land by congressional act in 1845. That is what kicked off the Civil War, extending admiralty jurisdiction onto the land.
That, not to interrupt you, but that in the bar.
The bar didn't, well, you can go back to the War of 1812 on that in the original Article the 13th,
Yeah,
which I
right,
have proof of was published in every state constitution clear up into 1819, which it was ratified.
right.
And I've argued with certain bar members about the, oh, well, it wasn't ratified. It wasn't. I said, what was the number of states that were at the time and at the convention? Because now we're talking ex post facto.
Right.
If your state was created after the Constitutional Convention, and this also brings up, wait a minute, why did we have a constitutional convention to make the Article the 13th or 13th Amendment? Wouldn't it have been easier for Congress just to make a statute that says Title 18, if you take a title of nobility, you cease to be a citizen of the United States and you can no longer hold any office of trust? Wait a minute, because that's how we make law. We're not supposed to have statutes.
Mhm.
Well,
We
it's
have
like-
statutes at large, but not like you think, and the way it's purported today, that's fundamentally altering our form of government. But so what's going on is so with these sheriffs and even the members of the legislature, all the other the governors and all that. Okay, this has already been put out. Executive order from Trump about the heads of executive departments about the truth behind Kennedy's assassination. So they all know, and this was clear back in 2018. So they all know, and now they all know they're under admiralty jurisdiction. We're at war, and you better start upholding the Constitution, including all of the federal judges, the ones that Trump nominated and the Senate appointed. We're all instructed by Trump to start upholding the Constitution, because now we're government de jure to a certain extent. We're not government de facto. So we're in limbo, and Trump, acting as commander in chief, is setting up this provisional government. So back to your original question, Luke, on the sheriffs, knowledge is power. We have to educate them. And this is part of what's going on with We the People too. And we're working on a lawful notification letter, which I've already done the 62-pager about the state of emergency and that COVID-19 or orders of quarantine and how that's supposed to work. And the both state and federal law, state of Idaho, which is all code anyway, it's not law. So the only would be legitimate is the United States Code, which is made from a public law. You go look up United States Code, you'll see Pub L, that's public law. Public law applies to public servants. That's about as close as you're going to get to any kind of a, and I hate using codification because that goes back to that Roman civil law. It's enactment of Congress or the legislature, because Congress is made up of who? State representatives. This is under federalism. But the states have all the power, and those are delegates, supposed to be delegates sent for specific purpose. They're not supposed to be meeting, technically speaking, every year, and we make law. No, you do not make law. You make regulations to regulate that which you create, and only applies to that. Back to Hale versus Hinkle. Okay, so this is what we need to comprehend about what's going on, and what we need to do is educate. We have to educate these sheriffs, and when the sheriffs don't do what they're supposed to do, as we instruct them, because they're the highest lawman in the county, and there's no such thing as a law enforcement officer. Doesn't exist. You have a sheriff, and there's supposed to be a sheriff and his one deputy. No armed bodies of men, no standing armies. We're not supposed to have that. It's in the Declaration of Independence. It's in our constitutions. Not supposed to have them armed bodies of men. The only lawful armed body of men is the well-regulated militia, being necessary for the security of a free state, and the right of the people to keep and bear arms shall not be infringed. Because ultimately, the people, even the free inhabitants, every able-bodied male between the age of 18 to 64 is automatically in the unorganized by state or federal militia. Duty bound. Declaration of Independence. We have a duty. It's not just a right, it's a duty to throw off such despotism and institute new guards. The guards would be the sheriff, the governor, not to overthrow the Constitution, not to overthrow our form of government, because we have a very beautiful form. It's just been hijacked and altered. We need to take back our power, and we need to properly assemble the state and county level assemblies. That's where the real power is going to be. And until that happens, we're not going to be back to a true Republican form of government. In the interim, Trump, the military, they're working from the top down. Make no mistake. Again, I was just talking to my U.S. Marshal friend. Shit is going down. You look at Monkey Works, tons of military planes worldwide, but clear all over America. It's happening right now. Military's been activated by Trump worldwide. It's on. You know, talking about that storm that Trump talks about. It's here.
Yeah.
It's happening right now. There are massive arrests going on. Go ahead.
Can you address what you and I discussed about the sheriff's oath? Because we need to put this to a pinpointed solution. So everybody's
Yeah,
on the same page.
Can I say something to you on that? Because that's what I was going to talk about. Rob
Yeah.
Ryder, who is also a common law expert, reached out to me to get through to Sheriff Dar and said he needs to correct his oath. And is that what you were talking about, Michelle? Because,
Yeah. I had this conversation with Kirk earlier. I want Kirk
okay,
to
so,
explain
yep,
everything.
go ahead, Kirkland. Yep, go ahead.
Yeah. So if we're talking about the government de facto, the alleged oath is to the corporation. This is all corporations. And until we dissolve each individual state corporation, they're still bound by all of that. And like we were just saying earlier, well, the sheriffs or whatever, they're all trained about the statutes, the codes. That's right. That's that bar code. It's written by members of the bar. And I've discovered it through Peterson versus Peterson, Idaho Supreme Court, Judge Eisman, 2014. The Idaho Code is not the law. Why is the Idaho Code not the law? Because the Code Commission has no legislative authority. Well, who in the heck is this Code Commission? Well, crap. The governor selects 7 members of the bar to create the board, the Code Commission board, and then they select 3 members of the bar to write the Idaho Code. And it's supposed to be to revise the statutes. But yet, Eisman says, well, it's not a codification of the statutes. It's just merely a compilation. It's prima facie evidence. But I've bought a lot of the Idaho session law books, and all I keep finding in these session law books, clear back to beginning of 1900s, and plus I have several of the very beginning ones in PDF, the first legislative session, second, third, fourth. This is where I'm finding for Idaho, it's perfect timing because we were 1863 with our Organic Act for the Territory of Idaho, written by Congress pursuant to Article 4, Section 3. Congress is the one that sets up the provisional government and delegates the powers, creates, and this is where they're supposed to ensure the Republican form of government by saying, here's your legislative powers, here's your executive powers, here's your judicial powers, here's your jurisdictions, and I'll be darned, right in Section 9 of the Organic Act of the Territory of Idaho, common law jurisdiction. Imagine that. That's a power retained by the people of the states, right? Which is a territory of Idaho, what it says. But we had original legitimate statutes right up until this crap went down with the 1871 Reconstruction. And in 1887, they created the American Bar Association, which is under the International Bar Association, which is under London, the Crown Temple Bar. The bar stands for British Accredited Registrar. Some people say registry, but it's actually a registrar, right? It's a registry, yes. Of what? Foreign agents. And they've hijacked the entire judicial branch. It's behind, there's a member of the bar behind every single executive agency, state, local level, city, it doesn't matter what it is, even Walmart, whatever, there's some freaking bar member sitting there, their legal department, okay? And then they've infiltrated the legislative branch and they've assumed all these powers that belong to the people, and they're the ones sitting there. And what I found, states of emergency. Oh, there's a state of emergency, a state of emergency, state of emergency. Just about every freaking book, there's all something about a state of emergency. And then it says being enacted by the legislature of the state of Idaho to amend the Idaho Code. But the Idaho Code's not the law. How is the legislature making amendments to the Idaho Code when the Idaho Code's not the law? And then you're saying in Peterson versus Peterson, well, it's just a compilation of the statutes. Where's the statutes? Self versus Ray talks about this. The book out there from Charles Wiseman, Authority of Law, coupled with the treatise on arrest and false imprisonment on my website, kirkslawcorner.com. And it talks about there has to be a statute made first. But then what if there's a statute, what do we need the code commission for? That's kind of redundant, and is it? And not only that, the power belongs to the Secretary of State to publish the law. And this goes back to a fundamental principle in the Virginia Declaration of Rights, June 12, 1776. No man or set of men are entitled to separate emoluments or privileges, except for in services to the community. Oh, wait a minute. No set of men entitled to separate emoluments? Separate from those foreign, right? Foreign emoluments. Anyways, yep, sorry. Back to the sheriff and the oath, okay? The fact is that we're deconstructing the reconstruction. So it really doesn't matter about their oath. The fact is they're in that seat. And until things officially get changed back to a de jure Republican form of government where the people are properly assembled, and at the county level, the people are directly electing from the pool of the people, which has to have the jural covenant and oath of office. Got to have that office oath. Got to have that in order to assemble the people to have it completely legitimate.
That's what we're
Well-
doing in the assemblies. That's
Right.
exactly what we're
But
doing.
what do we
Right,
do in
but-
the meantime? We got to
The problem
educate.
is- well,
Go ahead, Robert. Go ahead, Bob.
The problem right now, and I hear what you're saying. The problem is we use the word lawful. Well, to be lawful, you have to be filled with the law, which means the people have to fill you with the law, or you are not lawful.
Mhm.
So the only place that the people speak is in three places: assembly, vote, or jury. Okay, this goes back to the whole premise of a county court, deliberation by jury, declaratory judgment of fact, and they fill you with the law because the jury says, yes, you are lawful, you are that you are, which cannot be reviewed. It is now a general law of fact.
Mhm.
And that's the problem right now. If you don't get a jury to decide that you are a fact, you actually are not a fact, you are an opinion. And this is interesting because today I was actually reading a book called Blackstone's Treatise something. I can't remember. Someone sent me this book. They said, you need to read this. It was like 250 pages. I'm like 120 in the last 12 hours. So in that book, it specifically said exactly what I'm saying. It is only a fact, and it is general law. When the deliberation of the jury comes back at common law, they create a general law in that territory. And that makes you lawful. They have to give you the power, or you have no power. And that's our problem right now. If you can't get the county court, and you can't, and there might be a way to circumvent this in the rules of civil procedure. And the rules of civil procedure are not the common law rules. I hope everybody agrees to that. But the bar did not change the trial by jury rules. It still says in the rules of civil procedure, at least in Florida, that all issues can be deliberated by jury. They actually copy and pasted right out of the common law rules. So then if all issues can be deliberated by jury, why are magistrates, why are judges alone making decisions? And I think that's the argument you take there. Again, this is like the whole thing. And I talked about the political party. They're going to give you something. There's something you can put a hook in. And I just found this a couple days ago. And actually I wrote, so the school board dismissed my case. I wrote a motion for reconsideration. And then I listed all the things that they did that they weren't allowed to do. And then I filed a constitutional challenge to the 1967 Rules of Civil Procedure. Okay.
Nice.
So that's on the table right now. But it is, if you don't get, and this goes back to the premise of opinion versus fact, unless a jury says you are that you are not who you are. You are an opinion of yourself. When I read Blackstone today, I found a part in there where it said you actually could not be emancipated until you petition the court and you actually got a ruling by a jury to become emancipated at the age of 21. If that's true, then that means that I can literally, I'll try and find it and post it exactly where it is. Because it was shocking, because what it actually meant was you hadn't reached the age of majority until the jury that you presented yourself in front of actually made you an adult with rights.
Now, here's the thing on that is that's is Blackstone doing the English, the Perrines Patriae. Okay, that's Blackstone stuff, and that's English. Black's Law Dictionary, Blackstone is from England, and that's the English way of doing things, not the American way, and it doesn't come from the Bible like that. The Bible says once you become of lawful age, emancipation is before you're of lawful age, and you're petitioning a jury of your peers to say, I'm of lawful age now, even though the age number, which used to be 14, now they've moved it to 21 as to be. But see, how do you have people join the military, or men and women join the military at age 18, and then 16, as early as 16, with the consent of the parents? So,
well, because the military is actually a corporation, okay, and it's actually a private mercenary corporation entity that is under the United States of America that was never actually supposed to exist in the first place. So that's one of our biggest problems. We were supposed to be regulated by the militia, and we were never supposed to send our military all over the world, which is a whole nother. And I'm ex-military. I was a private security contractor in Iraq. I spent my time. I was there with TUMEF in Fallujah. So I've spent my time in Marines. I respect the military, and they've been bamboozled like the rest of us.
yes,
We've all been bamboozled in this.
yes, we have.
I still stick to the premise of no man can say who he is. He must put himself in front of the jury for it to become a fact. And this fact part is very powerful. And if I'm right, it means that this is the niche, because we can create a general law that's indisputable just by getting a jury to deliberate it at a county level, right where you live, right in your hometown.
Right. But we already have lots of stuff. And then we got to go back to the laws of nature, which is fundamental, which comes long before government was instituted. So there are certain facts of law. And see, here's what the thing is about the jury. Facts of law and facts of who did what, where, and when. There's the two different types of facts that we're talking about. Now, only if there's a controversy does the jury get to decide that. This goes back to the Declaration of Independence, depriving us of the benefits of a trial by jury. This is one way that we exercise political power, the right to alter, reform, or abolish anything. So when the legislature creates something that's unlawful, the law dictates that that's unlawful. The jury, we would present to the jury the true law, facts of law, and then we would present the statute created by the legislature, and the jury would have the power, has the power to determine the facts of law. What stands on a higher plane? Constitution or statutes? The common law or statutes? Obviously, the common law or the Constitution stands on a higher plane than a statute. Therefore, if a statute comes in conflict with either one of those bodies of law, the jury has the power to nullify that statute, or even a certain part of the Constitution. right? If I can prove that this particular part of the Constitution that went through the proper process, it was voted on, rights can't be put to vote. There's certain things that can't be done in our Republican form of government. That's the difference between a republic and a democracy. But anyway, the jury, I could present that to the jury, and the jury can abolish something from the Constitution, because that's the power of the jury. So it's
Yeah.
not so much as determining facts of I am man, creation of God, because those are already facts, and that goes in my notice
Well-
of special appearance. Somebody
well-
has to rebut that in order to create the controversy.
But that's actually the kicker. They are rebutting it. They're actually saying that we are legal entities. So if you get a jury,
Where does it say that?
Well, I mean, I have a friend who just showed me a court order that literally says that the person who got called into court is a legal entity. That's why they're disregarding everyone's rights. So if you get a jury to determine you in fact are a person with rights under the Bill of Rights, then it becomes a fact because the jury said it was a fact. So then, and that refutes their whole thing. Here's something else. If these facts are the way that they're written, and again, this is theory, so then could we actually define the word person by fact? So then I've been working on a definition, because this case where I brought it in front of, I'm taking it to the people, right? To have all these stupid questions answered about who my mom was, who my dad was, and all this. So I'm going to, if I can get a jury in the room, they don't know it's coming, I'm going to file a motion to define an actual person as it's stated in the Constitution. And the best definition I can come up with is a carbon dioxide exhaling, fleshly sleeved biped. Oh, wait a minute. Carbon dioxide exhaling, single entity, corporeal entity, featherless biped with the ability to communicate thoughts and ideas through a medium of linguistic exchange, do a two-step math problem of multiplication, division, addition, subtraction, and participate in a conversation of opinion or thought to determine a reasonable fact.
Let me show you something.
So
Let me show you something about person. I'll just use this one. This is avalon.law.edu, where I have done a lot of my research from. English Bill of Rights of 1689. Watch this. This will help you comprehend what I was saying before about in propria persona. This is where it comes from. This is how it's done. Right here. Whereas the Lord spiritual and temporal and commons assembled at Westminster lawfully, fully and freely representing. Lawfully means full of law.
yes,
We already have facts of law declared, laid down, ordained, and established. So we don't need to have a jury declare that those are facts when it's already in writing. All the estates of the people of this realm did upon the 13th day of February in the year of our Lord, then called, now pay attention right here, then called and known by the names and style of William and Mary, Prince and Princess of Orange, being present in their proper persons. In propria persona, in their proper person. Okay, so we have man, name, is William. Why isn't there a last name? Because that's a family name. It's not actual the name of the man. Or woman, Mary. Prince and princess is the persons. Again, these are fictions. These are things that are made up by man. This isn't made by God. Governor is a person. Lieutenant governor is a person. It's a personality, a personificance. They have to act out. When we look at the word government, a lot of people misconstrue this. Oh yeah, it's mind control. That's right. The people create the Constitution. That's the instrument of government. We control the minds of the man, known by the names of William and Mary, acting as governor or prince and princess. We control the emoluments of that office, the mind control. They can only act out the duties that we dictate by the Constitution, not from a statute, because that power it doesn't follow due process of law. Enactments of the legislature are not sent to the people for ratification. Therefore, it's not law. It's not law of the land. If you look up,
Well, it's their law.
but it's
For
not
them.
law. See,
Right.
this is where we got to comprehend the clear distinction between what is actual law and what is policy
Mhm.
or regulations. Okay, Hale versus Hinkle.
So, and let me give an example. I have a 110-pound Great Dane. Okay, and she's my friend, and I love her to death. But when she gets out of line, I grab a hold of her and I put her in her place. If we don't have a system to grab a hold of the beast and put it in its place, that 110-pound Great Dane gets really dangerous really fast. And if that 110-pound Great Dane decides you're not a person, you're an entity, or you're food, and you can't grab a hold of that thing's neck and put it in its place, you are no longer a person.
Yeah,
And that's the premise that I'm working off of. They are telling us we are nothing. They are telling us we have rights, but then when we try to exercise them, they don't exist. What
Yeah.
do we have to say they exist? And how do we grab a hold of the beast? I rest.
we have a system, it's lawful, it's in place, or it's getting in place. The problem is, as we talked earlier today, Kurt and I both talked about it, it's education. We got to get the people educated. They have spent 100 years taking away civil rights and civil understanding and civil education away from our people. And now our third, fourth, fifth generations are ignorant of the facts. So we, through the assemblies or whatever mechanism you want to work with, we need to bring and institute this education. The stuff we talked about today, the average person doesn't have a clue about. They're not even a smidgen of an idea of what we're talking about, yet everything we spoke about today is a fact. It's truth. But the tools, we have the tools, we have the arrows in our quiver. We just need to implement it. But how do we implement it? We got to educate the masses. They got to come up to speed. Somehow we got to find a solution to that.
Well, that's why, let me interject here for a second. That's why I was saying, like, starting today, like right now, this all needs to go down now, where we educate our youngsters, you know, because they're in there teaching our kids how to be a racist, gay communist right now. That's literally what they're teaching our kids today.
Yeah.
So
I hate to laugh.
what we got to do is, yeah, I didn't mean that, but that's actually what they're doing, you know?
That's the truth.
I agree.
Amen.
Yeah.
Yeah,
So
I
in our schools, we start in our schools, and all this needs to be happening simultaneously. We build the assemblies, we do the grand jury, we implement this stuff into the schools, so that way 5 years from now, our kids aren't learning how to be a racist gay communist, but they're learning about the republic for which it stands.
Well,
You know, because right now they're learning nothing about it.
if I may, one of the things that I'm trying to do in the assemblies that I have oversight over is to gang up. Like the lowest hanging fruit right now are the school boards. And you target the school boards and you bring 7, 8, 9 lawful affidavits to them in a 3-step process. And you know, they're done, they're cooked. And you remove them from office. And like Hamilton County, the Committee of Safety in Hamilton County, they put up 4 of the county people to run for the school board of this one school district, and they instituted these 4 guys. They got them elected on the school board. The first thing they did was eliminate the mask and the mandatory jab. Second thing they did was they took the money that was given by Biden and returned it back to Washington. The third thing they did was they eliminated critical race theory, theory. And when they did that, then the teachers union came and attacked them for removing critical race theory. I'm like, are you freaking kidding me? So they came to me and asked me what was the next step. And I said, dissolve the corporation. Dissolve the corporation. Go back to a republic school district. Tell the state of Ohio to go screw, go screw.
You mean put the schools back in the churches where they belong and
Yeah, exactly.
go back to the Constitution where it says, we can do public school education for what? Useful arts and science. This is supposed to be higher education for useful arts, as in not like painting, architecture. That's what the Constitution dictates as a subject matter.
So
Our government is not supposed to be providing public school education for K through 12. That's supposed to be done through the church.
Right.
so
Yeah, I know.
And this, I just post this thing on the text, right? I've been sending these out. There's 40 people that get these. Okay, so this was the hearing from August 3rd. I've been on the Google Drive. There's 38 documents at this point. This attorney who's representing the school. Now, this was to take out, it was to do 3 things. 1, get an injunction to remove a list of books. 2, get a writ from the sheriff to have the sheriff seize the books so that they could be examined. And then they were going to be put in front of a jury to determine if they were acceptable for public, acceptable for private. And 3, to get an authorization from the jury to present the evidence in front of a grand jury. That's what I asked for. Those 3 things. Okay. This is the hearing where I got dismissed. The attorney literally says, it certainly requires more than wickedness, slavery, and evil, as the judge dismissed the case, refusing my right. I demanded 7 times, and you'll find a thing in there where I filed my motion for reconsideration. I literally listed every time that I filed demanding a jury was absolutely refused. Okay. What I've figured out is, or what I think, and I'm pretty sure I'm right, these declaratory judgments of fact, because they become general law, if you want your kids in your county to learn cursive, just go get a declaratory judgment of fact. If the jury says, yeah, they're going to learn cursive, they learn cursive. That's the end. That's the law. That's the general law, common law. That's the law of the county from that point forward. If you don't want critical race theory, you get a declaratory judgment of fact. No more critical race theory. We don't care what the state does. You guys do whatever you want. Thanks for the recommendation. Move along. If you don't want federal agents or state agents operating in your county, you get a declaratory judgment of fact that everybody has to check in with the sheriff, and they have to get a court order before they're allowed to exercise anything in your county. And guess what? You now have a law, which means the militia can be mobilized and you can do anything. These declaratory judgments make general law in your county, but it has to be done by a jury.
But why would I need a declaratory judgment for something that's already the law?
Because they're not obeying the law. They're ignoring it.
And you're not
now
answering the question. That's redundant. Okay. Go into the judicial branch, which, again, we the people establish justice, not the judicial branch. And see, this is what we
we're
need to
not even the
comprehend about
people.
our Republican form of government. The judicial branch does not have the power to make law. That's a monarchy. We're not a monarchy here. We go by the rule of law. Laws of nature, morals, and principles dictate the rule of law. I don't need a declaratory judgment to say that I am man. I do not need a declaratory judgment that says we're not supposed to be teaching immorality in school. It's already in our Idaho Constitution. Okay, it's already the law of the land, and it's already fundamental law. So you're still speaking like a member of the bar that you got to go to the judicial branch. That's not how our Republican form of government works.
I never said judicial branch. I said
You said go to
have-
the court. That's the judicial
No,
branch.
No, I said you go to the people, but the people only speak in 3
But the
places.
people don't exist.
Well, what do you mean the people don't exist?
They do.
The
if they
voters-
assemble,
Where's the
they
General
vote.
Assembly? I want to
They
see
do if
your
they
jural
assemble.
covenant and office of oath.
But we
I
don't
want to
have
see
any-
your numbers
We
of
don't
the
have any
men.
assemblies. We don't have any assemblies.
Ah,
because
so you
we
don't
haven't-
have the people.
Well, don't the people vote?
No.
The people don't vote? No one casts their vote?
You're
only have
talking about the
elected
de facto.
Well,
Right, that's correct.
so the voter registration cards are attached to a trust.
That's government de facto. That's the
Well,
bar
I-
government.
I just asked if the voter registration cards are attached to a trust.
Okay, sure.
Well, they're not. They're not attached to a trust. They're actually the only form of identification that we get that is not attached to any form of commerce or any form of equity is our actual voter registration card.
Yeah, but they
Which
hold you to your US status with the voter registration, which is part of the de facto.
Right. You're see, this is the problem. It's a facsimile. They're trying to replicate our Republican form of government. And the fact is to be a qualified elector, not
Right.
vote and voter.
But you can't be an elector unless you get the people to say,
No,
You
No,
can
no, no. That's
represent
what
me.
makes you
No,
one of the
not
people
true.
is a qualified elector.
well, who told you you're allowed
You-
to be an elector?
you
It's right in our
become-
it's
okay,
right in our founding documents.
But what
Robert,
makes
Robert.
one person elector and one person not?
Robert, when you
The difference
join the
between a
assembly,
jural
when you
covenant
join-
and an oath.
Kurt, let me,
Sure, Dave, go ahead.
when you join the assembly and you become a member of the assembly, you become an elector. Now, if you are a member of the assembly and you run for office and you get elected, you have to remove yourself as an elector. And you are out as elector for 1 year after you leave office. Then you can come back into the assembly as one of the party or one of the people of the assembly. You guys got to learn this assembly apparatus. This is before this country was ever created. This
I-
is the secret that they don't want you to know.
That's
Well,
it.
I agree with that. I agree with everything you said. My only question is, who gave the assembly that you formed the power of law?
God did.
Well, so that means the Crips and the Bloods get together and they say, well, we're a lawful assembly, so
No,
we're in charge.
No, no.
Wait a
Don't
minute,
work
wait
a
that
minute.
way. Don't work
That's
that
not
way.
see
Well, I
there
don't agree
again.
with that.
That's
I
not
don't-
how that works.
Well,
See,
I don't, but then who tells an assembly they are filled with the power of law? To
because they do a
enforce?
covenant unto God. It's a covenant unto God to say, I'm going to uphold God's law. And then you turn to your fellow man and say, I'm going to take an oath, because there's no firmer bond among men than an oath. I'm going to take an oath with everybody here to my fellow man. Again, fellow man, right? Not the people. My fellow man, that I will uphold God's law and I will defend your rights. Okay. And then that, once you do that document, now you become one of the people. Now you qualify to run as any kind of office as long as you meet the requirements of that. Some of it is you got to own a certain amount of land. Because see, all this bond crap is
Backed by
bullshit.
land. It's supposed to be backed by land.
Supposed to be backed by land so that we could do a tort claim, right? Civil asset forfeiture, and we come and take your land because that's the only asset you got, which is why it has to be assessed for property taxes. And that's the only real taxes we're supposed to be paying, not the improvements on the land. And then if I sue you at common law and now I'd say $250,000 in damage, and your land is only worth 200,000, I can come take your land, and this is how they exiled bad actors out of their cities and towns and counties. Is they
Right.
come in and seized the land. Now you're no longer as a qualified elector, and in some cases, they literally came in and burnt the house down while they had you down there at the courthouse or down there tied up. Okay.
Well, I
You
mean,
need to
I'm-
read
I'm-
read a little more about history and how this stuff is supposed to work and how our Republican form of government legitimately is supposed to be.
Well, here's my question. You just said you're gonna sue them. That means you gotta go back to the courts.
No,
Where do you sue
the
'em?
court is the
No, no,
paperwork. See,
no,
you're
no,
missing.
but-
You're thinking that a court is a building.
No,
Right.
no,
The court is
listen,
paperwork.
I know what a court is, but paperwork is held with the exchequer, who is the clerk of court. He is the keeper of the record. He is the
No.
treasurer. He holds the record. He actually keeps the recording of all deeds, all marriage licenses, all public records.
That's all.
That would be
He
the
holds
county.
the
That would be
key.
the county recorder.
That's
That would
a
be
fraud.
the
It's
clerk
all
of court.
fraud.
You see,
Okay.
you're talking about the government de facto corporation.
Okay,
Right.
well,
You're
then-
reading from
then-
their code.
where do you sue from?
You
Suit
sue
at
from the
common law.
people's court.
But where is the
The
record
Court of
held?
Justice.
Where's that?
In the
court?
legislature, the General Assembly, the
So-
General Court, where you
Right.
have a grand jury and you get a grand jury indictment. And guess what? Wisconsin Constitution, Article 1, Section 21. This is a declaration of rights. Rights of suitors. We have the right to prosecute our own claims.
Have we
Right.
prosecuted our own claims?
A prosecuting attorney,
Have we prosecuted our
a
own claims?
defense lawyer,
Well,
has nothing to do
attorneys
with
are
the bar.
members.
has
Attorneys
nothing
are
to do
bar
with the bar.
members. Attorneys are bar members.
No,
Lawyers aren't bar members, but attorneys are.
No. That's where
No?
you're mistaken. Attorney is to attorn ye, to take from one man and give to another. We have the right, okay, if you run into my fence, I have the right to attorn you. If it costs me $750 to fix my fence, I have the right to attorn you for $750. I have the right to prosecute you and get consent from the jury to take $750 worth of your property to
But now you're-
satisfy the debt that
But
you
now
owe
you're
me.
saying that you're going to prosecute, which means you got to go back to a court.
No.
No, the paperwork is
I
the
don't-
court. I serve
But-
you notice and
You can serve the
demand
notice.
you pay me
You're stuck in a
$750 to
building,
fix my
Robert.
I
fence.
can't. But if I take a position of defense, we have to have deliberation, and then
Bingo.
we have to go in front of a jury.
That's right.
but
In front of a
again-
jury.
But again, where is the court?
The
You're on
paperwork.
the street
The
corner.
paperwork
At the
doesn't have-
church, down on the street corner, in my front yard, in your front yard.
Churches are 501c3s.
No. I'm talking common law. You're talking de
Okay.
facto. I'm talking
I don't-
real law, de jure, not
If-
government de facto.
If you can't, I don't understand how you're going to prosecute someone and use a judicial procedure and not be in a court. Number
See,
one.
you don't understand the
Number
common
two,
law.
Well, because I'm confused
Okay.
as to
Here-
who
Let me
holds
explain
the
it real
record,
quick.
Who
You run into
collects-
my fence and you cause $750 damage to my fence. Okay. I'm going to tell you in notice, because that's the first step of due process of law. And then I'm going to put it in writing, because that's the way it's supposed to be done. You give notice in writing. That's part of being sui juris, of lawful age, of sound mind, and perfectly capable of handling your administrative duties. And I have to follow this process that's due to you as a man, because I'm bound by God's law, who tells me I'm supposed to go to you and try to talk to you about this. Okay. And then you want to say, oh, screw you. No. And I go get two men and we come back. Well, who would that two men be in our common law system?
Assembly.
Wouldn't that be the sheriff and the prosecutor?
Can
Well,
be.
then, but then
Could
why?
be,
isn't it-
unless I
why-
choose to prosecute myself.
So then,
But-
how
Could
are you
also
going
be
to
the
get the
moderator
sheriff?
and the scribe of the assembly.
So right now, there's people all over this country going to prosecutors, going to sheriffs who actually work for the court, and they're not coming back. In fact, what the deputies are telling you is it's a civil matter. Take care of it there. So there's no one that can prosecute. There's no one that can give you
That's-
justice. There's no,
Okay.
I mean, none of
That's
this.
the
But you're
lack of
talking
education
government-
of the general masses. That's
We're
what-
talking
You're
in
talking about
general.
government
It
de facto.
doesn't
We're talking
exist.
government de jure, legitimate government.
And Robert, as long as you feel that way, nothing's gonna change.
Bingo.
I think the big question is, how do we get our society as a mechanism to enforce common law? I mean, is that, I'm kind of trying to read between the lines
Education.
and read the tea leaves here, but how do we get our society to recognize it and the people with the power of law enforcement to recognize it, enforce it, acknowledge it, and to abide by it?
You do what I do and you file paperwork.
All right.
And when they don't respond, there's no objection. Guess what? That's a default judgment.
Then where do you get paid at?
Oh, you want to talk about getting paid? A tort claim?
You still have
Yeah.
to go into a court.
Nope. No, sir. You want to play this de facto game shit? All right, let me tell you about tort claims. Okay, this is administrative process. I give you 3 notices and the opportunity to rebut and pay the debt that you owe me. That's $750. Okay, you want to play this de facto shit? It's called a UCC 1 filed. We'll stop with UCC 1 for a second. First of all, you have to put the Secretary of State on notice. Okay, and then I give you notice, and you have 30 days to respond and rebut. And if you don't respond and rebut, I'm going to give you a second notice and give you another 30 days. And if you don't respond, rebut, and pay or make arrangements to pay, I give you another 30 days. After 90 days, I go do what's called a UCC4, which is a title search for everything that you've registered in title. You see, this is how all the trust stuff works. You want to play this game? I'll take your shit. Our UCC4, I do a search for, oh, your house is in your name. I don't care if your mortgage is paid or not. That's irrelevant. That's what you own, your land. Okay. Any cars, boats, bicycles, motorcycles, any toys you think you got in title, I do a UCC4 search for that. I do a UCC1 and I lay claim to all that and transfer your shit to me. And then I do a writ of execution to the sheriff through the common law. And me and the sheriff come over to your house, and the sheriff physically will remove you from my property. As I'm showing the paperwork, that title has been transferred to me. I am now the new owner. Get out of my property. No court is involved in that.
Well,
That
where
is
do-
all
well,
paperwork.
Then who executed the writ?
The sheriff.
No, sheriffs don't execute writs. Sheriffs receive writs.
We're talking
court-
common law. That's
we're-
my writ of execution.
So where is this court at? I want to find one. I want to go
The
see it.
paperwork is your court of record.
Puppy.
You don't grasp the concept of paperwork.
I have a question.
Okay.
You're crossing
confused.
over to de facto with the UCC. How come?
I actually agree with that.
That's what I said. If you want to go that route. So I'm explaining to you how they do this and have subverted the common law.
Oh,
They're
okay.
using the Uniform Commercial Code and how it's done right now, which you can still do because that's how it's set up. Or we can go back to the common law way, which again, I give you notice.
But wait a minute. You said you went to the UCC and then you got a writ, but the writ has to be sealed by the clerk of court because he carries the seal to actually execute the writ. And if you've ever done a summons, when you file a petition, you have to take it in. Well, I have a digital, so I upload it. And then I have to get my summons. I have to write up my summons, commanding the sheriff. It says you are commanded to all sheriffs in the state of Florida to issue this summons. And then I have to take that summons. I have to take it down to the clerk of court. I have to pay $10. They staple my petition and my summons together, and they stamp it with the county.
But
Or
see,
with the,
this doesn't go
county
through
seal.
that process. That paperwork doesn't, I don't give them
the
jurisdiction.
sheriff is not going to execute a summons or a
But
writ.
no, there is no summons. You're missing it, dude.
I said, or a writ. Writ summons.
No, a writ of
subpoena,
execution is after judgment.
Right, but you have to get the seal.
No, I perfect
Put
the
on it.
judgment. This is still the common law. This is the remedy and relief through tort claims
But
through
all
the UCC
all
because
the-
everything has been put in trust. Everything is titled. Your car.
but all the books all the common law forms that I have that I got from Tallahassee, they all have seals on them. See, like there's 3 sets of seals. So they have to, somebody has to seal those. Who carries those seals?
We're supposed to
who-
actually have
who-
our own seal.
Who are the 3 seals that have to go on those common law documents? Because I know mine's 1.
Right,
know-
but
I
I
know
don't,
that I have
no,
one.
if we're
So then
talking
who
common
are the
law
other-
and tort claims,
We're talking common law, not tort.
that doesn't belong to them.
Common law
I
is-
don't
is
need their permission
property,
to attorn you.
but who carries the seals to execute the documents?
I don't need them. I don't need those documents. That's not how it's done.
I've been messing around courts for 20 years. I've commanded sheriffs to issue summonses repeatedly.
Okay,
I've
but
done
this
it
isn't a
repeatedly.
summons.
Well, summons, writs,
You're,
and subpoenas
this is a
are all the
tort
same thing.
claim, common law.
Common law
I
is not
give you
tort.
notice.
Common
You
law is
got 30
property.
days to respond,
on.
rebut, or pay.
Common law means, wait a minute, tort means torture. That's injury.
Really?
Common law works in property, right? So you can't hurt anybody and you can't damage their property.
Right.
So tort means torture, which means injury, which means equity, which means money. So I'm confused because in every system, common law only operates in flesh suffering or property deprivation or destruction.
It's called a common law
So then
trespass
Why are we talking about tort? Which
because
is-
that's what a tort is a common law trespass.
But torts are
Yeah,
not
you
common
run
law.
into my fence, you cause damage to my property. I have
That's
the
not
right to
tort.
attorn you. That's a
No,
tort.
That's
That's a
not
tort claim.
Tort is
You're the tort, you become the tort feeser.
tort is where punitive damages comes from, and tort is equity, money reparation
No.
for injury.
No, and I've already proved this and shown this. Tort claims come from the common law, is a common law trespass, and we go by the rules of the common law.
Well, we're not going by any
Not
rules.
in any courts of the United States. See the 7th Amendment again. This doesn't get heard in any courts of the United States.
So where does it get heard then? Who is doing
On
it?
paper between me and you. This is a suit between man and man,
So then who does
not
the
a government
deliberation?
created court.
Who does the deliberation?
There is no deliberation.
Who receives the
I claim
arguments?
that you did this.
Well, that's a
Can
claim.
you
it's an
rebut that?
opinion. I object and I dispute. I say no. Where do we go?
You have to put it in writing.
Fine, that's fine. I'm happy to write, but I'm still asking when we don't agree and we're in controversy,
Mhm.
where do we go to determine who's right and who's wrong?
That's
Where are
that
we going?
suits at common law, and we have the right to a trial by jury.
Okay,
So-
where are we going to this trial? Now that we don't agree and we're at common law, where are we going? What's the place that we're going to walk into and we're actually going to
There-
stand there?
That's the thing.
And
There
we're
is no
gonna-
place. You're not grasping the concept of common law. It's out in the streets. It's in my front yard.
Well, then who does the deliberation?
You and I. That's it. There's no
So just-
member of the bar there. The bar doesn't exist in
never-
our
I never said
Republican
bar.
form of government.
I never said bar. I asked for a place because the court was actually the courtyard in the middle, and that's where the court was, where controversies were dealt with. And then they built buildings around it, and they made a bench, and they made the box, and they
They
made
were at the churches.
gallery, and they called it the bar when you cross onto the court.
Yeah,
That,
That's
okay,
the
so
that
became-
monarchy bullshit again.
Well, no,
okay?
that's
We're-
not, that's
we're
actually
back to
how
the way it
the
was,
court is
where
structured.
we handled our private business in the private at church.
Right, but no man can be the judge of his own cause. So if you don't agree with me and I don't agree with you,
Yeah.
who determines who's yes or no?
That's the jury.
Well, then, but you just said it was just me and you.
You said deliberate. Who
Well, I mean-
deliberates? Me
Well,
and
I
you.
said- So who are we going to present arguments to?
To the jury.
Where's the jury go? Where is this jury right now?
From
Right
the
here in United
church.
States. So we go down to United
That's supposed to
Methodist
be part of
Church
the
down
General
road.
Assembly, and that's already supposed to be assembled.
So then we don't have anything.
Bingo.
So we have nothing.
Bingo.
It's all gone.
It's all gone.
It's all gone.
All those seats, and they've said it before, all those seats are vacant. That's government de jure. Those seats are vacant. And until man gets properly organized, which is the first fundamental primitive laws of nature, Go look it up in Bouvet's Law Dictionary, 1856, Laws of Nature. When man is properly organized, he knows the difference between moral good and moral evil. Properly organized. That's us getting organized. We come together. We
But
make a covenant and an
but I-
oath.
But I thought the Bill of Rights was individual rights. Why do I need a bunch of other people?
Yeah. What's an individual? An individual is a member of a person.
Yeah, me, like I'm an individual. I'm one.
No, you're no. That's not what the word individual. That's a commercial term. You are man. That's it.
Actually, the Constitution doesn't say man.
That's because the Constitution isn't for us. It's for them.
Actually, the preamble is the people, and the 10th Amendment of the Bill of Rights says the people. That
Uh-huh.
makes it a book, and everything in the middle binds them. But we are the Alpha and we are the Omega, because it starts with we
No.
the people and it ends with the people. So that means the people are first, the
Mhm.
people are last, and everything in the middle is to bind them in. So the Constitution is for us.
No,
You're-
the people are not bound by the Constitution. Article
That's not what I
6,
said.
Clause 3.
You didn't listen to what I said. We are the beginning, the Alpha, and we are the Omega of the Constitution.
Right,
All
we're the
things
sovereign
not-
body politic that creates the instrument of government.
Okay. But then we got a Bill of Rights that are for each individual human being,
No,
person.
no.
So the
no.
Bill of Rights are for groups?
The Bill of Rights are for the public servants who take an oath to ensure that their rights are not being violated. Our rights don't come from a Bill of Rights. They come from God. They're natural, God-given rights, unalienable rights.
So when you go to argue with a public officer agent, your response to them when you try to enforce something is, I have God-given rights. I don't need anything else.
That's right. What part of that do you not comprehend?
Well, I don't understand, because I swear that Patrick Henry and Thomas Paine said, we don't just need the preamble, because in Federalist Paper 84, Alexander Hamilton said they don't need a Bill of Rights. They have a preamble. And James Monroe to the Virginia Ratifying Convention said the preamble is the key to the Constitution. Thomas Paine, Patrick
Okay.
Henry,
Uh-huh.
and James Monroe, James Madison
James Madison. Mhm.
didn't even sign the Constitution. Okay. But they demanded through the Anti-Federalist Papers that the Bill of Rights was written down for each individual person, because the preamble wasn't enough.
You don't
now
even
you-
understand the words you're using.
I
Kirk,
believe
Kirk is if I understand correctly, are you saying that everything in the Constitution, the Bill of Rights, is written for maritime law?
It's for admiralty.
For admiralty law, excuse me, yeah.
Yes, it is for the servants, for the citizens, those that are bound by it. That essentially, the Constitution is the terms and conditions, a contract of employment. That's what that is. Well, some people call it a social compact. It's a contract of employment. See, government, to govern the mind of, to govern the mind of, or control the mind of president, to control or govern the mind of the legislators or Congress, to govern the control the mind of the governor, the lieutenant governor. It enumerates certain powers. Declaration of Independence, that to secure these rights, governments are instituted among men, not persons, receiving their just powers under the consent of the governed. Not everybody is governed by Constitution. And in fact, we have our Title 74, subsection 201, ethics in government here. The people of the state of Idaho, in creating the instruments of government that serve them, do not yield their sovereignty to the agency so created.
but you can't enforce it. So it doesn't mean anything. It's
Yes,
just
I most
words.
certainly can. You got to know how to claim and exercise your rights.
So you've enforced that, and you've gone down to the building, whatever building, and you walked in and you grabbed a hold of somebody and you took them out and you put them in jail for their bad behavior. Yes or no?
Me personally, no.
Why
But
not?
I have had a judge and a prosecutor arrested within 5 days of filing a public corruption complaint. It
Okay.
took a year to shut
I mean-
down the entire magistrate division of Ector County, Texas,
But
and over
but
1,250
but
cases
if it was
scheduled for
this
dismissal.
easy, it'd be happening everywhere, and it's not happening.
That's because nobody has this knowledge. And nobody's claiming and
Education.
exercising this right to petition the legislature for the redress of grievances. Nobody's exercising the right to file criminal complaints because they don't know how to do it. Because they don't know the law. They don't know the instrument of government that serves them. They don't know how to instruct their public servants.
Can I interject for a second?
Absolutely.
Mark
Although I love the
Pellegrino,
debate.
Mark Pellegrino, you still on the line?
Yeah, I'm still here.
Ma'am. All right, Kirk, Mark found out something, and this is regarding to the criminal complaint. He found out the other day about Michigan's task force, the special task force. Mark, you want to tell Kirk what you had found out? Because David on the line has been having feedback from issues of other states not being able to find that task force. So go ahead, Mark.
Well, I mean, a lot of the information I got from Kurt, but I mean, I did a bunch of my own research, and then I spent about almost 2 hours. All right, let's say I have a complaint. I filed an affidavit, and I made, you do your what's it called there? Your lawful notice and letter of, what's the other part there? Yeah, let me pull it up here.
Letter of liability.
Yeah, the letter of liability. So you got your lawful notice and letter of liability, then you make them aware of, So this is what you did, and this is what the repercussions are. And then once that falls on deaf ears, which it always will, because, they don't have to respond to the useless eaters. So then that becomes a tacit agreement. Then you go fill out that A091 form and staple your tacit agreement to it now. And now that's the only law in the room now. And then you file that with the task force AG, which that executive order was basically telling the AG of each state that they've got to go to their Department of Justice and set up this de jure task force that specifically handles this market integrity and consumer fraud. And then it's out of your hands. And according to what Kurt's saying, it takes 30 days, 60 days before they even respond to it. So, but once it's in their hands, you just took it out of the lower courts and put it in the executive branch, and it's all military tribunal after that.
Mm-hmm.
So we're putting together a process right now, so that way everybody. The only thing is, I'm trying to keep it more onto the federal side, because on the state side, everybody's codes are a little bit different, So you try. It's harder to mirror it and make a cookie cutter thing, so that way somebody just go, okay, here's the form, you fill it out and do this, do that, and send it in, and then it kind of all works. So if you're using federal codes, which they're all in violation of state, federal, and international. I mean, every code, they're all in violation of all of it. I mean, we all know that, but I mean, and there's so many codes out there that you can put on the actual complaint that you can fill that box up 10 times over with all the crap these people are doing. Because if they're conducting a criminal activity while they're being paid by a citizen, there's another code violation right there. So I'm trying to get to a process. Donna and I were working on a process, so that way you just go straight through it, and make it for dummies, so everybody can just start prosecuting all these people. I'm right now, currently, I'm going to do it on the health department head here, right here in Eaton County. They just took our county from nothing going on to red alert now. So we're in the red alert. I walk in the bank next door and they're all wearing masks. Right now, they're all wearing masks. And I said, what are you guys doing wearing masks? They did this to you again. And so I want to go here and shut down this this health department here. And that is not only for, ironically, it's not only for Eaton County, but it's also for Berry County, which is where DAR is at, you know? So Berry County and Eaton County Health Department is right here in Charlotte. And then I think they've got another one that they just opened up in actual Berry County, but we were the main health department for them forever. And they came here, shut down a bunch of businesses, you know, did this mass bullshit and injecting poison into our citizens and the whole 9 yards. So and my whole premise behind this is to build up some confidence for people like DAR, you know, and he's got all these people coming at him and nobody knows how to fill out this. Everybody still on there?
Yeah.
All right. Because I was getting another call on there from there. Oh, it looks like Andrew's trying to call me, but I'll just get back with him later.
Right, but Mark, you were having a runaround as far as the task force is involved. I want you to.
Yeah, the task force.
Yeah.
I was thinking it would be here in Lansing, and so I got shuffled around for no less than an hour and a half to 2 hours, and finally ended up in Detroit, and at the AG there, because I guess that's where it's all running out of. And then I said, look, to file a criminal complaint for the market integrity consumer fraud, is this the department I'm doing it in? This the task force that consists of, you know, the all the people that were mentioned in there, which is an AG of like, I mean, there was like, let me pull it up here.
It's a assistant district attorney.
That's correct. That is the one that holds the first chair. And then here, I got it right here, so give me a second.
Then you got criminal division, civil division.
Yeah, so here's what happens. The attorney general goes to their DOJ, and they have a deputy attorney general who serves as the first chair. Then associate attorney general serves as the vice chair. Then these are all assistant attorney generals. You got criminal division, civil division, tax division, and antitrust. Then you got a director from the Federal Bureau, from the FBI, and then and now all those people comprise the task force there. And then from time to time, and I'm guessing it's dependent on how high the profile of the person is, other people can sit in from time to time, such as the Secretary of State, the Secretary of Defense, the Secretary of Human Health and Services, Housing and Urban Development, Secretary of Energy, Secretary of Education, Veteran Affairs, Homeland Security, Administrator of Small Business. I mean, the list goes on and on about all the people that can sit in them chairs. That sit in from time to time. But the task force only consists of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 people, it looks like. And like I said, I got shuffled around, and from what they were saying, that we actually had to submit the paperwork, which I was told from the lady from the AG department in Detroit. You just go to michigan.gov/AG and click on file complaint, and they have all these little fields that you can fill in and copy and paste this and put forms in there. But my thing is, I would actually do that. I was going to add to that certified mail, priority mail with tracking, an email, a fax, walk in there and hand for it and get their timestamp right on there, so that there's more than one in there, because depending on how, I don't know, I just don't trust anybody in government, man. I have a hard time all the way around because of all this crap we're going through. I mean, who do you trust?
Right, so the whole reason, I'm sorry, the whole reason why I'm having him describe this to you, Robert and Luke, this is exactly what Kirk had stumbled upon, helping that woman in Ohio which caused the arrest after 5 days of filing these complaints for the judge and the prosecutor, which also circumvents going through any court. Because this is through the executive branch. So you submit it and you forget it, and then you wait and see what happens.
And that's how you hold your public officials accountable, and you keep them in line. And then after you get that, if they go after them and they find them, and they convict them, then you could go after their bonds. You can actually get money from their bonds. You can't do it without an indictment, though.
Well, I don't know about that because Rick has gone after bonds in the past.
No. See, this doesn't go through the indictment process. Attorney General Barr already talked about this and said, look, the president is going to start exercising powers that properly belong to the executive branch. What does Congress have the power to create? Military tribunals. Those are those courts of the United States. Okay, this is under admiralty jurisdiction, like I explained earlier. They're all under admiralty jurisdiction because they're bound by it. Okay, this is admiralty process or administrative, like some people like to call it. But no, this is military, right? This is military tribunals. This is martial law, admiralty jurisdiction, commander-in-chief. This is what Trump has set up for us to use. This is back to Texas v. White. The president has this power to set up provisional government. Okay, we're dealing with serious human rights abuse and corruption.
So they're going to be going down for treason then.
Whatever you put in your criminal complaint.
Well, if they're going against
Yeah, that's what you need to do. You need to put in treason. They have violated their oaths of office. That's treason.
Yeah.
And still, they were bound by their oath, and they're bound, and then their bond is what's supposed to be for us to get back, our torts,
This is the problem with the bonds. See, the insurance can only cover accidents. They cannot cover willful misconduct. This is where you go back to suing them if what they've provided for us right now is Title 42, 1983 and criminal complaints. That's the punitive damages that's listed in Title 18, subsection 3571. If it's not listed under the 18 USC, here, I'll just show you real quick. Oops. I moved stuff around. I'll show you this real quick, the civil rights section that I cited earlier. 15 American Jurisprudence, Civil Rights Section 2. Oh, this is 2016 update, September, when I got this. Natural rights have been described as those rights which appertain originally and essentially to each person as a human being and are inherent in his or her nature. Now replace that with man. Because we go back to mankind. What kind of man are you? A man? Or are you a man with a womb? Because God created all of mankind. But you get the gist of what's being said there. From nature, laws of nature. Go read the Law of Nations, Emerdy Vattel. You will be blown away about the laws of nature, as well as read the 6 primitive laws of nature from Bouvet's Law Dictionary, 1856. Those are defined in there, the laws of nature. Okay. As contrasted to civil rights, which are given, defined, and circumscribed by such positive laws enacted by civilized communities as are necessary to the maintenance of organized government. Civil rights are those that come from the people to the individual persons in those seats in government. And the Bill of Rights is that particular part that we're talking about, civil rights. Okay, that's for them. Our rights are long antecedent to the formation of the state. See Hale versus Henkel. Because God granted those rights. See the Declaration of Independence. Okay, This is the test of time. What has been fought for is that we have God-given rights, and they have what? Nothing to do. Okay, it's been said that the political rights are included within the more comprehensive term civil rights. So now we're lumping political rights with civil. So now we have a concept that what really is going on here, but that they are differentiating that a political right is a right exercisable in the administration of government. Not everybody has political rights or a right to participate directly or indirectly in the establishment or management of government, while civil rights have no relation to the establishment or management of government. Political rights have also been distinguished on the ground that a civil right is a right accorded to every member of a distinct community or nation. That's the people, which is not necessarily true with regard to political rights. Civil rights also been distinguished from social responsibilities, and has been pointed out in this connection. Where's the one part where it talks about yeah, I thought it said something about foreigners and stuff like that. Foreigners do not have political rights. Anyways, so we go look at the code. Let's go look at Title 18, Crimes and Criminal Procedure. How about misprison of felony? Okay. Whoever having knowledge of the actual commission of a felony caused and obliged by a court of the United States Military Tribunal conceals and does not as soon as possible make known the same to some judge or other person in civil or what? Military authority under the United States shall be fined under this title. There is no fine, or imprisoned not more than 3 years or both. Okay. So where's the fine? It isn't there. Now, I've been at this for quite a few years. There used to be fine here. Now, what they've done is they've moved them to 3571, sentencing of fines. Oh, wait, where did it go? Whoops. Sentences right here. 3571. In general, a defendant who has been found guilty of an offense may be sentenced to pay a fine. Fines for individuals, public servant, in their individual capacity, except as Friday subsection, an individual has been found to be guilty of an offense may be fined not more than the greatest sum or greatest of the amount specified in the law setting forth the offense. For a felony, not more than $250,000. For a misdemeanor resulting in death, not more than $250,000. Class A misdemeanors not resulting in death, not more than $100,000. Okay, here it is, listing out what the punitive damages are. Now, fines for organizations, except as provided subsection E. Okay, for a felony is $500,000. For a misdemeanor resulting in death, not more than $500,000. Class A misdemeanor, $200,000. For an infraction, not more than $10,000. Here's your fee schedule for punitive damages. If it's not listed under the one you're talking about, that you put in your A091. Now, we can go 241, 242.
Which that would be the what you would list under the lawful notice, notification letter, and notice of liability, right?
Yes, sir. The notice of liability is these crimes. You're putting them on notice first of the law, your rights as the law, and the Constitution. And you can even go so far as the code, because that's what they want to go by. That applies to them. Okay. And I might even have that pulled up right now.
So here's a question. Do you have to do a lawful notice if you're filing the A091, or do you just do an affidavit and file it?
Well, technically
always
speaking,
notify.
due process of law requires notice first, and even the federal rules of procedure require notice first. So you have to give them notice to cease and desist or whatever. But if they've already violated their rights, it doesn't matter. Right?
So in my case, where the eye doctor violated my rights already, and I sent them a lawful notification, I don't need to wait for them to respond. I could just file a A091.
Well, in that instance, I would give them the lawful notification letter, put them on notice of the law,
Which I did.
and the notice of liability if they fail to cease and desist with their actions, their conduct. Right? Because this goes back to God's law. You got to give them notice. You got to try and reason with them. And again, have compassion for your fellow man, knowing that we've all been brainwashed and indoctrinated. All of us. Except for those of us that have done our own independent studies. We didn't go to the 2-year bar school, which they don't teach the law. They teach code pleadings. I have their frickin' books from law school. So I know what they're taught. And then if he doesn't cease and desist with depriving you of those rights, after notice, now you proceed to the next step. Title 42, 1983 is what they've put in place for us because we no longer have our common law jurisdiction. Article 5, Section 1, they've abolished our common law. Just like what Bob was talking about. Okay, that came through in Idaho in the end in 1974. So we're a little bit behind the times. We've always been a little bit. I'm surprised it happened so fast, really, because Idaho is usually about 20 years behind the times. But I'm going to read from American Jurisprudence, Volume 16, Constitutional Law, Section 1, the very beginning of constitutional law. What is a frickin' constitution and constitutional law? As used in here, the word constitution means a declaration of fundamental laws or principles for the government of a nation or state. The Constitution represents the supreme written will of the people regarding the framework for their government. Where a constitution asserts a certain right or lays down a certain principle of law or procedure, it speaks for the entire people as their supreme law, and it is paramount authority for all that is done in pursuance of its provisions. Delegations of power, limitations of power. A constitution thus embodies fundamental values, and it should be principles, and articulates the lowercase c citizens' common aspirations for constitutional governance and the rule of law. A state constitution is likewise the supreme written will of the people of a state regarding the framework for their government, and is subject only to the limitations found in the federal constitution. Federalism. Although a constitution may be either written, as in the case of the United States, or unwritten in the case of Great Britain, the word constitution is applied to the organization of our federal and state government always implies a written document which is understood to have been enacted by the direct action of the people, providing for the form of their government and defining the powers of the several departments within it, the emoluments of the offices, thus creating a fundamental law which is absolute and unalterable except through amendment by the people from which it emanated. The General Assembly, the people, not the representatives, because the representatives don't exist until the people create the instrument of government. Now, constitutional law, which deals with the interpretation and construction of constitutions and the application of this fundamental law to statutes and other public acts because of the American governmental system. That's right. We're not a monarchy here. We're not an aristocracy. we're a Confederate republic, occupies an extremely important position in the jurisprudence of this country, because constitutions in this country, rather than stating inflexible specific rules of conduct, contain broad principles capable of accommodating societal changes. That's because it's the law of the land, due process of law. This is the process to bring things into being based on the subject matter jurisdiction granted in the Constitution itself. Thus, constitutional provisions gather meaning from the experience of the people, and courts should expect that modern society will mold and shape constitutional principles into new and useful forms. That's BS, because if it's the rule of law and it's unalterable, then the courts can't change that. That's what our founders made very clear in our Republican form of government. They don't have the power to make law, not like in England in a monarchy. Okay. Oh, yeah, here's a cumulative sub. Constitution intended to endure for ages to come and must adapt itself to a future that can only be seen dimly at all. No, the Constitution is set in stone, and it's the process that you got to follow. And those are the powers that are delegated, and that's it. And the only set of men that can alter that is the ones that have the power to alter it. That's the people, not the representatives, not the servants. That's back to the same question posed in the Law of Nations, Book 1, Chapter 3, Section 34. No, they do not have the authority to alter the fundamental law or the laws or the Constitution. It's the law of their creation. They can't alter their own powers. That's the servant dictating to the masters what their powers are. It's illogical. Now, this is where we start to comprehend the difference between a constitution and a statute, and who statutes apply to. A constitution differs from a statute in that a statute ordinarily provides some details of the subject of which it treats, whereas a constitution usually states broad general principles and builds a substantial foundation and general framework of the law and the government. The Constitution is the framework of government, containing the general principles upon which the government must function, intended not merely to remedy existing conditions, but to govern future contingencies. It is a compilation of fundamental laws of the jurisdiction and embodies principles upon which the jurisdiction's government was founded. The Constitution is made for the people and by the people, and is above all an embodiment of the will of the people, deriving its force directly from the people themselves. Statutes, by contrast, are enactments and rules for the government of civil conduct. That's for them and what they create. Back to Hale versus Hinkle, which I know that I have that one pulled up because I just showed that one again in class the other night. So we have right here, if whenever an officer or an employee of a corporation were summoned before a grand jury as a witness, he could refuse to produce the books and documents of such corporation upon the ground that they would incriminate the corporation itself. It would result in the failure of a large number of cases where the illegal combination was determined only upon the examination of such papers. This is saying if, conceding that the witness was an officer of the corporation under investigation and that he was entitled to assert the rights of corporation with respect to the production of its books and papers, we are of the opinion that there is a clear distinction in this particular between an individual and a corporation. An individual is a member of a corporation because that's the employee. But grasp the concept, and that the latter has no right to refuse to submit its books and papers on examination at the suit of the state. But even the individual does, because that's who the Bill of Rights is to protect. We already have all those rights, and you're going to read that here in just a second. And the individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited, with the exception of fraud. He owes no duty to the state or to his neighbors to divulge his business, or to open his doors to an investigation, so far as it may tend to criminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution, not a statute. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest and seizure, except under a warrant of the law, not by law, the law. He owes nothing to the public so long as he does not, what? Trespass upon their rights. Now, this where it starts getting interesting. On the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises, and it holds them subject to the laws of the state. Oh, statutes. And the limitations of its charter, corporate charter, business license, the bylaws of corporation. Just like Kirk's Law Corner LLC, I have the bylaws of my corporation. I had to create them. I had to submit them to the Secretary of State. Okay. Its limitations or its powers are limited by law and by law statutes. It can make no contract not authorized by its charter. Its right to act as a corporation are only preserved to it so long as it obeys what? The laws of its creation. There is a reserved right. Wonder what that reserved right is. In the legislature to investigate its contracts and to find out whether it has exceeded its powers. Oh, wait a minute. What do you mean we're supposed to go to the legislature? Well, I'll be darned. Let's look at this political power that's inherent in the people. Article 1, Section 2, all political power, not some of it, not most of it, but all of it, is inherent in the people. Government is instituted for their equal protection and benefit. God, it sounds just like Hale versus Hinkle. And they have the right to what? Alter, reform, or abolish the same whenever they may deem it necessary. Now, this is a verbiage right out of Hale versus Hinkle. And no special privileges or immunities, special privileges or immunities, shall ever be granted that may not be altered, revoked, or repealed by the legislature. This is law. This is Hale versus Hinkle reiterating this law. There is a reserved right in the legislature to investigate its contracts and find out whether it exceeded its powers. Is it obeying the laws of its creation? That says legislature. Our right dictates that we go to the legislature. Now, the right of assembly has to do with peacefully assembling the General Assembly, the common law grand jury, how it's supposed to work. But the way it's working right now is the people shall have the right to assemble in a peaceful manner, to consult for their common good, to instruct their representatives, and to petition the legislature for the redress of grievances. That kind of sounds like Article the 1st of the Bill of Rights as well. Now, I'll show you from our rules of procedure here in Idaho, which you can look up your own stuff there. Let's go look at some House rules. Rule 60, order of business. After calling the House to order, the order of business for the day So this is every day. Roll call, prayer, approval, da 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 da. What do we, wait a minute. What do we got down here? Presentation of petitions and communications. Oh, we're supposed to present our petition to the legislature. Now they want to deny this right, which we went round and round with them. But right in the Mason's Manual legislative procedure, it says petitioners have the right to present their own petitions. Now, I'm going to show you Mason's Manual right here, Rule 74, 75. The rules of parliamentary practice set forth in Mason's Manual legislative procedures shall govern the House in all cases to which they are applicable and in which they are not inconsistent with the standard rules and orders of the House and the joint rules and orders of the Senate and House of Representatives. Well, when you read through these rules are quite deficient. That Mason's Manual legislative procedure, I call it the guidebook for dummies for the legislature. But just like the judicial branch, you have rules of procedure. That's what these are. They like to say, oh, it's a rule. A rule of what? Rule of law, rules of the game of Monopoly, rules of the game. No, it's a rule of something always. It's a rule of procedure. Got to learn how our form of government is supposed to work and who has what power, rights, and how those rights are claimed and exercised. You got to follow due process of law. Parliamentary practice is what we use and have used for a long time, thousands of years. This is just how it's done, how we do it in a civilized society, especially where we're claiming that we have all the power. This is how it's done. This has been refined over time and to be found to be the best way to do this. Our founders were brilliant minds and had been through a heck of a lot. To get where we are at today, or I should say, to get where they were at then, was a heck of a feat. Read the Magna Carta again with different eyes, and you're going to see a lot of succession of law from the Magna Carta. But those are, just some finer points of rights, the law, rules of procedure, and how this is supposed to work, right directly from a Declaration of Rights. Thoughts, ideas, questions?
Hey, Kurt, you were talking about they abolished like something in common law, the law. What was it? You were talking about they abolished?
Yeah, they abolished our frickin' common law. Bob was pointing that out here a little bit ago, and I've shared this a few times.
But they don't even have that. They don't even have that authority to do that.
No, they most certainly don't. And that's exactly what is in Article 6, Clause 2. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary or notwithstanding.
Right.
And again, they don't have the authority to forms of actions abolished. The distinctions between actions at law and suits in equity and the forms of all such actions and suits are hereby prohibited. How do you abolish the common law? How do you abolish the Seventh Amendment?
Well, that's the problem in Florida. So, and I agree with you. I agree that
nationwide.
Can you hear me?
Yes, sir.
Oh, sorry. I agree. So what's interesting about Florida is that the legislature didn't abolish common law. Florida statute, and I understand the whole, I get it, but Florida statutes for them, and under Florida statute 2.01, it says common law and certain statutes declared in force. The common law and statute laws of England, which are the general and not local nature, with the exception hereinafter mentioned, down to the 4th day of July, 1776, are declared to be in force in this state, provided that said statute and common law are not inconsistent with the Constitution and laws of the United States and the acts of the legislature of this state.
Uh-huh.
So in Florida, our legislature never abolished common law. It was
You
the-
just totally missed what you read.
What did I say?
That is the bar coming back in with the monarchy. We have American common law, not an English common law.
Right. Up until it was an English common law up until July 4th, 1776.
No, sir. No, sir. Go back and read history.
Well, they were Englishmen.
We adopted
then-
and brought that over here in 1606. This has been the test of time. The reason why they
Right.
were fleeing from Great Britain was because they're trying to get away from Catholicism. The
Well, I agree with that.
ecclesiastical law,
That's true. But
souls and trusts.
But we went to war with England. So they were Englishmen in 1776 until they signed the Declaration because they were under the king. And
Right.
that was their division saying, we are no longer under English law, common law. We are now going to make American common law going forward.
No. Mm-mm.
No,
They were saying they're no longer under the king, the political bans. They
correct.
severed the political bans, policy.
But
of
they
the
would have
king.
had to start their own road, which is where American common law came from. It didn't start until they declared independence.
No, sir. No, sir. They were claiming they were Americans to begin with. And reading like the first Charter of Virginia, second Charter of Virginia, 1609, third, 1611. Okay. We have about 17 years of history of law before the Mayflower of 1620. And then the Mayflower Compact just says, hey, we're under Virginia, because Virginia was a very large territory, which encompassed a total of 7 of the states, of the 13. Okay. After the first Constitution, July 29, 1776, Virginia Constitution was adopted. And then they had to grant the land, because this is under land patents. Okay. It says for them to go out and colonize in the territory of Virginia. These were colonies within the territory of Virginia. But in reading history, it says, yes, we brought the English common law with us. We adopted it, but only those parts which was conducive to the public weal, to our weal.
Right.
We started making American common law right from the get-go. And I've got the history on it. That's what it says. And we have an American common law. But because of the Reconstruction Acts of 1871, bringing in the bar in 1878, or pardon me, 1887, 1871, 1878. Okay. This is where they put us back under the Roman civil law, the Roman code, the bar code. This is why they said, oh, you're all back under the English common law. That's why it says what it says, and I have it in my Idaho code as well. Very similar. It's shorter than that. It just says, yeah, the common law of England is in full force and effect, except for by which is altered by the statute, is not in conflict with the Constitution or the law of whatever. So we're not comprehending what we're actually reading there. They're saying that these bar agents from the Crown Temple Bar, England, are here enforcing the Roman civil law again, which is enforced through bills of attainder and bills of pains and penalty. We're being subjected to pretended acts of legislation again. They've erected a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance again. Are we not quartering soldiers, armed bodies of men? We may not be quartering them in our actual House. But technically speaking, what we would think is that our taxpayer dollars are paying these FBI agents, CIA agents, police officers. Okay. They're getting a paycheck and turning around and buying a house and a car. And okay, that's quartering them soldiers. That's not military. That's not lawful. No standing armies. But yet here we are, back to the same thing again.
So this is Jefferson, okay, in his autobiography. When we returned home, they had fair copies made of the several parts which were reported to the General Assembly June 8, 1779 by Mr. Wythe and myself. Mr. Pendleton's residence began being distant, and he having authorized us by letter to declare his approbation, we had in this work brought so much of the common law as it was thought necessary to alter all the British statutes from the Magna Carta to the present day, and all the laws of Virginia from the establishment of our legislature to the 4th of January 1 to the present time, which we ought and should be retained within the compass of 126 bills, making a printed folio of 90 pages. So this Jefferson saying they had American English common law, and then they were switching it over.
Yeah.
Yeah. But
Right from the beginning in 1606 with the first charter of Virginia.
Well, no, he's literally saying the 1779. So this is 3 years after the Declaration. He's saying we took the Magna Carta all the way to present day, and all the laws of Virginia, and they put together 126 bills to make American common law.
What 126 bills are you talking about?
Well, that's
Of the Magna Carta.
He said out of the
Oh,
Magna Carta,
gotcha.
out of the Magna Carta all the way to the present day, it says all the British statutes from the Magna Carta to the present day, and all the laws of Virginia from the establishment of our legislature in the 4th of January to the present time, which we ought should be retained within the compass of 126 bills, making it a folio of 90 pages. So they were taking everything from they were taking the best of the best. They were literally saying, it's going to change. We have to change all of it. We're switching over. So we're going to take everything from the past and we're going to go through it. And they took what they could, because that's what they didn't just make it up as they went. There have been what, hundreds of years of law created through common law from the Magna Carta. They would have taken the best of what they could, and then they would have made it their own.
All right, so with that in mind, with that in mind, all the way that our Constitution, everything's been eroded. Why wouldn't we go back to what we had before, what was eroded?
Well, I think the Constitution is actually written in common law. I don't think it's written in any other type of law. It is above the rest of our government, so it is the birth child. It gave conception to the United States, which means that it has to be written in common law to be above the actual United States. It is the fence around the government. Our problem right now is power.
It's the statutory law and then the Admiralty.
Well, Admiralty and Maritime are written in the law. And if you read the first 3 or 4 Supreme Court cases for the United States, they were maritime cases. They were legitimately like ships being outfitted in the United States when they were at peace. I think because France and England were going at it. And they
not only that, they were trying pirates and stuff when they would subdue ships and stuff.
And I think that's why they referenced Admiralty Maritime. They were actually talking about actual Admiralty Maritime ships and what the laws of Admiralty Maritime are on the high seas versus our laws on the land,
All right.
which were divided into law and equity.
Okay. Here we go. Here's my 1899 English common law in the early American colonies. The accepted legal theory of this transfer is well known. It is clearly stated by Story, which is Joseph Story and Van Ness versus Packard. The common law of England is not to be taken in all respects to be that of America. Our ancestors brought with them its general principles and claimed it as their birthright, but they brought with them and adopted only that portion which was applicable to their condition. We're talking clear back to 1603 with the establishment of Jamestown, Virginia, our ancestors. This theory is universally adopted by our courts, and it has been given them the important power of judging the applicability of the principles of the common law to American conditions. According to this view, the common law was from the first looked upon by the colonists as a system of positive subsidiary law, applying where not replaced by colonial enactments or by special customs suited to new conditions. While this legal theory is adopted in an eminently satisfactory explanation of the jurisprudence of today, it is not complete enough to afford an adequate synthesis of colonial legal facts for the historian. It contains, of course, the great truth that men cannot all at once cut themselves loose from a system of thought or action under which they have lived. So what he's talking about is when they first come over here, you got to read these charters. What it's talking about, they're fleeing the Roman Catholic Church, Catholicism, the good Christian people, okay? And they brought with them, yes, the English common law, and only adopted those parts that were conducive to them, what they thought was good, and thus created the American common law, because this is America, not England.
I agree, except this book was written 120 years after the Declaration of Independence. Which
Right.
means ancestors.
But it's
could
talking about our
mean just our
ancestors.
forefathers. I mean,
You have to go through the whole
if this
history.
was,
They-
I mean, I've read the, listen, I have this book. I've read it. I
Okay.
mean, and there were many parts of this book where they actually divided the book into lower states, middle states, and upper states. And they were showing the difference in this book about how they were handling common law in different areas of the colonies.
What does it say? Our ancestors brought with them its general principles.
I understand that, but it was 120 years after the Declaration. We don't
This
know.
is a guy doing an investigation into the history of the common law. Okay. And our ancestors brought the English common law with them when they came to America.
Yes.
And then it became American common law. This is what we have to comprehend, a separation from the Roman Catholic Church to Christianity. Even in the Magna Carta, 1215, the good Christian people are trying to separate from the Roman Catholic Church. You don't think 400 years later that they're still not trying to separate from the
Well-
Roman Catholic Church, the English common law?
I think we're arguing this semantic part of, is it American common law, is it English? The problem with common law is no common laws can actually be legislated. Common laws come
Right.
from cases. So
No.
when we
This is exactly what our founders were saying no to.
what?
No, the judicial branch does not have the power to
You're not-
make law.
Okay, I think you need to understand, when I say cases, I'm not talking about any say of the court. I'm talking about the people in a jury box in self-governance deciding what the general law will be after the deliberation argument. You are assuming I'm talking about a magistrate or a court. I'm not talking about a court or anyone who's elected. I'm talking about the jury deciding this is what we're going to do and this is how it's going to be. That is now the law.
because laws
Oh.
can only come through two ways. Well, laws can only come at common law, but they're either going to come by referendum, they're going to come by, well, we don't have assemblies anymore, or they're going to come through the jury box. Okay.
Okay.
So anything that's a US code, anything that is a legislated doctrine or legal doctrine, or came out of the birth child or the little puppy called the United States of America, or any of the states, legislatures, or anybody else, or county government, is not common law. It's the opposite of common law.
Okay, so this is where we have to comprehend what our good Christian brethren did when they came here and was telling the Roman Catholic Church to kick rocks. Our God-given rights is the common law, the law that is common to all. Natural rights come from God and are unalienable. These are the laws of nature and nature's God, as it is written in the Declaration of Independence. Rights are the law because the word right and law are synonymous. They come from the French word droit. Our founders knew this. Our founders were brilliant men, and I'm not even talking about 1776 founders. I'm talking clear back to 1603. The founders. Okay? And this is what Anglo-Saxon is about, is that God is the creator. God is the sovereign. God created the law. Thou shalt not commit murder. Thou shalt not steal. Thou shalt not bear false witness. We have a right to be free from that. Those rights are the law, the common law.
That's true, but even Moses
Yeah.
wrote the Decalogue on tablets. So because we were too stupid to listen to him, so then he had to write it down and say, "Can you read it now, or is it really this difficult, stupid?"
Right?
So
And that's where
has to
we're
be
at again
written.
today.
Well, I mean,
Yeah.
that's my point. It has to be written.
Literally.
So
Yeah.
And that's why I
Oh.
say that we need to get this in front of people. I mean, the youngsters, man, they need to know all this stuff from the beginning. It's actually really interesting, you know. I mean, if you go back and say, here's where you're from, here's where we came from, you know, and this is all we went through, and this is where we are now. I mean, if we get past and through all this, just imagine what kind of story that's going to be, you know.
Yeah. But see, this is what was fought for. Even the Magna Carta, right? What happened there? They put the sword to King John's throat and told him, you better sign this thing or we're going to kill you. And we're going to go throughout the castle and we're going to kill your whole family bloodline and all your people here. And we should have they should have just done it then. We'd probably be a whole lot better off. And you know what? More than likely, they found out about what? The satanic rituals of the Roman Catholic Church. And they were upset that these popes and the priests were diddying these boys in the back room, and then found out that they were doing satanic rituals underneath the churches. That would be my guess what really was going on there. But and if they didn't, they would have found that stuff if they would have went throughout the castle and killed all of the family bloodline and all of that. We'd probably be a whole lot better off today, 700 years later, 800 years later.
So the book that you cited, English Common Law in the Early American Colonies, 1899, page 13 says, cases involving amount not over 40 shillings are to be heard by magistrates or a commission of 3 freemen without a jury. A suit is commenced on summons or attachment. Testimony may be taken in writing by any magistrate or authorized commissioner to be used in criminal civil cases. If the party casts any new evidence or the matter to plead, he can obtain a new trial on a bill of review, which we would probably call an appeal at this point in time,
No,
free
we
tenure.
still have a writ of review.
Well, yeah, because the appeal is basically the writ of review. Do we have a writ of review?
Yes, writ of review.
I
Oh,
don't,
certainly.
I'd have to look at the
That's
form.
that's a common law writ.
So free tenure lands adopted and feudal indictments are abolished. Conveyances are to be by deed of in writing. So again, here it is. I mean, the same book, and it's saying it's the courts. They're still using the courts.
Right, but not the courts of the United States. That, see, again, you're not grasping the change that happened in 1871.
I still think that the county court, because it's on meets and bounds and was not established by law, is the common law court.
They're supposed to
Because
be ran by the people.
Well, I there's a whole lot of should that should be going on that ain't should
Right.
going on. We all know that.
So those
But
are
the
called
reality
de
is when
facto
I-
kangaroo courts.
When I went and researched my county, when they carved out my county, they did not make any mention of county court. They mentioned the circuit court coming in. They gave it the ability to come in, which back then was the 20th Judicial Circuit. But they didn't say anything about the county court, because the county court would have been by the meets and bounds of the county. It has to be territory court, which means that technically in the United States, there would only be 3 territory courts. There would be a county court, there would be a state court, because if you look through your laws, they actually designate your meets and bounds on survey by, so you would have a state Supreme Court, and then you would have the United States Supreme Court, and those technically would only be the 3 territory courts.
Who
in the
creates
United
those
States.
courts?
Well, who created them?
Who creates them?
We created them.
We did.
And actually, we said we give the full weight as vested in a Supreme Court. That's it. I mean, that's literally what we allowed in the Constitution.
Let me correct you on that.
This is like the president being commander in chief. The Constitution does not say the president's commander in chief.
Yes, it most certainly does.
No, it says that he will be called to be commander in chief, which means Congress is actually in charge of the military until a time of war when the president is called.
The president shall be commander-in-chief of the Army and the Navy of the United States and of the militia of the several states when called into actual service of the United States.
Yes, when called
That's
into
right.
actual service,
Right.
of
And
the
who
United
calls
States.
them into service?
Congress, by a
Read
declaration
again.
of war.
You better read again. The
Then
United
why
States
did
shall
they have
guarantee to every state
recall-
in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. All right. We have to comprehend we have the right to petition the legislature for the
hold on,
redress
hold
of
on.
grievances.
You're talking about the president executing domestic violence, which the military is not to operate against its citizens. So that would have been an activation of the militia.
Well, who is the militia?
Well, the militia ain't our military.
Yes, it is.
No. It's
Yes, it
not.
most certainly is.
Well, you need to read the laws of the state of Florida, because in the state of Florida, it's the militia is any able-bodied man or person that can defend the state.
Okay, hold on. There are 3 parts to the militia. We have 2 that are organized by government. You have the state and federal organized militia, which is the military. And the military is subordinate to the civil power. The unorganized by government militia is every able-bodied male between the age of 18 to 64. You are automatically duty-bound to defend because you're an American.
Right, but you're saying domestic violence, which they are not allowed to use the military.
Yes,
Because,
no, right here, it's what it says. Do you know what domestic violence is?
Well, that would be like insurrection.
Internal
Yeah, I agree.
insurrection.
Yes, domestic violence. Yes.
It's an attempt to overthrow the Constitution in war against the people.
Well, we've already overthrown the Constitution, so
They
that's
have.
over. Yeah.
Why do you think we are where we are right now, and what's going on?
Well, because we let them.
No. I'm saying because there
Yeah,
has
but
been
now we hold
internal
these cells to be
insurrection.
Yes.
The Reconstruction Acts of 1871 is the great fraud. It converted our Republican form of government, subverted its subversion of law, its seditious conspiracy to overthrow the laws of its own creation and alter fundamental law in the Constitution, and created a corporation. Congress doesn't have that power. You can't alter the fundamental law or the Constitution.
Well, if you have no one to stop,
That
you,
is
you can do whatever you
internal
want.
insurrection. It
And
doesn't
I agree
matter.
with you. I agree
It
with you.
doesn't matter. It happened. And that's why we
Well, I
are
agree
where
with
we're
that
at
too.
right now. We are at war with our domestic enemies. Internal insurrection.
The problem is they're holding all the power and we can't even get an inch in.
And this is why I'm here trying to teach you what our power is
Right, we
and
don't
how
have
to
any
claim
power.
and exercise that power.
We don't have any power.
Yes, we most
The only
certainly do.
power we have is to be as annoying, is to be too annoying to punish.
No. No.
No?
No. We have lots of power, brother.
I haven't seen anybody enforce anything or punish anyone or prosecute them or drag them anywhere.
I've already shared
I've
with
seen a
you
bunch of
what
complaining to
we've
elected
done.
representatives.
I've already shared
Brian-
with you some of the things that we've done.
Right. But then you,
But
I
you,
mean,
you
like,
just
let's
that
be
contradicts what
honest.
you just stated.
well, that's not true.
We're
You-
gonna put that
you-
into a process, though.
You
We'll
called,
put it all into a
You
process,
called
and-
elected or appointed public officers, which means you have no power over them. You have to beg them.
No, I didn't call them.
They just, well, I'm just making.
I mean,
I'm making,
I did call
I'm
him and
making a
instruct
general-
my
I'm making a
representative.
general point. If you have to go to them, you have no power over them. When you
Yeah,
have
but that's
power over
until-
them,
That's
You
until
tell
we
them to
build
come to you.
build back the republic. Until we build back the republic, you're right. We're still a slave. We have to bow down.
How
But
do you
once
not,
we
how
once
do
we
you,
build back our what's that?
how do you not grasp the concept about petitioning the legislature and instructing our representative to discharge the duties of their office?
and what happens when they ignore you?
I'm saying that we did that, and
No,
that's
no,
what happened.
I'm
That's
not
how.
complaining.
I'm saying. what
No,
happens
I'm
when they
saying what
ignore
we
you?
did do, and I'm countering what you're saying is
So they're,
false.
so they're doing that everywhere in 50 states. They're doing that all the time. Because I can tell you,
No,
I've
okay.
talked
Where's
to
your
20 of them,
petition?
they're all
Where's your
failures.
petition? I want to see it.
Which would you like to see?
Your petition to the legislature for the redress of grievances in proper form.
What's proper form?
Oh, you don't know?
Oh, is it a secret or are we playing a riddle?
No, it's in Lex Parliamentary Practice. You got to know how these documents are done in proper form.
Yes, yes. When you're in charge,
Because ignorance of the
when-
law is no
hey,
excuse.
when you're in charge, guess what? Your little child, yes, he tells you what rules you have to follow. When you're the parent and in charge, they dictate who's in charge, or the little kid just tells you what to do, right? And you have to have your proper form. I thought we were the parent. I thought we were in charge. If we're in charge, I don't have my proper form. I tell you what to do, you do.
Yeah, you have
Yeah,
to
but
that's
do
the
it in
whole
proper
now
underground
it's
form.
just getting
dog.
argument.
You
Yeah,
have to
now
follow
it's
due
just getting
process of
argumentative.
law.
This is where we're at right now. The reality is,
Right.
this is where we're at right now.
Well,
We
Yeah.
still have to bow down until we get our republic back. This is what we're doing. So, like, if we could stay on track here,
Right,
I
but
agree with that.
this
but
comes from the
problem is
common law.
We are assuming we have power we don't have. We are assuming that they
yeah, but
care.
we're building
They
that power
don't
back.
care.
This is what the assemblies are. This is
Yeah.
what about finding out what we can do in the meantime.
But I'm telling
once
you,
we- once-
I've already claimed and exercised this power and had results. So that's contrary to what you're saying.
I don't see too many people doing nothing, and I would like to see what you did, because I can tell you, I've been head to head with
Well,
them,
actually, I'm
and the only
actually right
thing-
now.
and
what Kurt
can I-
just did-
Let me finish.
Oh yeah,
please.
go ahead. Go ahead.
The only thing that I've found that works is when they come, you go right back after them. That's why the sheriff in this county, they don't talk to me. They leave me alone. They won't come near me. I wrapped 16 of them up in knots, tied them in knots. I was a pain in the ass. And now they just leave me alone.
Mhm.
You have to be too annoying to punish. When you have no power and you are inferior to the force, you have to be just exhausting. And when you're exhausting, they'll just leave you alone.
But
That's
see,
really
you
the only
took the
power we have.
initiative. You took the initiative and you learned the law. You know, so that's a form of self-preservation, which nobody knows about today. These kids aren't learning this stuff.
Yeah, knowledge
I
is
mean,
power.
most people aren't learning this.
Listen, we're
That's
all
what
in
it is,
agreement on
and
that.
yeah.
We're all in
I mean, so
agreement on
that's
that.
really what it is.
Well, because and listen, I mean, I'm probably just beating a dead horse when I say our education system is not an education system. It is a propaganda-based indoctrination of pulpit preaching to program
Like I
good,
said, man,
obedient
it's
slaves.
they're turning out racist, gay communists for the ones that are catching what they're teaching, and the ones that rise above it are,
And here's the thing, I believe that we're all passionate about the same thing. And I like the debate. So there is nothing personal here. I like the debate because we get to get these thoughts out and we get to go at it.
Yeah.
And I think it's healthy.
Well,
So
dude, I'm telling you what, you guys argumenting back together. I'm learning a lot from you guys.
So, well, there you go.
I'm
See,
just
that's the
bringing
And
it
that's
up.
the whole point of this. Notice, okay, point this out again. I'm not calling Bob any names.
no.
Right.
I'm actually not being disrespectful to him. I mean, other than maybe interrupt him a little bit. So please forgive me on that.
You're
But I
forgiven,
allow the same
totally.
thing, right? Because sometimes I've seriously, I've been at this for 28 years solid, right? Well, okay, I changed that. Not solid. The first few years there, I was going in and out of jail, so I studied a lot because I got screwed. I got threatened if I didn't take the plea bargain after I'd already proved the cop didn't have probable cause to pull me over to begin with.
Mhm.
And the public defender in the felony case, possession of a non-narcotic drug, which was nothing. They couldn't even prove what it was. Then it was, oh, well, you better take this plea bargain or we'll go to trial and make sure that you lose and you go to prison for the maximum amount of time. Okay. I was 1994, 23,
That's disgusting.
24 years old. Okay. But I had enough common sense and what I'd learned in the Marine Corps, right? We are to disobey any direct order that comes in conflict with the Constitution, and we are to report to the next higher in command. Gee, we were taught the Constitution in Marine Corps. Weren't you in Marine Corps? You remember falling asleep in the room?
I was Air Force. I worked for the Marines when I was in Iraq, but I was Air Force.
Yeah, and we were also in the time that I was in, which was in 1990, the Geneva Convention. Okay, the laws of war here, rules of engagement, how to treat prisoners. They have rights. Imagine that. The law of nations protects those God-given rights because they're man. It doesn't matter. Those are universal rights. And I don't give a rat's ass about your universal declaration of rights. This is the law of nation and the laws of nature, international law for all nations. That's where the Geneva Convention come from. So mankind have all these rights, and you have to respect those rights. That's mandatory. That comes first. That's what government was instituted to secure.
Yes.
So those are facts of law that I don't need a jury or a court, a judge, or anybody else to say, oh yeah, that's a fact of law. All I have to do is know it, cite it, quote it, claim it, and you have to rebut it. And you can't rebut those facts of law. It's impossible. Completely illogical to think anything other than, right, being of sound mind, that these rights come from God. It is declared in the Declaration of Independence. It is declared in the Virginia Declaration of Rights as the theoretical foundation of all government, which is ideology when creating a new nation called America, because the Lee's Resolution separated us from Great Britain. So now we're an independent sovereign nation state and you have to declare, lay down the law. And what we're talking about when we talk about the law of a nation, you have to declare its ideology. What is ideology? A set of ideas, morals, and principles. Well, where does that come from? Religion. That is the document that declares Christianity without the use of force and violence. That declares Christianity as our theoretical foundation of all government. We're grateful to Almighty God for the blessings of liberty. Not man, not the king, not a prince, not a princess. Okay? This is fundamentally one of a kind form of government in all of history. To this day, there is no other form of government on the face of this planet that has ever been laid down, ordained, and established like our republic. Not one.
Nope.
So,
We agree on
Hey,
that.
Kurt.
yes, sir.
Yeah, absolutely. Hey, Kurt, I had a question, man. Let me, you know how we got here, you know, with all these, you know, all this bureaucratic bull crap of them coming here, changing this, dropping that, you know, just playing bait and switch with us with all of our rights and the Constitution, and everything. What would you think would be a way to protect that in the future? If we, let's say we got our republic back and we put all the checks and balances in there, how do we keep from that ever happening again?
You know, it really comes down to education. And we need to do the declaration declaring our rights is the law.
Go back to the roots, right?
Go back to the roots and lay this stuff down before instituting government and make it very clear that the government, you know, see, this is what's in my mind piss poor about the Constitution is they really don't
Break it down.
they really don't break it down very far, do they?
No.
Like you kind of have to really know what they're talking about. And see, when James Madison drafted this Constitution and William Penn penned it, but James Madison is the one that drafted this Constitution. He's a brilliant man. And I'd say, you know, I hate to say it like this, but I feel like I'm James Madison in reincarnation here. Even before I started studying James Madison, I'm like, I agree with this guy when I started reading and studying about him. And at first kind of Alexander Hamilton too. And then I found out, oh, wait, he was supposedly a bastard child, blah, 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 blah. But anyways, yeah, we need to lay this stuff down for all of history again, just like the Declaration of Independence. But I think we need to be much, much more thorough. Now, I'm not sure if you're aware of this one, Bob or David, Mark. There was originally 157 proposed articles in the Bill of Rights.
I didn't know that.
And they said one of the arguments that was made against having a Bill of Rights was that there were too many rights to try to enumerate, that the government might assume that these are the only rights that we have. This is the reason why the Ninth Amendment is written the way it is. And essentially, these are not all the rights that we have. Just because they're not enumerated here doesn't mean that you get to deny them or disparage, which means, oh, you're one of them constitutionalist or sovereign citizen. That's disparaging. That is an attempt to deny rights. The common law of the land. And that's actually the full phrase, is the common law of the land. So here we go again with what is really the common law. The law that is common to all, due process of law. And no rights can be deprived without following the process that is due. Now, I had a bar member friend, Fred Kelly Grant, who just passed away here. He'd been in law for 60 plus years. He's been under the Supreme Court, clerk of the judge. He's been helping with the governor, Cecil Andrus here for Idaho, you know, done all sorts of stuff. And when I said that due process of law literally means it's the process that is due. He's like, in all my 60 years of doing law stuff, he's like, you're only the second man that I've ever heard explain due process of law that way. And I'm like, what? That's just common sense. But it's not.
Common law. It's supposed to be common sense.
Exactly. It's supposed to be common sense, or as the Declaration
You know,
of
the-
Independence says,
The unfortunate thing at this
evident.
point, oh.
Sorry, it's supposed to be self-evident. This is why it's the lex non scripta, the unwritten law. This doesn't need to be written down because we're already, from the first primitive laws of nature, you're either of sound mind or you are insane. You're supposed to be properly organized up here with your thinker, and that you already know moral good from moral evil. Naturally, fundamentally, and principally, you're supposed to know this. And here's one of my going jokes. Do you have to hit your thumb with a hammer to know that it's going to hurt? Or do you possess just the minimal amount of common sense to go, oh, hell no, I don't have to hit my thumb with that hammer to know that it's going to hurt? Or are you literally one of those people that have to hit your thumb with that hammer and get hurt and go, oh, damn, that hurts? Told you. There are people out there, I really think they do. They have to hit their thumb with the hammer to go, oh, that does hurt. Go ahead, Mark.
Oh no, I was just listening. I forgot what I was going to say now.
Oh, no.
So it's funny. Listen, you're exactly correct. The problem is, and you hit the nail right on the head. Our education system is so bad. It is so bad right now that, I mean, we have. Listen, I don't want to get all the political stuff.
It wasn't even there. I mean,
we don't have an education system. We have.
It was intended that way.
Yes, because you can't, and that was, and you know, I mean, this is repeated.
Rules of radicals.
Washington, Jefferson, Franklin, they all said, even what is it? I think it was even Plato. To have a republic, you must have a well-educated society. Yes. Because it must function under the rule of law, which is interesting because when I did some research, what I found was, after 1812, right, the 13th Amendment disappeared, the one that was actually there. And then in 1861, you have Lincoln with his little scam that he pulled. But what I found when I did some research on immigration between 1820 and 1850, 33% of all the immigration that came into the United States between 1820 and 1850 was Irish immigrants fleeing the potato famine. They were uneducated. They had lived in countries where all they knew was oppressive government. So this is a tactical strategy when you have a society that is becoming educated or they know how to defend themselves. You infiltrate the society or you flood the society with people who do not have any type of education or any type of intellect to be able to defend themselves, and they've only been commanded by their government. Well, this sounds a lot like what's happened at the southern border. Flood the system with people
it's not
who
just the
don't
southern
have any
border,
information.
it's worldwide.
Yes.
But they don't even need that.
Well, I mean, they don't. But maybe they think they do. I don't know. They're so dumb now. I mean, listen, I was a paramedic for 20 years. Okay. I can tell you right now, I've been to enough. I live in Southwest Florida. I live in like the third oldest county in the country. Joe Biden has Alzheimer's. I have been to more nursing homes than I can tell you in 20 years. Joe Biden has Alzheimer's. That little shuffle he does, that's called the Alzheimer's shuffle. You can look it up. He has Alzheimer's. That's a fact. He is walking like we have memory care units here. He is doing the Alzheimer's shuffle. That dude, he's not there. Legitimately not there. That's a fact. And I would
That's on
bet
purpose,
20
too.
years, 20 years in the EMS
He's
on
got
it.
the chomo. It must be the chomo shuffle.
Yeah. The little wobble with the hands not moving,
Yeah.
like a little stick. That's the Alzheimer's
Yeah.
shuffle. So interestingly, I looked in. Let me throw this in real quick. I'm gonna rescind. This was to the Republican legislature, and it's Jefferson. It says, in that one of the bills for organizing our judiciary system, which proposed a court of chancery, I had provided for a trial by jury of all matters of fact, in that, as well as in courts of law, he defeated it by the introduction of the words only, if either party choose. So in other words, you could choose trial by jury. The consequence has been that is no suitor will say to his judge, "Sir, I distrust you. Give me a jury." Juries are rarely, I might say, perhaps never seen in that court, but when called for by the chancellor of his own accord. And this is literally our problem right now. You have magistrates acting as jury, running defenses for defense. I literally got thrown out of a courtroom a couple days ago because the judge was lying. He was putting words in the petitioner's mouth, and I made a face at him, and he got angry with me, came across the bar screaming at me, asking me if there was a problem. I told him, I said, no, there's no problem, right? Because I don't want to get in an argument with them in the middle of the courtroom. And he says, no, there's a problem, obviously, because you're making that face. And I said, well, he never said advisory, and he never asked the court for an opinion. He asked the jury, and he goes, get out. He started screaming at me to get out of the courtroom because the judge was literally lying. This guy demanded a jury on all issues. That is in the Florida Rules of Civil Procedure. That is in the common law rules of procedure. They are refusing juries. And as much as I have done in research, the reason that we had that the trial by jury, and it wasn't just trial, it was on any issue, any decision was to be made by jury if you did not trust the judge. Well, we don't trust the judge, but it doesn't matter how many times you scream to have it ruled by a jury. They ignore you and they just keep going. That's literally what's happening right now. This was specific in common law. All issues ruled by jury. Judges, and the rules of common law, it says judges take an administrative role only.
See, we do have to demand the jury, and we also have to instruct our jury. I don't know if
Can't
you
even
need
get
that.
them in the room.
No. Again, you got to do this in proper form. You got to do the proper paperwork. You got to perform your administrative duties. Okay. Rules of the common law. You're going to be sui juris. You better know how to perform your administrative duties.
I have the rules of common law. I literally copy and pasted the rules
Those are the ones
of common law.
they made in when?
53.
Yeah. That's after 1871, isn't it? That's the corporate one.
Well, it still says the same thing.
It's quite expansive.
It is a default. And
What
it
is-
says the same thing in this is what's interesting. In the Florida Rules of Civil Procedure in 2022, the exact words that are in the 53 that says that it's automatic. You get a jury. Automatic. Literally, it says it. In 2022, in the Florida Rules of Civil Procedure, it says a jury can rule on all issues. They are flat. They're not only refusing it from the common law rules, their rules of procedure say it too, and they are not having it.
Well, if the sheriff knew what he was doing, he should arrest the judge right then and there, or
Yeah.
put him back in line.
Now, when they're all working together,
Right. But that's the thing. They slowly infiltrated. We should slowly infiltrate back.
yeah. Well, I agree. It's going to be a process to work to.
For
We just
sure.
got
It's
to
not
get a
going to
hook
happen
somewhere.
overnight.
We got to get a
Right.
hook somewhere. There's got to be a hook somewhere we can put in them.
We're coming
Yeah, that's
back
what
to the
this
force of
AO91,
forces.
that's what that AO91's about, man. That's what I'm getting ready to try and take down my health department here right in my own county with that AO914 doing the exact same thing.
Now remember, the Sixth Amendment
So I'm talking to you, Kurt.
in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. That's a shall. That's mandatory language. Okay. Seventh. What's the seventh say?
Any fact tried by and trial by
In
a jury
suits
cannot
at
be-
common law, where the value in controversy shall exceed $20, the right to trial by jury shall be preserved. Shall.
Yep.
That is mandatory language. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Okay. Now, back to what I was going to show you, which we got sidetracked. Courts of the United States. Who makes those courts? Congress. We got to look at what it says, due process of law, to bring what? New states into the Union. Who has the power to create? Article 4, Section 3. New states may be amended by the Congress into this Union. Congress is the one that creates the law of creation. And here it is for Idaho. This is the first legislative session for the territory of Idaho. Come on. Skipty. What does that say? Laws of the territory of Idaho, not a state of Idaho. Okay. Territorial Organic Act. Declaration of Independence, Federal Constitution, the preemption, and naturalization laws. Look at that. Territory of Idaho. Declaration of Independence. Why is that one first? Quite the key.
You got to shed the skin.
Got to lay down the law first. So you got the law. Then you have our Republican form of government who holds supreme power, the sovereign body politic, the power to create. Then we'll get into the Organic Act because that's created by Congress. Therefore, they are courts of the United States because Congress has the power to create inferior tribunals or inferior courts. Oh, wait, this says amendments to the Constitution, but yet it reads Article 1, Article 2, Article 3, Article 4. These are not amendments. And they hide the original writing that's up here. I actually have two of them. One that I got from the gift shop at the Supreme Court of the United States when I was in DC in September of 2018. And the other one I got from my buddy. I have a certificate of authenticity from RJ Reynolds. And it reads something to the effect of, these are articles in addition to an amendment to the Constitution of the United States of America. These are articles in addition to. This is contract law. But notice it stops at Article 12. Where's Article 13?
Wait a minute. Go back up. Those are the articles that Washington signed. Those are actually the articles that made the Bill of Rights.
Yes,
Those are
sir.
the 12.
Yes, sir.
Yes.
No,
That were
no, these are the 10.
No, they're
The 11th
12.
was made after.
Originally, there were 12 that came out of the Senate. Washington signed 12 original
Yes, I know.
articles.
But
10
due
came
process
back-
of law, the states have to ratify them, and
That's
not all
right.
the states ratified.
What-
And in fact, it was Article the first and Article the second that was not ratified.
Correct.
Okay. But these two were made in the second session of the third Congress. Oh,
All the judicial power of the United shall not be considered to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state. Yeah. Or by citizens subject to foreign states.
yep.
That actually, yeah, that is the original. That's the 12th. Yes, sorry.
Yeah.
Go ahead.
Shall
I
not
apologize.
be construed to extend to any suit in law or equity. That's suits in law, incorporated in the body politic,
Mhm.
created under the Constitution. Suits in law is admiralty jurisdiction, because that's the only jurisdiction that's enumerated in Article 3, Section 2, granted to the judicial branch. It says the judicial power, right? Oh, the judicial power granted. But here's the Organic Act for the Territory of Idaho. What does that say? Be it enacted by the Senate and House of Representatives of the United States in Congress assembled. And here it is. Here's your meets and bounds. Beginning at a point in the middle channel of the Snake River, where the northern boundary of Oregon intersects with the same. Then follow down the said channel. This is meets and bounds. Okay. But I want to show you something here in Section 9 about our judicial branch. And this is the organic law created by Congress to ensure our Republican form of government, which is Article 4, Section 4. Anything that comes in conflict with its laws of its creation would be void for any effect. You can't exceed the laws of creation. The judicial power of said territory shall be vested in a Supreme Court, district courts, probate courts, and in justices of the peace. Where does it say magistrate division?
No, we agree there.
It does not. Okay,
It does say court.
right? But these are courts of the United States because Congress is creating this. Uh-oh. The Supreme Court shall consist of a Chief Justice and 2 Associate Justices, any 2 of whom shall constitute a quorum, and who shall hold a term at the seat of government of said territory annually. And they shall hold their offices during the period of 4 years and until their successors have been appointed and qualified. Said territory shall be divided. Now, pay attention here how this is supposed to be. The said territory shall be divided into 3 judicial districts, and a district court shall be held in each of said districts by one of the justices of the Supreme Court at such times and places as may be prescribed by law. Bylaws is policy. And the said judges shall, after their appointments, reside in the districts which shall be assigned to them. So, the Supreme Court justices are the ones that are supposed to preside in the district courts. Clearly not what we have today, is it? Now, but let's read on further. By one of the justices of the Supreme Court at such times and places prescribed by law, and the said judges shall, after their appointments, respectively, reside in the district which shall be assigned to them. They have to live there. The jurisdiction of the several courts herein provided for both appellate and original, and that of probate courts. Original jurisdiction, that's common law. No, it is not. That's admiralty jurisdiction is original jurisdiction. Article 3, Section 2 does not mention common law courts. It suits in law under admiralty and maritime jurisdiction. But let's read what else it says here. And that of probate courts and of justices of the peace shall be limited by law. provided that justice of the peace shall not have jurisdiction of any matter in controversy when the title or boundaries of land may be in dispute. Back to that equity suits in equity. Article 3, Section 2, having to do with an equitable interest in land, or where the debtor sum claim shall exceed $100, and the said Supreme and District Courts respectively shall possess chancery as well as common law jurisdiction.
As well as common law jurisdiction.
Right.
Well, then that means that the courts are the courts.
Can't be heard in any courts of the United States except after it's been heard by a jury. It has to be heard by the rules of the common law.
Well, we agree to that. The problem is
It's what the Seventh Amendment says, as it is
yes,
written. That's
but
law.
They're ignoring it.
I'm not disagreeing with you on that. But we have to learn how it's supposed to be so we can call out what's fraudulent. You have to know the truth to know what's not truthful. You have to know the law so you know what's not lawful, which means you got to read.
Yeah.
And that's what I've done. And this is what I'm reading, right? So this destroys the whole concept that the common law is stare decisis, case law, the judicial branch. No, not here in America. Common law is rights as the law. Suits between man and man, because if you were going to say that, oh, well, that's case law, this is where I bust members of the bar's balls. Well, then why does it say suits at common law in the Seventh Amendment? You're saying that suits at stare decisis, suits at case law? That doesn't make any sense. Does it? No, it does not. Therefore, common law is a body of law, rights as the law, that are supposed to be self-evident, that are long antecedent to the formation of the state. It's a body of law because that's what jurisdiction is. Juris meaning law, diction is the words. It is a body of law. And the judicial branch doesn't have the power to make law. Natural rights, God-given rights, the laws of nature, that's the common law. It comes before government and is retained by the people. See the 10th Amendment.
So the Declaration of Constitutional Challenge that I sent 2 days ago. Oh, by the way, I just got a notice that one of the Supreme Court justices for the state of Florida retired today. So I don't know if it's an association, but this is it. It's not that long, but it is direct. It says the petitioner draws into question the Supreme Court of Florida abolishment of the separation between common law and equity in Florida Res Civil Procedure 1967 revision. This action has never been supported by legislature, nor could the Supreme Court make a rule governing the actions and processes of all state of Florida clerks of court. The Supreme Court of Florida superseded the limitations of its mandate when it assumed authority over all clerks of the court in the state of Florida. Supreme Court, Florida acted as legislative body in making law, rules, policies, and procedures for all clerks of court, for which they have never been bestowed authority nor ability. The Supreme Court of Florida's actions put the Bar Association, a non-public entity, in charge of all clerks of court in the state of Florida, disregarding any common law general laws established by the people in actions at law. The Supreme Court of Florida's actions restricted the people's right to speak and petition and participate in self-governance. The clerk of court is more than just a clerk for judges and courts in the judicial branch. The clerk of court is the treasurer and keeper of the public record. The clerk of court is required to be the printer of election ballots to be used in elections under Florida Statute 13805. The clerk of court is the keeper of the candidate oaths and qualifications
Again,
all
you're reading
candidates
code
according
made by the
to
bar.
Florida Statute 13805. The Supreme Court may have authority over their clerks, but the Supreme Court does not have authority over the clerk of court for the President of the United States, Congress, or the Secretary of State. The action of assumption by the Supreme Court would significantly and directly violate the clear separation of powers emanating from Articles 1, 2, and 3 of the Constitution for the United States. The action of Supreme Court of Florida assumption to administratively command the policies and procedures, possesses, processes, and actions of all clerks of court in the state of Florida are most importantly in a presumptive interpretation that American common law and equity have been merged into the docket, consolidating, thereby putting man's desires for power and money over the laws of nature and nature's God, sending the American people into bondage with no individual right courts to petition. The result of the Supreme Court's actions in this matter violates the Bill of Rights. The petitioner, as an American person, hereby challenges in Florida rules of civil procedure in 1967 and any subsequent ruling, lawful and legal doctrine emanating as a violation of the separation of powers, separation of church and state, or the separation of God's law and inequity, and the superseding of the Supreme Court of Florida's limitations and mandate. We'll see what they do.
Yep. Now, again, you're still reading code, bar code written by members of the bar. Anything after 1871 has already been made void.
Right. But the problem is they won't listen to anything. So you're going to have to get a notch somewhere. And that's what I'm trying to do is get a notch on something.
Right.
And
But
then
you're still
exploit
trying
it
to go
from
to the
there.
judicial branch.
But there's no other branch to go to.
Yes,
go
there
anywhere
is. I just
Who?
already, dude, what have I been talking about for 3 hours, 4 hours?
Right.
The legislature and the executive. Here, I'll just show that to you again. I guess I still have this up.
I'm in conflict with that interpretation.
It's right here as it is written. Article 4,
My
section 4.
position is we are to prosecute them ourselves. We are not to go beg anyone.
It's not begging, it's instructing.
Yes, but they don't have to listen.
Yes, they
And
do.
I don't ask
If
my
they
dog,
don't, they become misprison of felony. You've been informed of a
Yes,
crime.
but
That's
you have to
dereliction of duty, and you become culpable. And not only that, we have the right to prosecute our own claims.
They don't care because they're not listening.
I'm telling you, I've had success. They do care. But let's go ahead and read. In Luther versus Borden, the Supreme Court established the doctrine that questions arising on this section are political, not
Listen,
judicial
I
in
agree
character, and that
I
it
agree
rests
with
with Congress to
everything
decide
you're
what
saying.
government is established in a state, as well as its republican character.
I agree with
Texas v.
everything you're
White
saying.
held that the action of the president in setting up provisional governments at the conclusion of the war was justified, if at all, only as an exercise of his powers as commander-in-chief, and that such governments were to be regarded merely as provisional regimes to perform the functions of government pending action by Congress. On the ground that the issues were not justiciable, the court in the early part of this century refused to pass on a number of challenges to state governmental reforms, and thus made the clause in effect non-causable by the courts in any matter. This is our republican form of government. This is not a judicial argument. This is a political one. And if the legislature fails to act, this is internal insurrection.
Yes,
We go
but
to the
there's-
executive.
But there's no enforcement because no one
Yes,
cares.
there is. And I'm trying to tell you, I've had success. So stop saying that there is no enforcement because I've already done it. That's a fact, Jack. I followed the law as it is written.
How many people
And
have
it
you
worked.
prosecuted and put in jail? Or beaten with a stick? Because I want them beaten.
Well,
I want him taken in public and I want him physically beaten right in front of everyone. Because that's what
You
I'm
don't-
looking for.
yeah, I know, but you don't
I
get
don't
to
want
be
their
the
money.
judge, jury, and executioner all at
Well,
once.
no, that's why, hey, guess what? I can pass any law I want as long as the jury agrees with me.
No, that's not how we make law, dude. Sorry.
Well, that's how juries
you-
make law.
No, no,
Tar
no.
and feather 'em.
We're supposed to be abolishing something that's made by the legislature. So when we go and we say, okay, the statute created by here says this, but I have this right over here. So which one stands on a higher plane, jury? Oh, well, you're right for sure. And so we abolish the statute. That's how we exercise political power, and that is one of the benefits of a trial by jury. This is how we maintain our Republican form of government. When they exceed the servants, exceed their powers, we have the power to provide oversight through the jury.
Except 2 days ago, a guy tried to get a definition between a public road and a private road, and he got eviscerated by a judge who refused his right to trial by
That's
jury.
because you went to the judicial branch,
Well, the
not the legislature.
Oh, they went to the legislatures in 2020. They went to the legislators. A whole video about how he went there and he talked to them and everything. They're like, "We're really good when we'll put our heads together. We'll come up with something." Ignored.
Did he go to the executive?
Oh, you mean the county administrator? It's a county issue. So yeah. Oh, you mean the county administrator that's not
Following due
elected?
process of law that we just covered on application of the legislature, and technically speaking, at a state legislature, you would appeal to Congress.
There ain't nobody listening.
I'm telling you, there
I'm telling you,
is.
I don't
And
think
I've
you
already
understand.
done it. So I
There
know
ain't
for a
nobody
fact
listening.
there
Not
is.
listening. In the great state of Florida with Governor DeSantis and all the babbling crap, I'm telling you, there ain't nobody listening. Nobody.
Well, that's kind of funny because that's where Chris was at. And there was all sorts of things happening down there when Chris was pushing it through. Just
Well, I
saying.
haven't seen much except a lot of the same behavior.
Oh, well, maybe you ought to do something about that. Maybe you should follow due process of law and file some paperwork.
I have filed thousands of pages of paperwork. Nobody
In proper
cares.
form, to the proper place, following due
That's an
process of
arbitrary
law.
statement. That's an arbitrary statement.
No, that's a
Proper-
fact, dude. You have to
Proper
follow the law.
is relative to.
You're
what
not
they-
above the law. You don't get to make shit up.
Oh, they're
Yeah.
above the law and they make shit up. I watch them make shit up all the time.
Great. That's them. I'm talking about you, your conduct, your actions, not theirs.
Well, I agree.
So, I mean,
But I'm not
I
the
always
law.
throw this out there. People claim, oh, they're violating my rights. They're violating due process of law. Great. Why aren't you following due process of law? Because you're doing exactly the same thing that you're claiming and accusing them of. You're not following due process of law. You're violating their rights to due process of law.
What exactly is due process of law?
Law of the land. It's the process that
What
is
the
due.
process of
It
law?
is the process that is due.
No, that you just reverse the words and send them back.
But
What
that's
is
what
the
it means. It is the
definition?
process that is due.
I don't. That's not that. That doesn't explain the word. There's three parts to every word. There's the essence, there's the word, and there's the definition. The definition has to explain what the word is. So we're talking about a phrase. Due
Okay.
process of law.
Right.
What
So the
exactly
process is the steps.
okay.
right?
So we
The
have a process.
steps
Yes.
that are due from the law, not from the statutes, not from a code, not from a rule of procedure. From the law.
Well, that doesn't answer the question to
That
what
does
you're
answer the question.
determined. I mean, I'm trying to figure out if we have an understanding definition problem. That's because in my research, a due process means that you have the right to face your accuser. When someone accuses you, you get to cross-examine them.
That's one of the
You get to
steps
have
of
a
the process.
ruling. So then, but if wait a minute, if due process is you get to cross-examine your accuser, you get to get a ruling,
Mhm.
what does that have to do with the legislature?
Because they're the ones that provide oversight. But do you not comprehend that's how a Republican form of government works? You know, checks
Well, I
and
thought we
balances.
were supposed to provide oversight.
But we're supposed to be part of the legislature.
Thought
This is parliamentary practice from the rules of the common law. This is how it's done in our Republican form of
parliamentary
government.
practice is just a procedure.
Say again?
Parliamentary practice is just a procedure. It's Robert's Rules of Order. And any assembly
no,
you're
no, no,
supposed
no,
to
no,
follow
no.
Robert's
No, no, no,
or
no, no.
the rules of order.
That,
which is
Robert's rules of
parliamentary-
order is for group decision making.
Yeah, that's what parliamentary process.
We're talking parliamentary practice from common law. Lex parliamentary practice, Americana. The history of parliamentary practice.
Okay.
Common law practice. How we make things, how we create, how we provide oversight. The
Kirk,
steps.
Kirk, is there something you can offer to him to read so he knows what these steps are for due process, maybe more pinpointed?
It's right there in the Constitution. The Constitution is due process of law. Law of the land literally means due process of law.
Yeah,
That's
but
why it's called the common law of the land.
I think what he's asking, and Robert, you can correct me if I'm wrong, but you're trying to figure out the step by step by step by step process of due process of law and what she's referring to.
Well,
I just read it. It's right here,
Yes.
Article 4, Section 4.
okay, so let me
On
read it.
application of the legislature.
So,
Your
this
right
is-
dictates that you petition the legislature.
Okay.
What's a petition? It's a lawsuit. It's a
All right.
political lawsuit done
Okay.
through the legislature.
All right.
How do you do a lawsuit? You got to do your petition. You got to have an affidavit in support of that. You got to have your evidence in support of that. Right?
Okay.
Those are the steps of the process that is due to your fellow man.
All right.
Well,
So
Let-
right here is Thomas Jefferson. That that imprisonment under the protection of the laws in this Commonwealth, in his failure to obey the simple order of the president to depart out of the United States, as it is undertaken by said act entitled "An Act Concerning Aliens," is contrary to the Constitution. One amendment to which that has provided that no person shall be deprived of liberty without due process of law. And another having provided that in all criminal prosecutions, the accused shall enjoy the right to public trial by an impartial jury to be informed of the nature and cause.
Mhm.
It is not talking about legislature. It is talking about judicial due process of law through the court to be ruled on by a jury. There's nothing in this about a legislature mentioning due process of law. So when you say to me due process of law, you are talking about the right to be of the accused to bring forth their witnesses, to cross-examine them, and to have a jury rule. That
Right.
is
And
due
so when
process
these,
of law.
see, here's
So
what
I
you're
don't
missing.
understand the connection between legislature and a courtroom due
I'm going
process
to
of law.
make that connection for you right now that you're
Okay.
missing.
'Cause
Now,
that's what I'm missing. I
when-
don't understand.
when the police officer and when the sheriff, the jail, when the judge, magistrate, when the clerk, when they all don't follow due process of law, that is domestic violence. That is internal insurrection.
That-
You go to the legislature for that because they're the ones that created it.
Wait a minute. That's
They're
not-
the ones that provide oversight of that which they created.
Yes, they ignore things. So that's the point. I
I'm
was trying to
tired of
make
hearing
earlier.
you say they ignore things. I've
Well, I'm
already
tired
done
of
this.
them ignoring
We've
them,
already
but-
had success. So stop telling me that it doesn't work because it does.
Hey, have you tried filling out, doing your lawful notice and then get attached to the agreement and attaching that to A091 form and send that into the executive branch?
I haven't I haven't done any. I know people that have done it.
And that's
They
what,
haven't
that's
gotten
what
anywhere.
Kurt's talking
They're
about,
still
though.
walking around in the dark, trying to figure out what's going on. So that's the
here-
problem. I mean, I wouldn't. be
Here's
here.
the thing. When you file these A091s and they take them, right? You're not going to hear from them. If you do hear from them, it's going to be, we're not going to prosecute. It's backwards from what we think should be happening. That's even in the False Claims Act that we originally started out with for E-Clause. Okay. And it specifically says 30, 60, 90-day process in there. And that they're not going to contact you. And if it's under investigation, they can't talk to you. I know it's backwards from what people. Well, I was calling and I emailed and they just won't talk to me. It's under investigation then. So stop making the argument that nothing's happening because they're not answering your phone calls or emails.
I don't.
Something's
Your phone's-
happening if they're not talking to you.
Well, not only that too, we don't know where they filed it either. If they're not following the executive order and going through the task force, then it's gonna lay on deaf ears anyway.
And I agree with that because all I've seen is deaf ears.
But Robert, what kind of process do you do? Maybe that'll explain things a little bit better for Kirk to understand where you're coming from.
He
I
already
spent-
has. He goes to the judicial branch.
Yeah, but with what though?
Well, I've been petitioning. Well, eventually, I just got to the point where I actually got the rules of common law procedure in Florida. So I've been petitioning. Well, I've been filing with the court, but I've been trying to demand jury trials and trying to prosecute, and they're just standing in your way. They don't care. They literally don't care. And I don't see anybody getting any traction anywhere. I mean, I live in the same
Right,
town as General
because
Flynn.
you're not going to the
General
executive
Flynn
branch.
is running around trying to conjure people up. So he isn't getting any traction. Okay.
Who?
He lives in my hometown. All right.
Oh.
Now, so what, I mean, we're all sitting here saying that this is all happening, but we're not in charge of prosecuting anybody. We can't get anything done. We're sending all these letters, whatever, writs, whatever.
Yep.
That nothing's happening.
But you
nothing's
just
getting
said you
done.
went to the judicial branch. You're supposed to go to the executive branch.
So I'm supposed to go to the governor. Do you know how many people have gone to the
No,
governor?
the attorney general.
The attorney general is a cabinet member of, yes.
He's the
I've
general,
gone to the attorney
and I'm
general
talking
numerous times.
federal. We're
Ignored.
war, dude. Read executive order 13844 was the
let's go-
commander in chief, which I just read to
My
you
issue's not a
from
federal
Texas v.
issue.
White.
I can't even take care of a road in my hometown. How am I, why
Right,
would I
right.
even deal with those clowns up there? That's a bigger shitstorm than this one is.
Did you show him the executive order yet? You want me to pull it up?
Yeah.
All right.
I would just try it.
Have you tried it?
Like I told you, I can't even get, I mean, we just had an election.
It's either a yes or no answer to the question.
Well, it depends on
You
my
tried it.
target. I'm not trying to mess around with the federal government because I already know it's a failure. I'd like to fix my county. Let me fix something in my
But that-
county first.
That's what I'm talking about. We're at war, dude.
Well, I know that. I'm not
This
arguing
is
that.
this is corruption
Yes.
in your local area.
So when we say things like they're not listening, that's the only tactic they have. They're not
No,
listening.
because you haven't tried it.
Okay.
You haven't even done it.
I've gotten farther than most. Yes, I know there's all kinds of executive orders. They don't give a shit.
Because you're not going to the right place.
Robert, read
The
this. to
judicial
us.
branch doesn't care about the executive order. Because that's not their jurisdiction.
Yeah, Robert, read this out loud.
Executive Order 13844 established task force on market integrity and consumer fraud. by the authority invested in the President of the Constitution and laws of the United States of America, in order to strengthen the effort of the Department of Justice and the federal, state, and local and tribal agencies to investigate and prosecute crimes of fraud committed against the United States U.S. government or the American people. Oh, American people. That's cool. Recover the proceeds of such crimes and ensure just and effective punishment of those who perpetrate crimes of fraud. It is hereby ordered as follows. 1, establishment. The Attorney General shall establish within the Department of Justice a task force on market integrity and consumer fraud task force. Membership and operation, the task force shall include the following members: the Deputy Attorney General, who shall serve as chair, the Associate Attorney General, who shall serve as vice chair, the Assistant Attorney General Criminal Division, Assistant Attorney General Civil Division, Assistant Attorney General Tax Division, Assistant Attorney General Antitrust Division, and the Director of the Federal Bureau of Investigation. The United States attorneys, more attorneys, designated by the Attorney General and such other officers of or employees of the Department of Justice as the Attorney General may from time to time designate. Do I have to read all of this out loud? The Deputy
That
Attorney
was good.
General shall convene and direct the work of the task force in fulfilling the functions under the order. The Deputy Attorney General may permit, when appropriate, a designee of a member of a task force, including participants invited under Section 3 of this order, to precipitate in lieu of the member or precipitant. The Deputy Attorney General shall convene the task force at such times as the Deputy Attorney General deems appropriate. Additional participation of for specified function of the task force, performance of these functions set forth in subsection 4A and C of this order, and to the extent permitted by law, the Attorney General or the Deputy Attorney General, as his designee, shall periodically convene meetings and shall invite participation from the following senior officials for executive departments and agencies or their designees, as well as such other officials of the federal government as the Attorney General of the Deputy Attorney General deems appropriate. Secretary of Treasury, Defense, Health, Human Services, Housing, Development, Energy, Education, Veteran Affairs, Homeland. So basically all administrators, small business, Board of Governors, federal system, Social Security, Bureau of States, International Development, Consumer Financial Protection, Trade Commission, Exchange Commission, General Services, National Credit Union Administration, Futures and Trading, it's all commerce. Chairperson of the Board of Directors, the Federal Deposit Insurance Corporation. That's interesting. The Director of the Federal Housing Finance Agency, Comptroller and Currency, and the Chief Postal Inspector, Postal Inspection Service functions. Functions consistent with the authorities assigned the Attorney General by law and other applicable law, and task force shall provide governance for investigation and prosecution of these cases involved in fraud on the government and financial markets and consumers, including cyber fraud and other fraud targeting the elderly, service members, veterans, and other members of the public, procurement and grant fraud, securities and commodities fraud, as well as other corporate fraud, with particular attention to fraud affecting the general public. Digital currency fraud, money laundering, including recovery proceeds, healthcare fraud, tax fraud, financial crimes. Provide recommendations to the Attorney General fraud enforcement initiatives across the Department of Justice and any matters of the task force determined from time to time to be important in the investigation and prosecution of fraud.
Still there, Robert?
Huh?
You still there?
Yeah. I'm talking. I'm reading.
He's reading the executive order, Mark,
Yeah.
but he's
Oh,
reading it
Oh,
very low.
it went. Okay.
Action enhanced cooperation among the agencies, investigation, prosecution of fraud and financial crimes. Actions to enhance cooperation among federal, state, local, tribal authorities in connection with the detection, investigation, prosecution of fraud and other financial crimes. Changes in rules, regulation, or policy recommendations in the Congress regarding legislative measures to improve the effective investigation and prosecution of fraud and other financial crimes. General provision. Nothing in this order shall be construed to impair or otherwise affect the authority granted by law and the executive department or agency or the head thereof. Functions of the director, office management, and budget related to budgetary, administrative, legislative proposals. Task force shall replace the financial fraud enforcement task force created by executive order 519, November 17th, 2009, established a financial fraud task force. Financial fraud task force is hereby terminated pursuant to Section 8 of the executive order 519. And the order is hereby revoked. This order shall be implemented consistent with law subject to availability and appropriations. This order is not intended and does not create a benefit, substantial or procedural enforceable law or inequity by any party against the United States, its departments, its agencies, its entities, its officers, its employees or agents, or any other person. Termination. Task force shall terminate when directed by the president or the approval of the president by the attorney general. Donald J. Trump. Yeah. So
The reason why I had you read it out loud is because usually you remember what you read a lot easier when you read it out loud. So this is what the A091 has to be utilized under and through a criminal complaint. And what Kirk has been telling you is he's had remedy and relief already. He's had success. He's done it. And we're going to start utilizing it.
Are you in front of a computer,
me?
What?
Yeah.
Robert?
Yeah.
You are?
Yeah.
Go to uscourts.gov.
I'm gonna take off, guys. I'm burnt out.
All right, thanks, Kurt.
Looking at these screens. I've got two big, huge screens here just blaring in my face, and my
I'm
balls
getting
are burning.
tired too, but I am going to go to uscourts.gov.
Yeah. So.
Yeah, it's just real quick. I'm going to show you the form.
Yeah.
Yeah, so Tuesday at 8 p.m., we're gonna have another meeting and with Sheriff Dar and 3 of his posse members. Mark, did you call that woman that you were talking about earlier today
Which one?
from the Michigan Assembly?
Oh, Chrissy? No, not yet.
All right. Yeah, well, try to call her over the weekend, see if she can come on Tuesday. And,
All right.
I'll give her a
Send,
jingle.
send
Actually,
me,
I'm gonna talk to
send me
you
an
anyway.
email.
yeah, I will. I'll put it
Okay.
together.
Kirk, it was nice meeting you.
Nice meeting you too,
Have a
brother.
good night, Kurt.
Enjoyed the arguments. And by the way,
Absolutely.
arguments, not fighting. We are supposed to make our arguments. You have
Well,
to
this is debate. We're
That's right.
supposed to debate.
bingo.
This is good.
Right.
This is
And you're
good.
supposed to bring
Definitely
your
good.
facts of law, like I have. I show you the facts of law as it is written, not my opinion. These are facts of law, undisputable. Either you're of sound mind, possess logic and reason, and shall come to a reasonable conclusion based in reality that these are facts of law, or you are insane. That's your two choices.
Well, I'm trying not to be insane.
Me too. And actually, I looked that up, and it's funny. I can't even remember where I looked it up. It was in some dictionary, one of my Black's laws or something, and it's talking about insane. It's like we're all insane, and we only have but moments of lucidity.
I agree with that.
And as soon as I read that, I was thinking "Silent Lucidity" by Metallica.
Yep. I agree with
I'm
that
like-
too.
So we only have these brief moments of lucidity. The rest of the time, we're just fucking insane.
Yeah.
Yeah.
That
See
pretty
that.
much sums it up.
Speak
So
for yourself.
can I go into court and claim temporary insanity? Because I've only got moments of lucidity. So the rest of the time, I'm temporarily insane.
That depends on how high they can get the bond.
Right? Hit that one
That's
over the head, did you?
insanity.
As long as they get paid, they don't care.
Well, that's exactly
What's
what's going on.
the thing is that's all supposed to be a resolution, and case law really is the law of the case and actually only applies to the parties to the case. Just so you know,
Yeah, not arguing that one.
it's a
here.
resolution. It's a resolution of the parties, whether it went through trial or not. It's still just a resolution. That's how you resolve the issues, the matters before the court. And it only applies to the parties because if you're not a party to the case, how would that case law apply to you? Because the judicial branch doesn't have the power to make law. Therefore, it can only just be opinions backed by facts of the law, which these judges are supposed to write their opinions and do a finding of facts and conclusions of law. They're not supposed to interpret the Constitution. They're supposed to interpret whether or not the statute comes in conflict with the Constitution. Like it
Well,
says in,
that's totally true.
yeah, like it says in American jurisprudence, their section 2, the constitutional law, that the statute, they're looking to the Constitution for the subject. This is where subject matter jurisdiction comes from. If it's not delegated to the legislature to make legislation regarding that particular subject, that power doesn't exist, and there is a lack of subject matter jurisdiction. Then we get into personal jurisdiction. Did we delegate power to the legislature over mankind, the free inhabitants, or the people? No, we did not. There's a lack of personal jurisdiction. Hale versus Hinkle. They are only have personal jurisdiction over that which they create. And they sure enough fuck didn't create me. I don't care about that artificial construct, that corporate Ponzi scheme through the birth certificate. That's all fraud. And fraud vitiates everything from its inception. Now give me my fucking trust back that you stole from my family.
Mhm.
That's what's happening with Jisara and Nasara, by the way. So much love, everybody. Great meeting today. And
Nice meeting.
hey, I didn't lose my shit and fucking leave.
Wow. Good,
I
man.
actually rather enjoyed it, to be honest.
Yeah.
So
Did I?
look
He-
forward to, I did send just a brief, quick email for contact to the three of you, which two of you aren't even on here anymore. But definitely look forward to try and bring unity here. And we gotta figure this out. This is exactly what our founders did for years. Sat
Yeah.
around, except
Yeah.
for, how much easier is it with technology that we have today? I mean, where are you at, Bob? You're in Texas, right?
Oh, I'm in Florida.
Well, you're in Florida, right? I'm over here in Idaho.
I'm in
I'm about
Georgia.
freaking about 2,800
I'm
miles
in
from.
Michigan.
Ron's in
I'm in Michigan.
Massachusetts.
You know
and-
how long that would take by horseback to meet each other
Yeah,
Yeah.
right.
Yeah.
Yeah.
for a 4 or 5 hour session?
Yeah,
Yeah.
Thank God for technology.
yeah.
There's no reason why we shouldn't be able to outdo and outmaneuver the deep state with the abilities that we have here today. We have to bring our great minds together and work together, read the law and follow it. We got to figure this out, how to do this. And we have to follow our commander in chief because we're at war. And that's just the way it is.
Yeah, so Mark, I pulled up the A091 for him to see it.
Yeah.
So much love, everybody. Love y'all.
All right.
Have a good night.
Thank you
care.
so much, Kirk. Talk to you soon.
All right.
All right, Kurt, have a good one.
See you,
You're in
Mark.
front of a computer, Robert?
Yeah, I'm looking at it.
Or
I'm
you
gonna-
got
I'll
it?
put it in-
You're-
I'll put the link in
No, I
the
was going to
chat.
show you how to get to it, but if you go to uscourts.gov, and then right on there, you see court forms.
I'm putting it in the
And
chat.
when,
The link is
and
right
then
there.
when you, oh, you got
Thank
it
you.
too there?
Yeah.
Good. All right, enough
Forms.
said.
I got it.
Forms, then you go to complaint. Criminal complaints.
I thought, and I don't mean to interrupt, but Robert, I thought Luke told me that you had something going on in New York. You were trying to get a grand jury together in New York or some
No,
judge.
that was in Florida.
I don't know why he said New York. Oh.
Yeah, he might have misspoke.
So you have a judge almost ready to say okay to a grand jury?
No, I petitioned and I asked for an authorization at
Oh,
common law to present the evidence. And they did, listen, they did what they've been doing on everything. They just dismissed.
oh,
That's the game. What I found is that's in where, well, at least where we are, everything's getting dismissed. It doesn't matter what it is. You know, and then I don't know if you were here earlier when I talked about the guy that all he wanted was to get the road determined, to get a road or the roads in the county determined if they were public or private.
well, all the roads are owned by the postal service. Are you aware of that?
Yeah, well, technically, yes. Okay. But the county is in charge of the roads. The county has declared that his road that his street is on, that he doesn't pay taxes on, doesn't pay MSBU's, doesn't pay any form of public fund on, the county has determined it to be a public access right of way.
Oh,
So all
Just
he
like-
wanted was to have a jury rule whether it was public or it was a private road for the residents. And it literally got kicked out. And I'm like, if we can't get a road, we can't get determined a road is public or private, how exactly are we going to get anything done?
hmm.
Like
Who paid to put the road in?
the developer. So what they've done in where we are is that they made all the county back in its much less populated days, made all kinds of deals, backdoor deals with developers for future development, roads and stuff like that. And then the developers did what they wanted and then they left, and they basically left all the residents holding the bag. And now because the roles are so messed up, they don't want to fix them and they don't want to give a declaration. And we are pretty sure that they are there's more backdoor deals, that people are getting benefits that don't pay, and they're using public resources to like take care of their stuff. And that's why they really don't want to do it. But it's a mess. But the point is, this is a very simple thing.
Yeah,
Why is this that's so simple, so easy? Why is this so hard to get done?
because I don't think they have the authority to say unless the postal service approves it. And not to mention, all the developers that create roads are the ones gifting it back to the state. Ron, am I right?
All right, then you know what I would do is why don't you just declare that road for public use and put it in the form of an affidavit, have a bunch of people sign it, and
Petition
send
the
that to them and
legislature.
see if they rebut it. And if they don't rebut it, put an A091 to it and send it up.
Well, he went and had a hearing with them. I mean, he's done. And listen, this isn't my thing. I'm just
Oh.
using this as an example. I'm going after the school board in Sarasota
I got
County. You know, that was mine. I was just trying to help him. But I was like, this is like simple. Like, we should not have a problem. You should not have a problem getting this done.
Okay, so let's stop for a second. You're going after the school board for what?
You know, the sexually explicit books,
The
in the
CRT and the
schools,
sex ed and
all
the
that. Yes. Yes.
transgender? Okay,
Yep.
so
Only I went
how
after-
are you, what steps have you taken so far?
So I filed a petition at common law, and at action at law, and then I basically went through, you know, whatever I filed the petition, they came back. At first it was, and it got actually a lot of traction in the beginning. And then I finally gotten to a courtroom, and it was back and forth, back and forth. They were basically, saying, oh, it's going to get dismissed. It'll never see the inside of a courtroom, blah, 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 blah. Well, I had filed it at law. The judge, so finally, when we get through this thing, and I kept calling them out on stuff they were doing, like, according to the rules of common law, they're supposed to have a separate docket. According to the rules of common law, they're not allowed to dismiss it. The judge isn't allowed to make any rulings. I demanded a jury like 6 times, repeatedly demanded trial by jury. And it was all ignored. We went into the hearing on August 3rd. And in the hearing, the judge basically, I argued jurisdiction. They hadn't made proper appearance. I argued proper appearance. I was overruled on everything. Now, mind you, the judge, I demanded a jury trial or trial by jury. The judge was not allowed to make any decisions. Refused to give me my jury and refused and basically dismissed the case.
All
Well,
right.
luckily in her dismissal, she cited, I don't know if she did it on purpose. I don't think she did. She cited a case from 1937 that literally laid out like how common law is supposed to work in a courtroom from 1937.
Hmm.
So in it, it said that the 7th Amendment is only whatever at federal courts. Well, but if it was an example, it was making this comment and it was actually rebutting the comment if you went a little bit further down, and it gives this entire paragraph where it lays out that trial by jury is inviolate. They cannot deny you of it.
Mhm.
And there was a bunch of other things in this case. So I just filed a motion for reconsideration. And in the motion for reconsideration, I pointed out the case she filed and literally proves that everything that I was arguing, and this is from 1937. So this is like in the 1800s. And this was her case. She brought this case in to use as an example.
Hmm.
So I filed a motion for reconsideration. I literally used her entire case that she used to dismiss me. And in it, she openly admitted that in 1967, the Supreme Court abolished the separation between common law and equity. And it was a ruling in 1967. Well, I went up to Tallahassee in March or April. I spent a week in Tallahassee. I have cases from like 1940s and 1950s that are at common law in courts,
Mhm.
prosecuting. Like one of the cases that I scanned has it's a sheriff and like 8 of his deputies that they lied. They accused the guy, they violated all his rights, whatever. The guy came back and prosecuted them at common law.
Hmm.
And this is in the 40s. So I believe that this is not I believe the county courts are where our common law system is. And we have to bring it in as an action at law. And we have to get the common law rules. I actually have a set of the Florida common law rules of procedure.
Mhm.
I got them from the Supreme Court Library in Tallahassee. They've been sitting on a shelf in the Supreme Court Library, along with a clerk of court manual at common law to give our clerks of court directions. I don't know anyone that's tried to try a case at common law and actually had the rules of common law procedure.
Hmm.
But even though I had them, they still ignored them.
Hmm.
So in the case, in the actual case that the judge cited,
Mhm.
it actually says that it was in county court. It was actually county court is where the case originated.
Hmm.
It sounded like they were in violation the whole time. I mean, your rights were trampled all over. So
Yes.
I would just put that in the form of affidavit, and then get all that, your case files, and attach it to that A091 form, and I would send that in. Because that's a violation against market integrity or consumer fraud. You've been frauded.
Well, the problem is I claim no money.
You
When I
don't
brought
have
this,
to.
well, yeah, when I brought this case for it, there's no money involved. They were trying to move the court into equity. They were trying to actually get a bond on the case. And I kept objecting to it and fighting them on it. I'm like, there's no money here. And they're like, well, this is they literally wrote it in their answer. This is some kind of tort. I'm like, literally, that's what they said. I'm like, you guys have to have it in equity because that's where, well, number one, I think it's the only court that they know is equity court. They don't know anything else. And two, I think that I'm to the point now where I'm pretty much convinced it is literally the county courts in our
For all
counties.
common law.
They are, because they're the only courts here. I sent this out. Yeah, I saw it earlier. So this is what the attorney responded with. Okay. In response to the judge, not everything and not everybody under every circumstance has the ability to obtain court-based relief. And under it is certainly requires more than wickedness, slavery, and evil. This was the school board's attorney.
What the hell does that mean?
He's admitting. We know it. We know it because I literally said I called him out. And this, if you go into the Google Drive that I just put up,
Yeah.
it's the whole docket. It's the emails back and forth. It's the stuff they were saying, what they were doing. I mean, it's everything. It's like 35 documents, including the entire transcript of the hearing.
So what did you base your claim on?
I claimed a petition of right under the preamble and under the state constitution. So in the Florida state constitution, let's see here. Hold on, is this it? Yeah. It says, hold on, let me look. So yeah, exactly how it's written. It says the right to bring action at law. The petitioner filed an action at law as an exercise of individual right embodied in the preamble of the Constitution for the United States and the Bill of Rights. The petitioner repeatedly cited action at law is bound by the 7th Amendment that only a jury can determine a fact and only at the rules of common law. The Constitution for the state of Florida, Section 8, Ethics in Government. The public office is a public trust. The people shall have the right to secure and sustain that trust against abuse.
Yeah.
So that gives me the right. It didn't matter. They ignored. There were 50 people in the courtroom. The entire courtroom was full.
You got a pretty good case for that criminal complaint. I'm telling you.
Yeah.
Yeah, I'll look into it. I will. I'll look into it. So, I mean, this literally and then, like I said, I used her case. If you go down through this thing, if you start looking at it, I don't think I can throw it up here. Can I? Do I have the ability to, or is it only administrative?
Oh, I could give you, yeah, hang on. I don't think, Mark, you're on the phone though. You can't really see, can you?
Yeah, I'm on the phone.
Oh, okay. Don't worry about that. So when I cited her case, right? So this is what it says. This is what she cited. It says the court stated in the dismissal at the hearing, the petition, and this is quoted, at the hearing, the petitioner argued that it is his Seventh Amendment right to have trial by jury. This is what she quoted. The Seventh Amendment to the US Constitution guarantees the right to trial by jury in suits at common law. The Florida Supreme Court held that the Seventh Amendment is only binding on federal courts. Dudley Harrison McCready, 173-820, 1937. So that was her quote, right? Only the next line says, and this is what I wrote in my reconsideration. However, in the court's citing of Dudley Harrison McCready, 1937, after Dudley, for which the petitioner acknowledges and supports the numerous elements of the petitioner's action at law under Florida common law rules, which makes it makes an indisputable standing for reconsideration. The Dudley suit at common law was the result of appeal ultimately deriving from the Supreme Court of Florida regarding the actions of a circuit court of appeal, which supersede the limitations of its mandate under the law, common law rules where a trial by jury shall be inviolate to precisely determine facts and render verdict. The Circuit Court of Appeal retains this appellate role in 2022 as referenced in Florida Statute 26 for cases appealed out of county court. The Circuit Court assumes an initial appellate role. The Circuit Court that was in the appellate role appears to have assumed the role of superior court over the jury's verdict and facts and gave final judgment for defendant that was ultimately determined the circuit court had no authority to supersede the jury or facts rendered, but was only to determine if the jury verdict was based on law, rule, and full disclosure of evidence. If the circuit court determined that there was not the case, a new trial, a new trial to determine verdict and fact should have been initiated. The original appeal from the county court to a circuit court of appeal was ultimately remanded back to the original court for a new trial, action at law under common law rules to be determined and deliberated by jury verdict to declare the facts. And then the case goes into the court that assures an arrest of judgment, but grants its motion for judgment non abstante vertigo. So this case that she gave me elaborates and details about juries are the only ones that can determine a fact, and judges are not allowed to determine facts. They're only allowed to give opinions. And that's the separation between law and equity. Right now, there's a presumptive premise at equity. That they can give an opinion or an advisory opinion. Only at common law, in front of a jury, can you get a fact determined. So because from what I understand, or from what I've learned, if you get a declaratory judgment of fact, because it was rendered by a jury, by the Seventh Amendment, it becomes the general law for that county. This case elaborates in detail, and it just so happens it is a county court case that was an appeal that then went to a circuit court, which is basically where all our equity cases are. But even in our state statutes, it says the circuit court will assume an appellate role for any cases of appeal coming out of county court. That's still on our books. And then the case cited like 40 other cases. So I got to this theory that it was county court before I ever knew about this case. The judge cited this case. But this case confirms, or at least gives validity to, it's the county courts. Because counties are surveyed. It would be territory. I mean, it makes sense.
Yeah, and you have your county sheriffs too.
Yeah. You have your county supervisor of elections, your county commissioners, your county sheriffs. If it's territorial, it has to be by metes and bounds, which means it has to be on the land, which means it has to be the counties, the lowest court. I mean, think about what better way to hide the court that can determine a fact than to make it small claims court, right?
Mhm.
Small claims court and traffic court. But if common law went away, they would have had to delegate duties down to it, or the court just would have sat there empty. They had to give them something to do.
Well, all the power is in the county.
Yeah. I mean, it makes sense.
Mm.
That's true.
So, Robert,
And-
are you on Telegram?
Yeah.
What, type, can you
Me-
type in your thing here?
Yeah. Give me one second. I gotta look and see what it is.
Okay.
Oh, it's called
If you,
Action
put
and
his
Law.
if you put his contact in your phone, it'll automatically show up in Telegram.
Oh, really?
Yeah, really.
Okay,
You hit the
so,
3 lines by your picture or by your name, and its contacts show up. Just click on there, and you'll see him pop up there. You just put him as a contact in your phone.
well, how come you didn't know who was texting you then?
Because I wasn't looking in Telegram.
Uh-huh. Anyway, I want to go over this real quick with you, Robert. This is what we created. We created We the People US. Our first course of action was going after the fraud of COVID.
Oh, yeah.
So if you come over here, you'll see we have COVID resources, which gives all information, right, of the fraud. Now,
Oh, yeah. It was horrible.
yeah, okay, so hang on, I'm not done. I just want to tell you real fast. And up here, it says stop the genocide. My computer's slow tonight for some reason. Wow.
Everybody's playing video games. Should be reading a book.
Yeah, right. What the heck is going on? Wow. Well, anyway, that's not what I want to get to here. Operation Bedrock. We have step-by-step process here. All right, so if I can get that other page loaded, I want to show you. Here we go. Okay, so we created this as a non-branded site, right? Anybody can come on here and utilize any of the documentation. So you see this, the left side flyer here?
Yeah.
Okay, so the right side flyer can actually be customized if you have a site and you want to use your site instead of We the People too. You can actually create it so it has your link and you have a QR code. We have stickers. We have a little quick flyer, meme thing.
You know, I was a paramedic when COVID hit.
Yeah, so
That was
kinda
one
neat.
of the things that boy, they were pissed at me. They had no policies and procedures, nothing. They didn't know what to do.
Okay, so maybe I should have asked you to begin with. Do you believe in COVID?
Well, as somebody who got sick, I would
I
tell
think-
you I believe in it. Do I believe whatever they came up with? I don't believe anything they say.
Okay, so
Just
COVID is a fraud.
whatever bug or whatever it was.
Yes, it was something, but it was not COVID because it's never been isolated or identified,
Right.
captured or procured by any scientist.
I would agree to that.
in any living or deceased person. So we made this very simple for any kind of groups or people or anything that want to get involved. We have this HTML where once you put this into your site, it will come up exactly the way you see it here with all the videos and everything that you can incorporate into your own site. But here's the problem. Here's the whole situation that we're faced with. Is I created state groups for all the states under We the People 2.us. So right now, we're still in an awareness stage because we got to make the people aware of the fraud that they've been bestowed upon by our lovely deep state government. All right. So that's one action that we're taking. The second action here is called the MAR project, MAR, Municipal Accounting Review. It's headed up by a forensic CPA, and we have 20-something states so far involved. For any district, now you said the schools, this is why I'm introducing all this to you. What it is it's FOIAing all the bank accounts for each district for the last 3 years. So you want to know where all the pennies and dollars came from, going in and going out. And we're not letting them actually know what we're up to. Oh yeah, see, this is the map of the states that are participating right now.
Yeah.
And you could do it anywhere. I mean, if you live in California, you can even do it over here, you know? Like the whole point is it's our money. The school districts and the school boards accepted money 3 different times with the ESSER funds, but prior to that, they accepted the CARES Act funds, okay? So where's all the money? So there's a town in my county that got over $164 million, one town. Where
Where's
the
all
hell's
the
the money?
money?
Yeah.
Yeah.
So on Telegram, we have a group for this, for the MAR. They meet on Thursdays. Now, did you send me your personal Telegram or you sent me a page?
Oh, I don't know the difference. I'm not very good at this stuff, that stuff.
Oh,
What's, hold on. I don't know.
all right. Well, you don't have, let me see.
Oh, wait a minute. No, you're right. Good call. No, that was my page. Hold on.
Okay.
Sorry. I didn't even know there was a difference.
Yeah. So if you want to get involved on this level as well, it's very easy. We don't charge anything. It's for free. And it will help hold these school boards in your area, district, or wherever accountable. So they have a whole action step plan for this.
I think that's it.
Okay, so then we started with pulling up, and I know everybody said that they don't like Tori says, but she had a call action to send this letter out to all your local county and state officials about destroying the election voter ballots and all that other stuff,
Mhm.
because Sunday is actually the deadline for that. So we incorporated this into the site as well. And then we also have a National Day of Prayer coming on September 11th, just to get the people involved, just to get them organized, trying to do it as a group. We told them to go at your local town or city hall, but they can go anywhere. There's actually pastors who are customizing this. So they're doing prayer wherever that church group decides, or so on and so forth. And you can even customize it for your own group or what have you. But this is just the beginning of what we're starting on. What
Yeah.
you're not aware of, and I know that Luke brought up the sheriffs, and we never got to the point that I wanted Kirk to make. We are also going to lawfully notice every single sheriff across the country. Because they're not doing a fucking thing. Excuse my French.
Well, no, they're in bed with them. The majority, at
And-
least the majority of them are.
Mhm. The majority are. And we don't know if it's by design or if it's just by complete and utter ignorance because they don't know any better. All right. So the lawful notice that we are creating, which is almost done. Let me see if I can find it on here. Is headed up by Kirk. And we're incorporating the fraud of the COVID with the vaccines and all that other stuff. I hope you never got vaccinated.
No, no way.
Okay,
I don't do dumb. So
okay, all right.
I'm not following dumb anymore.
Okay, so that flyer that I showed you in the beginning,
Yeah.
that was created with Dr. Judy Mikovich. So I don't know if you're aware who she is.
No.
Dr. Judy Mikovich is a top microbiologist in the country, and she was Fauci's partner, and she whistleblowed on Fauci. And her husband was murdered over it.
Yeah.
And, you know, we have a lot of contacts in a lot of high places. And we went over, I wish Ron was on because he could tell you. They asked her 10 different questions and they truncated it down to 5. So those questions and responses are based off of her information, her knowledge, and her know-how, right?
Yeah.
So this isn't like fly-by-night stuff that we're dealing with. And I really want to get you involved because it sounds to me like you have maybe your own following or you have maybe your own group. I mean, you tell me, I don't really know.
Yeah, I have a small group. I'm attached. I mean, I'm associated with. I'm kind of like Luke. I'm associated with a various amount of people,
Yeah.
and then I have a small group. Like right now, I'm teaching a class up in Sarasota. For the next couple weeks. That is a basically I call it cognitive warfare class, where it basically teaches you how to engage them, and instead of having to argue with them or fight with them, it teaches you how to engage them to get them to tell you what they're doing and how they're doing it. And it really it's philosophical. Most of the stuff, I mean, you're asking me about people. I don't really watch TV. Most of the time I spend reading books. So it's, most of my books are, old philosophy, Plato, Aristotle, stuff like that. So I don't turn on the TV pretty much ever. And I'm, and Luke and I, we do podcasts and stuff like that. I sent you actually sent you a link to my YouTube. There's like a YouTube file. It's got a bunch of videos in it, but there's some stuff in there with me and Luke where we have conversations about law, common law, stuff like that. So I would say I have associated with a small group, but we're trying to get more connections to try and come to, a way to actually manage this. And the one thing I've come across is, I'm kind of on my own road because, I've come to this thought or this idea that I'm trying to explore the depths of it. And I know like you guys are doing the federal thing, and there are people that I'm associated with, like Tracking the Money group that I'm associated with. They literally have an office with legitimately the entire office is the people that are involved with strings running to all the money. And it's the depth of corporations and shell companies and law firms. And I mean, it's incredible. It's just too much. There's just so much,
It is.
you
So
know?
we gotta start small. We gotta start somewhere. So with that sheriff, I just posted the link to the Florida group here, so
Yeah, I just
you can
grabbed it.
click on it, it'll bring you right to it. The only thing is I have 2 bots in there, so you might have to click 2 buttons in order to allowed to be entered in.
Yep.
So anyway, with the lawful notice to the sheriff, after we serve the sheriff this lawful notice, we're gonna serve cease and desist to all the pharmacists, because you gotta start somewhere, right?
Yeah, I mean, that's the kicker. Like we're all just testing these systems, trying to figure out.
Well, we're not
No.
testing anything, we're gonna do it. And we're going to utilize that A091. If the sheriffs don't stand up, and if the sheriffs don't file their own criminal complaints, and if the pharmacists don't cease and desist, then we're gonna file the A091s against the sheriffs and the pharmacists. And then we're gonna move on to the doctors, then we're gonna move on to the hospitals. Then I'm also in the process for New Jersey, I'm also in the process of using one of Kirk's lawful notices that he used in Idaho to shut down the school from enforcing the masks and all that other stuff. So we're gonna also notice the school boards and also utilize the A091 form too, if they don't cease and desist all the propaganda, all the coercion, all the manipulation, all the signage, all the, stand 6 feet apart, whatever, all of it.
Yeah,
So we're also gonna notice the schools. And we're just gonna keep moving along. Just keep going,
yeah. I mean, I think that's the plan, is we're just gonna keep pushing until,
Yeah,
the
so
pillars
I would
crack
love
and-
for you to get involved here
yeah,
with this. And have your people join too. Now, the MORE group is here. What the heck is, let me see. I'll put that in the chat too. That's the MORE group. We also have a research group, which is also under, right here is our research group. That's under the Constitution Law Group. You want to join this? Excuse-
you all right?
Yeah, I'm laying sideways, so I tend to cough a little bit more. I have a smoker's cough. So here's the Constitution Law Group. We're gonna go live tomorrow night at 8 o'clock. So if you want to hop on, we have a bunch of different variety of people in here. We have one guy, this guy right here, Yoda. All
Yeah.
he does is equity. That's the only thing he practices, the only thing he teaches, the only thing he utilizes is equity law. We have another guy called King Fish. He's all about trust law. We have a couple other people that are all about the title, statutes, and codes, the way that the law is written, and they don't really believe in a lot of the patriot mythology stuff that they actually call it. We have learners, we have sufferers, we have victims, we have all kind, it's not a large group, there's like 1,300 something people in here, but they're all pretty good. This guy, Doug, he's pretty knowledgeable. He studied Anna von Reitz stuff. He studied David Straight stuff. There's a mixture of a lot of different people in here. So feel free to go in
Okay.
and feel free to go on the live tomorrow night. Mark, are you going to be available tomorrow night?
Is he still there?
He's still on.
Yeah, I'm still here. I had it on mute. I was just listening. Yeah.
Oh.
What time tomorrow?
Tomorrow night, 8 o'clock, we're gonna go live here. It's just gonna be like an open
Oh, you
discussion.
mean on the CLG site?
Yeah,
Yeah, I'll type in there.
yeah. So, I don't know who's gonna come on. I don't know what the topics are gonna be about. I kind of just like to touch base once a week with everybody. And it usually lasts, one night it lasts for like 8.5 hours. But, you don't have to stay on. I'm just saying, like you want to hop on, you want to contribute, you want to have a discussion, feel free,
Well, I think it's good. I think sharing information and really trying to figure this out. Like I said, if anybody had all the answers, we would already have this fixed.
Yeah, I know.
So that's where we're at.
Yeah. So I actually, for the state groups, I'm gonna start kicking out, like Florida, New Jersey, and Washington State are gonna be one of the first 3 states to notice the sheriffs. New Jersey and Washington have county groups already set up. See, I was part of Bonds for the Wind, but I switched it all to We the People too. So these are all the Jersey counties. But I have to get admins in Florida, so because you got so many different counties down there.
Oh yeah,
One-
67 counties.
67, yeah.
Yeah.
Like I know for me, I manage all these groups myself. And
Wow.
I have one guy helping me, but he's not up to speed like for me. So every day I go in like twice a day, like here down in Texas, they have, obviously this is a porn thing. So I have bots in here. This one should have been removed and it wasn't. So I gotta physically go in and remove them.
Oh my god.
But I have folders. See how I have them created on the side here?
Yeah.
I have folders, so if I want to go to my New Jersey county groups, I just click here. If I want to go to all the We the People 2 groups, I just click here. If I want to go to the CLG group, I have this pinned, so I just click here. We have a news channel, so people can post anything they want on here, as long as it's not porn or crypto or Bitcoin or none of that. I don't really suppress anybody in here at all. Only if I, like it says, no porn, no crypto,
yeah.
soliciting. And there's a lot of, and this isn't a large group either. And I kind of like it like that, but there's constant, like this, We the
Content.
People, this person here, they post every day. They post, so they're all getting involved. And, I think it's a good thing. But then, these are all my other groups too. So, yeah, I have a lot. See, yeah, I have a lot.
Wow.
Yeah. So this is the guy with the trust law. And I don't know if you're aware of like the W-4 sandwich process.
Yeah, my buddy just that's the ones you get from Treasury, right?
This is the one that you notice the IRS. Yeah. And
Yeah,
then it'll
he-
go to the Treasury. And then
He just got his from
What do you-
IRS or Treasury or something.
what do you mean? What do you get?
He got his, I thought it was his W-4s. Like he got them delivered from Treasury, and he told me he just got a funding authorization or something.
Are you talking a 1099-A maybe?
Yeah, he got he got his 1099-As, and he just told me he just got a funding authorization, and he's already had his trustees assigned.
Oh, really? Well, I
Yeah.
would like to talk to him.
Yeah, so he's waiting to figure it out. He's super smart, smarter than me.
Well, that gentleman I told you about that's all into trust,
Yeah,
he accesses his Sesta all the time. So like, if you want to invite him in for tomorrow night's call, I know he'll be on it.
Okay.
Kingfish and Yoda guy, he's the one that does equity law. He has 100% success rate at discharging all debt. I've been following him for over a year. So I know what he does because on Facebook, he goes by, see, it says Hamilton Elbay. That's what he goes by on Facebook. And I don't know if I have Facebook open. Hold on. Do I have? Yeah, I do. He actually, and it's not loading. He actually posts what successes he has all the time. So like I see what he's done, you know, because a lot of these people are like, oh, what do you call it? Like Chris Hauser. I don't know if you know who he is.
I've heard the name.
Yeah, he does like this coupon for value, you know, the coupon method.
I've heard of that.
Yeah,
My
a
buddy
lot of-
does like he's more trust where I'm more like common law. Like actually I'm legitimately trying to figure out a way to get myself appointed as prosecutor so I can actually put them in jail myself.
Wow.
Like that's my mission.
Well, why do you have to be a prosecutor? Why can't you be a sheriff?
Well, sheriff has to get elected. I'd rather put the sheriff in jail, find a new one, and then send a message.
Oh, so what's the qualifications for a prosecutor?
Well, my plan that I had when I went into my hearing, had I got my jury, was because I asked for an authorization to present in front of the grand jury, was I already filled out a motion to the jury telling them basically we do not trust any public officers or agents, and we do not trust any bar members. So I'm requesting the jury authorize me to be appointed special prosecutor for the case, and I will oversee the prosecution with all the powers of the attorney general and the state's attorney. And apparently, if a jury only rules in facts and they approve that and they issue that order, I become special prosecutor with all the powers.
Okay, so you really need to get involved with David Roberts about assembling so that you can actually be the de jure prosecutor.
Yeah.
Because once you're assembled and have the assembly and the state settled, you can actually be appointed. What they call also is a private attorney general. You can even be that, you know, where you oversee it all. I mean, it's so amazing to me. I mean, I started into all this when they said stay home for 2 weeks and wear a mask.
Well,
So,
I
like-
think that's what happens is they get everybody to stay home, and all of a sudden everybody has 5 minutes to look around and go, what's going on around here? 'Cause
Well, that's
something's
what I
wrong.
say that all the time, you know, you can't leave me home for 2 weeks and not be able to do nothing.
Right.
You know? And put me under house arrest and tell me I can't travel or I can't go anywhere without putting a friggin' face mask on? Yeah, that ain't gonna happen.
We did that here in this town for, I think it was 2 weeks. After 2 weeks, everybody went to the beach. Everybody started going on the boat. Nobody cared. They tried shutting the beaches. Everybody went on the boats, on the sandbars. Like nobody cared.
Yeah, no.
It was
Well,
2 weeks.
That's fine. What town are you actually in?
Inglewood. It's like Southwest Florida.
Southwest Florida.
It's
So-
between Sarasota and Charlotte County. My town's actually split between 2 counties.
Oh, so you're north of Port Charlotte then?
I basically live 5 minutes from Port Charlotte.
Oh, okay.
So listen, I hate to cut it short.
Yeah.
We have been on for a long time, and I do want to hang out with my girlfriend
Oh, sorry. Yeah.
and get to, no, don't apologize. I appreciate it. And I enjoyed the debate with Rich. Listen, I believe in healthy debate, and I believe by having those debates, they create thoughts, and hopefully you can find more stuff.
So you're gonna join us Tuesday night then?
Yeah, I'll join you Tuesday night.
Because there's gonna be a bunch of other people on.
Yeah,
Well,
absolutely.
All right. Well, you have a great night.
You too.
Nice meeting you, Robert.
Nice meeting you too,
Mark,
sir.
Yeah, Mark, have a
Yep.
good night.
All
And,
right, guys,
uh,
you
We'll
too.
talk to you soon.
well, if you
Fruitful.
go on tomorrow night on the CLG Live, I'll talk to you then.
All right. Sounds good.
All right,
All
bye.
right, have a good night,
See you,
Bye,
Michelle.
guys.
guys. Good night.
All right, bye.